May I approach, Your Honor?
You may.
Is Defendant's Exhibit 36 the study that you just referred to, Dr. Murray?
Yes.
And what is the title of this study?
Lost Votes: Effects of Methods of Voting on Voter Participation in Iowa, 1920 through 1984.
And since we are a bit pressed for time, I'm not going to ask you to walk through page by page in the study, but when you prepared yourself to testify here, were there any sort of general conclusions that you drew when you reviewed this academic piece?
This academic piece has 110 pages, but one of the general conclusions was that it documents that the method of voting affects voter participation or influences voter participation both at the level of how many voters go to the polls and among those voters who go to the polls, the extent to which they vote all the offices and initiatives on the ballot.
I'm going to hand you another study. I don't know if we've assigned a number to it yet, but we will be. This will be Exhibit 59.
What was the prior?
I'm sorry?
What was the prior report?
The prior one, Your Honor, was Defendant's Exhibit 36.
All right.
And this is Defendant's Exhibit 59. And we'll put a mark on that and provide one to the clerk later, Your Honor. What is Defendant's Exhibit 59?
It is a journal article from the spring of 1998 by an author named Nichols, and it is entitled State Referendum Voting, Ballot Roll-Off, and the Effect of New Electoral Technology.
And again, without going through page by page, what was helpful to you in reviewing this study?
A statistical documentation of the effect of electoral technology, in other words, voting method, on the participation of voters in an election, including voter choices to vote all or not all of the offices on the ballot.
Now, you've reviewed these two statistical, or the one statistical study and the other one, the Iowa study. And if someone was going to do an actual analysis of what accounts for the difference in the undervotes, would you want to look at issues such as, with optical scanners, you're filling out a ballot that has the names next to the holes, and you fill it out with a number 2 pencil, that kind of thing?
Right. That would be how the kinds of issues you asked about earlier, the framing issues, would show up in this context. There are different levels of user-friendliness of different methods of voting. Some of them involve procedures that are quite foreign and strange to the kind of things we do in everyday life.
For example, in everyday life, we don't use little styluses with plastic handles that have little chains attached to the table that we're writing on, correct?
I do not in my everyday life.
But lots of us use pencils, and that's a more familiar, user-friendly.
That is a familiar thing to do.
And when we, in our everyday life, when we're writing something, we generally have the entire page in front of us, and we can see what we've done, right?
Exactly. So you get some visual feedback from the page in front of you, and you see all of what you've done at once in one frame, as it were.
And like the cognitive psychologists, do they tell us that if there's something left blank on that page and you filled in the rest of the dots, it kind of pulls you in and says to you psychologically, you know, let's fill in all the blanks here.
It would not surprise me if they said that, but I'm not a cognitive psychologist.
And you have looked at the punch card machines and the ballots. Do you get the same kind of visual feedback that you get when you have a optical scanning ballot that you fill out.
You do not.
And in fact, if somebody was undecided about who they wanted to vote for president, one of those people who make up their minds at the last minute, and they decided to vote in the rest of the races first while they kind of let this make their last final decision. If you did that with the optical scanning ballot, if you glance down at it, would you get a reminder that you still have to come back and vote for president?
Objection, Your Honor. He's already said he's not an expert in this area.
Well, I'm talking about the ballots that he's examined here, Your Honor.
He still has no expertise in cognitive psychology.
Sustain the objection.
Well, we'll just leave that and the lawyers can talk about it later. So we talked about the question of user-friendliness. You know, you're not an expert in cognitive psychology, but as a statistician, before you drew any conclusions about why there may be more undervotes with one kind of a voting method versus another, would you want to make sure that someone who did know what they were talking about in cognitive psychology looked at those two methods to see if one was just more user-friendly than the other and could explain the fact that people just don't vote for all the offices in one more than they don't vote for all the offices in the other? Would you want to look at that?
Absolutely. And it could even be studied by a properly designed experiment.
Oh, it could be studied by a properly designed statistical experiment?
Yes.
If you were designing such a statistical experiment, would you want to investigate whether one explanation for undervotes for president in the punch card ballot could be that it's possible for people to walk in and open that ballot and just flip open by accident to page 2 and start voting at the senators and never even open the page for one?
It's a factor that you would want to consider in the design of such an experiment.
And would you want to design into the experiment the difference between a ballot like that, where you might not ever even notice that you didn't vote for president, and one where it's staring you in the face because it's a punch card and you can see that you didn't fill in it? I'm sorry, it's a thing that you fill in with the pencils, so it's staring you in the face and you can see that you didn't fill in one of those ovals with the number 2 pencil.
It is certainly one of the differences between the situations for which you would want to control if you were going to attempt to draw a valid inference.
Now, let's move from the user-friendliness to the possibility that I keep saying the Gore legal team has raised, but I'll just state it as a hypothetical to you, that we have this difference between the undervotes in votomatics and optical scanning, and I want you to assume that someone is claiming that the explanation for that difference is that there's something wrong with the votomatic machines, especially the left-hand column, where the rubber's gotten hard or the plastic's gotten scratched or there's chads that have built up in little mountains underneath there, and people are trying their level best to vote for Al Gore, but they just can't push the stylus all the way through, and instead they're leaving these little dimples. Now, if that were a hypothesis for the difference in the undervotes, as a statistician, would you want to subject that hypothesis to scientific testing to see whether there's anything to that?
Yes.
Before you drew any conclusions based on a hypothesis like that, would you want to hear from the people who are proposing that explanation from somebody who understands rubber and can tell you whether rubber gets harder the more times it's impacted with a stylus?
I would want to do that.
Would you want to hear from somebody who actually works with the machines and designs the machines rather than a political scientist about whether little mounds of chad can build up and stop somebody from puncturing the ballot and voting?
I would want to learn that because it serves no useful purpose to try to learn from statistics alone about a situation where there is a lot of subject matter specific information that can be brought to bear on the question that is being examined.
And as a statistician, would you want to look, and we referred to this earlier in your examination, and I asked you to defer your discussion of it, but would you want to look to see whether there was a pattern from prior elections where people in the left-hand column voted fewer times than people in the right-hand column and than they did in the right-hand column and in the middle of the ballot.
Yes, particularly if I had encountered anecdotal evidence that something like that could be discerned.
And of course, you've read the affidavit and the proffer of proof concerning Professor Hengartner, have you not?
I have.
And you read the paragraphs in both those documents concerning the 1998 election in Florida, right?
I did.
And were you here yesterday while he testified about that?
Yes.
And without going through all the details, do you generally recall that in his sworn affidavit and in the proffer of proof that was submitted by the Gore legal team, they claimed that the ballot in 1998 had the senators on the far left column and then had the governor's race in the second column?
Yes.
And we saw yesterday that was wrong, that both those were in the left-hand column. Remember that?
Yes.
Now, did you take a look at the number of votes that were cast for the different races that were in the left-hand column on that 1998 ballot, and the number of votes that were cast in the races that were in the number 2 column to the right in the 1998 election? And that is our Exhibit 60. which I'll put up on the screen. Now, and I'll represent to the court, we can put the sample ballot up if somebody wants, but I'll represent to the court that the sample ballot actually had in column 1 the race for senator, and then the race for governor, the race for secretary of state, and the race for attorney general. Have you checked the sample ballot? Do you know that to be the case?
Yes, I have scrutinized it closely.
So you actually did have a close observation of the sample ballot?
Yes, I did.
Okay. And then in column 2, there were races for state controller, state treasurer, state commissioner of education, and state commissioner of agriculture, right?
Yes.
Now, let's take a look here. Here in column 1 for senator, how many votes total were cast for the 2 candidates?
300,426.
And over here in column 2 on the top race, how many votes were cast for the controller?
302,557.
Now, can you draw any conclusion on that said, gee whiz, people were trying to vote over here in column 1, but they couldn't do it because they couldn't punch the chads through?
That's not a conclusion I would draw.
Well, let's look down to the next race. For governor, what was the total number?
310,925. And
then over on the second race in column 2, what was the total number?
309,104.
So there were, for the first one, a little bit more votes were cast in column 2, and for the second set of races, a little bit more votes were cast in column 1. Right?
That is correct.
Let's move to the third race. Secretary of State in column 1, how many votes were cast?
304,786.
And then, correspondingly, the third race in column 2, State Commissioner of Education.
307,072.
So this time, column 2's got a little bit more votes for the third spot, right?
Column 2 wins.
Then let's go to the fourth race, Attorney General. How many votes were cast?
308,523.
And then State Commissioner of Agriculture, the fourth race in column 2.
302,742.
So, recognizing, Dr. Murray, that looking at just one prior election may not be the greatest analysis in the world. I mean, would you agree with that?
I would agree with that.
But it is the analysis that they did, right?
Objection, Your Honor. This is not the analysis that we did.
I guess I'd say
Cross-examine.
it's the analysis that they proffered to this court, and they submitted to other courts in a sworn affidavit from their statistician. Let me put it that way.
Objection, Your Honor. Again, that misstates it. And counsel is continuing to lead. I've been patient on that, but I do object to his leading the witness.
Well, he's an expert, and I don't believe he's going to confuse the expert, so you have some latitude to lead your experts. I'll overrule the objection. Go ahead. Rephrase your question if you need to.
Doing the analysis that Professor Hengartner put forth in his sworn affidavit, and which the Gore legal team included in a proffer that was submitted to this court and the Florida Supreme Court. When you look at the ballot as it actually existed, and you look at the vote totals as they actually existed for the 8 races in column 1 and column 2, is there any statistical support whatsoever for the claim that there's something wrong in column 1 and people are trying to vote their level best, but they're unable to punch the chads through?
On the basis of what we're looking at here, absolutely not.
Now, another possibility that a statistician would want to consider for this difference between the undervotes with the votomatics versus the undervotes with the optical scanners, that there might be demographic differences in the people who are using the 2 different kinds of machines.
It is certainly another possibility that a statistician would want to consider and analyze.
And in fact, in the last couple of weeks, have you seen Vice President Gore going on television saying that it's a shame because the votomatic machines are older machines and they're in poorer areas, and the optical scanning machines are newer and more expensive machines, and they're in wealthier areas?
I have seen that, yes.
And I don't know whether Vice President Gore is right or wrong about that, but if he's right, if what he says is true, then the fact that one type of machine might be used with people with one level of education, one level of wealth, one level of voting past participation, and another kind of machine would be used by people with a different level of education, a different demographic. Is that the kind of thing that statisticians need to look at before they draw any conclusions?
That's the kind of thing a statistician would need to look at before concluding that it is the machines that create the effect that is observed.
And did you look at the individual counties to see whether, in fact, there were some demographic differences that might be significant to a statistician before you leap to the conclusion that it's hard rubber and chad buildup that's causing this differential?
I did.
And what did you see when you did that kind of analysis?
Well, you understand, of course, that I've been on this project for 9 days.
Yes.
And so this is a very preliminary look. But there are demographic differences between the counties, and the votomatic machines are not, for example, used predominantly from that look in poorer counties.
And did you say they're not?
They are not.
So Vice President Gore is wrong about that?
Yes, the Vice President was wrong about that.
Okay.
For that matter, Professor Hengartner does not, I think, from his testimony, disagree with that.
Well, let me read it and ask you whether you agree with what Professor Hengartner said on this. This is at page 32 of his transcript, where he says, I said, if I look at voter demographics like racial profile of the counties, which is the appropriate aggregation in which I have the data, then they can't explain all that difference, referring to the difference between votomatics and optical scanning. Do you agree with Professor Hengartner that based on your preliminary look at the demographic data, they cannot explain all of the difference between the 2 levels of undervote?
Based on my preliminary look, I do not have an independent opinion as to whether they can explain all of the undervote difference. but based on my preliminary look at the data, there are demographic differences. Since I've not seen all of Professor Hengartner's analysis, I cannot comment on his analysis in any detail, but I understand from his testimony that demographic differences in his analysis do explain some of the difference in the undervote rates.
And if somebody wanted to do a thorough analysis that you could draw statistically valid conclusions from about the reasons for these differences.
この違いというのに基づいて分析をしなければいけないわけです。
At the demographic data to see how much of the difference is just accounted for by the kind of demographic data that you and Professor Hengartner both agree accounts for some of this difference.
You certainly would. As Professor Hengartner testified yesterday, the available data at the county level, instead of at the level of very precise kind of data for studying that matter, and so one would not expect to learn the full extent to which other factors could explain the difference in undervote rates from the kind of preliminary look that I and apparently Professor Hengartner have been able to take.
Now, last question, I hope, Dr. Murray. From a statistical point of view, is there any valid basis for drawing the conclusion that people were in the votobannic voting booths trying to vote for Al Gore, but they simply weren't able to push the stylus through the chat?
Absolutely none.
Thank you, sir.
May need a minute to take that down. All right.
Maybe we could put back up the picture that you had up on the screen before.
You have to tell me which picture.
I think it was the last one. It was the Palm Beach County charts.
Sure. Take me a second to find it here. Do you remember the exhibit number?
I don't think it had an exhibit number.
No. I just have to find in my notes where it was so I know what to plug in there. I thought it was 60, but I think I lost a page of my notes, but I'm guessing that it was our exhibit 60. Is this it?
60 was the ballot.
This is I think this, do you want me to blow anything up?
No, this is fine.
Okay.
This is fine. Good morning.
Good morning.
Did you prepare this chart?
Yes, sir.
And what was the purpose that you meant to convey to the court about this chart? What were you trying to use this chart to prove?
I was using this chart to explore for my own understanding the analysis that Professor Hengartner had described in his affidavit in this matter and in his proffer in this matter, in which he drew certain inferences from a comparison of column 1 and column 2, about which he was misinformed apparently.
Did this have anything to do with the testimony that Professor Hengartner gave in this courtroom yesterday, this chart? Or did it only relate to that affidavit in the proffer?
I heard, I believe, Professor Hengartner testify about column 1 and column 2 in this courtroom yesterday, yes, sir.
And what did you hear him testify to about column 1 and column 2 that you think this related to?
I believe I heard him testify about his proposition in his affidavit and in the proffer that there was a conclusion or an inference to be drawn from comparing the ratio of votes in column 2 to the votes in column 1 on the ballot represented by this chart, sir.
You were here in court when Professor Hangarten testified,
I was.
and you know that what you're now talking about is when on cross-examination, Governor Bush's lawyer read him from the proffer in the affidavit. Correct, sir?
If I do not have a clear recollection of the order of events, I remember Professor Hedengartner testifying on that point.
Do you remember whether it was on direct examination or whether it was simply when Governor Bush's lawyer was reading him something?
No, sir, that's a distinction that matters to lawyers, but not so much to statisticians.
Well, sir, in terms of whether you're a statistician or a professional witness, you testify a lot and you deal with lawyers a lot. Do you not, sir?
I have met a number of lawyers, and yes, I work with lawyers.
Right. And you give testimony. For example, you go into court and you testify, and that's basically your business, consulting, right?
Well, there are two propositions in your sentence. My business, my line of work, is statistics and applied mathematics in a consulting context, and on occasion, that calls for me to testify.
Yes. And for example, you'll go into court, and you will testify that a statistical analysis that some other statistician has put into evidence, or that some other organization has published, does not meet your standards as to a thorough scientific analysis, correct?
If a matter involves such an analysis that I have assessed and that I have found does not meet a particular standard, that would be the subject of the testimony, but not necessarily. There could be analyses that I would support.
Well, for example,
You've been watching live proceedings from Tallahassee, Florida, where the Florida court is hearing arguments about
your standard for statistical scientific analysis, correct?
No, sir.
You didn't do that?
No.
Well, sir, what did you testify?
Your Honor, I'm going to object to the relevance of this in any event. If time is short, why is quizzing him about other
Some other matter, some other case?
Well, Your Honor, I think it goes to his credibility, and I think it goes to the way he performs statistical analyses.
Your Honor, I think he's being, the counsel's trying to tar him because he testified in a case that Mr. Boeis thinks would be unpopular with the public, and I don't think it has.
Sustain the objection.
any relevance here.
Irrelevant what the testimony was in some other case.
Let me inquire, Your Honor, whether, because I don't...
You ask him what did he testify to in some other case,
I
which
cannot...
has absolutely no materiality or relevance in this case.
Would the court permit a comparison of the way he approaches what is a scientific statistical analysis in other cases with the way he's done it here?
Not a detailed, so that we get involved in other cases, no, sir.
And Your Honor, I'm going to ask that the court admonish Mr. Boeis about his obligation not to go down that route unless he has a legitimate held belief that there's a difference in methodologies, because otherwise all he's doing is grandstanding and saying that this man testified in cases that Mr. Boeis thinks will be unpopular with the public, and that's not right.
Your Honor, I'm not grandstanding.
I understand. Go ahead and let's see where you're trying to go, but I'm not going to get off into other cases.
Your Honor, I'll abandon the line of inquiry. I think I understand the court's ruling. Let's go back to this exhibit here. Did you mean to imply by this exhibit that you could tell something from these statistics as to whether voters were more likely to vote in column 1 or column 2?
No, sir. I meant by this exhibit to test a proposition that I understood was being advanced by Professor Hengartner in the present matter, and to see whether he was right. or whether he had got it wrong. And it appears that he got it wrong.
Would you agree with me that you cannot tell anything at all from this chart as to whether or not voters are more likely, all other things being equal, to vote in column 1 or column 2?
It appears that...
Could I have a yes or no, then an explanation, Your Honor?
Yes, even though he's an expert, he may certainly in detail explain his answers.
No, because in the context in which the chart is being offered, there is already testimony from another expert in this matter that one can tell something from these data about likelihood of voting in column 1 and column 2.
And do you believe that this statistical chart that's in front of you here or behind you is evidence that is contrary to that proposition?
Oh, but of course, sir. It is evidence that the expert who advanced that proposition couldn't even get column 1 and column 2 straight.
And, sir, did you get them straight?
I think the ballot in Palm Beach got them straight.
How many candidates were there in column 2 in the Palm Beach ballot?
Which ballot are we referring to? This one?
November 3, 1998 Palm Beach County general election ballot.
I don't know that with precision. It's my recollection as I sit here that I have shown all of the candidates from column 2, but I'm not sure that whether that is so or not, and it doesn't matter a whit to the point that I make from this exhibit.
Well, sir, did you look at the ballot yourself?
I did.
And did you notice how many people were in column 2?
I looked at the ballot, and I must have noticed, and I recall, I think, that I have actually held up that ballot next to this exhibit to make sure that I got the columns right, and to make sure that I got the offices right.
And was this a paper ballot or a punch card ballot? Or both?
This was actually what I was looking at, I believe, was the sample ballot, and so it's not a punchable voting medium itself. It is a list of candidates and offices with arrows pointing to presumably where the punch holes would be.
And did you look at the punch card ballot at all?
No.
Did you compare the ratio of votes in column 1 and column 2 in Palm Beach with the ratio of votes for the same offices in optical ballot counties?
No, sir.
Is that something that you would want to do if you were doing what you called a thorough statistical analysis?
Not if I were responding to Professor Hengartner, who did no such thing.
So you would only do what the other person did? You wouldn't do what you think is a thorough statistical analysis?
That would depend on what I had been asked to do. And in this matter, as I testified at the beginning of my testimony this morning, I have been asked to respond to statistical propositions raised by the Gore legal team.
So you weren't asked to do a thorough statistical analysis?
I was asked to respond to statistical propositions raised by the Gore legal team thoroughly.
Were you asked to do what you define as a thorough statistical analysis?
I was not asked to do a thorough analysis.
May I get a yes or no and then an explanation?
You just said he was not asked to. Go ahead and finish your answer.
Thank you, Your Honor. I was not asked to do a statistical analysis of any kind independent of what I was responding to in propositions advanced by the Gore legal team.
But let me see if I can understand what you're saying. You were asked to respond to Professor Hangarten, but you were not asked to do anything else? Is that what you're saying?
No, sir.
Okay. Were you asked, either in an attempt to respond to Professor Hangarten or otherwise, were you asked as part of your work to do what you would consider to be a thorough statistical analysis?
When I am asked to do anything statistical, such
Your
as
Honor, could I
responding...
get a yes or no and then an explanation? That's been the rule with other witnesses.
Can you answer that one, yes or no?
I could, Your Honor, if I could hear that question again.
State the question again. I'm not sure it was phrased where he could, but
Okay.
let's see.
Okay.
At least I will try, Your Honor.
All right. Well, if you ask it so you can, then try to do so.
I'll give it my best shot.
The question is, were you asked, either in an attempt to respond to Professor Hengardner or otherwise, were you asked as part of your work to do what you would consider to be a thorough statistical analysis?
I would have to answer yes and explain that what I mean by that yes is not that anybody said, please do a thorough statistical analysis, but just that whenever I am asked to do a statistical analysis, I take it that people are asking me to do that work thoroughly. I do not interpret a request for statistical analysis to do something slipshod and slapdash.
Well, sir, you used the term thorough statistical analysis several times in your direct examination. Do you recall that?
I don't recall it specifically, but it's possible.
And you said that in order to do a thorough statistical analysis, you would want to investigate other causes for the statistical association that you might see. Do you recall that?
I do.
Did you do that, sir? Did you investigate these other causes?
I've not investigated these other causes because that answer was in the context of what would a statistician want to do in a full statistical analysis of this matter. I've not been asked to do any such analysis, and I've not attempted any such analysis.
Do you distinguish between what you talked about on direct examination, which was a thorough statistical analysis, with what you now talk about as a full statistical analysis, or are those the same thing?
No, sir. These expressions have to be understood in the context of what is being talked about, and the context of my work in this matter is a response to the statistical claims raised by the Gore legal team, not an independent and elaborate study of voting patterns.
Did you look at any election statistics for the November 3, 1998 election outside of Palm Beach County?
I must have, because I believe when consulting the source of the data used here, what one sees on the screen is all of the election results for 1998. But I have no specific recollection, and nothing that I have said here this morning depends specifically on any other kind of data.
Well, my question just is whether you analyzed or looked at it.
I understood your question to be whether I looked at, and when an item appears on my computer screen, I see it.
Okay. Other than sort of seeing it because it was on your computer screen, did you consider it at all?
Not that I recall.
Did you look at on your computer screen and do so sufficiently to remember what the statistics were in the November 3, 1998 election in optical ballot counties in Florida?
No, sir, I don't recall that. I don't recall doing that.
Do you know whether the undervote in the November 3, 1998 election in Florida, there was the same disparity in terms of undervotes comparing punch card counties with optical ballot counties?
No, sir. Like Professor Hengartner, I don't know that either.
Is that something that you had available to you on your screen if you had looked at it?
No, sir.
Did you ever ask anybody for that information?
No, sir.
Let me turn to the election that we're involved in. And if I can find where the charts were put back, I want to show you some of the charts that you were asked about. Plaintiff's Exhibit 7. Now, I'm correct, am I not, that as a matter of arithmetic, you don't have any disagreement with these statistics that are shown here?
I believe the division was done correctly, yes.
Now, am I also correct that you agree that the difference in the percentage of undervotes for optical ballot counties compared to punch card ballots counties is very, very unlikely to have occurred purely as a matter of chance?
Yes, sir, that would be true, just like the correlation between the seatbelt sign and the turbulence in the airplane. Doesn't happen by chance.
Exactly. That happens because the seatbelt sign is turned on by the pilot when the pilot thinks, based on information that the pilot has, that there's likely to be turbulence. Correct, sir?
That is correct. There is a mechanism in between. It is not the seatbelt that causes the turbulence to occur.
Is there a mechanism like that that applies to the difference between optical ballot counties and punch card ballot counties?
Several such potential mechanisms came up in my previous testimony, in fact, and in Professor Hengartner's testimony. Yes.
Well, my question was not whether potential ones came up, but whether you've identified any such cause.
I have not identified and studied in detail in the past nine days such causes, no.
Have you reached a conclusion that there is any such cause that explains that difference?
I do not have a conclusion about what it is that causes those differences. My conclusions are about the absence of evidence for certain causes that have been advanced.
Okay. Now, would your answer be the same for the other charts that Mr. Handgarten put in? That is, you don't have an independent conclusion as to what causes the statistical differences that are shown.
I do not have independent conclusions about the true causes of the differences that appear in Professor Hengartner's charts, no.
Okay. Let me just try to clear up a few additional items, and then I think I'm through. You mentioned ballot roll-off, and you mentioned a particular article by Stephen Nichols. Do you recall that?
I do.
And ballot roll-off refers to the fact that people, when there are a lot of names on the ballot, will tend to vote less for the less contested, high-visibility races, correct?
That is one interpretation of that term, yes.
Well, that is, in fact, the interpretation that's given in this article that you rely on, correct?
I would have to review the article to make sure that that was the and the only interpretation, and that would take more time than we have.
Well, let me just ask you to read one sentence that I've highlighted and see if you agree with that.
What page are you on, please?
It's on the second page of the... Could you read that into the record, please?
I do. I could. This is on page 107 in the second column, and it reads, this is a portion taken from the middle of the paragraph, and it reads, also known as voter fatigue, ballot roll-off is the long recognized decline in the number of votes cast in lower ballot contests as compared to the tally in the higher profile partisan contests that attract most voters to the polls.
Do you agree with that definition of ballot roll-off?
I doubt that there is a single truly precise and universally recognized definition, but this is a fair characterization.
Now, in the election that just occurred this last November, did you vote in that election?
Yes.
And as a voter, did you have a view as to what the highest profile race was in that election?
I thought it would probably be the presidential part of the election, yes.
Yes. Let me ask you just a couple questions about the Iowa study that you referred to. Did that Iowa study deal with punch card ballots?
No.
Did it deal with optical ballots?
No.
Did it deal with a comparison of punch card ballots with optical ballots at all?
No, sir, and that's why I didn't bring it up in that context. It clearly has nothing to do with a vote, or it does not reference the actual machines used in Florida. Its relevance is the effect of differences in voting method on voter behavior.
And the causes of the lost votes that are referred to in this article
Yes, sir.
are what, sir?
There are numbers of potential causes, including the appearance and the organization of the ballot. The transition from paper ballots to voting machines itself is cited in some portions of the report as a cause. But again, just to be clear, in case I was unclear before, the relevance of the report is not because it refers to vote-o-matic machines and optical machines and systems, because it does not. The relevance of the report is that it is a documentation over a 64-year period in Iowa of the effect of changes in voting method on voter behavior, establishing the proposition that voting method influences voter behavior.
And the voting behavior, the main voting behavior that was analyzed here was the behavior of whether or not voters came to the polls, correct, sir?
Various voting behaviors were analyzed, including voter choice to vote offices once at the polls.
Well, sir, may I approach on?
Hey,
Let me
I
ask
think you have
you.
another report up here somewhere, too.
Yeah,
I do.
you do. Would you turn to page 36?
36 of the 110 approximate pages. This would be chapter 4.
Yes, and what is the title of that?
Causes of lost votes.
Okay. And would you turn to the last page of that chapter?
That would be page 40.
Yes?
I have it.
And would you read into the record the last 4 paragraphs? Beginning, what we seem to have here is not 1 but 2 voting machine effects, 2 kinds of undervoting. Do you see that?
Okay, so this would be the last 4 paragraphs of chapter 4, beginning in the middle of page 40. What we seem to have here is not 1 but 2 voting machine effects, 2 kinds of undervoting. 1, a failure on the part of some voters to operate the machines properly to record their votes. This effect was transitory and may have been solved by improvements in the voting machine mechanism. 2, a failure on the part of some voters to come to the polls at all. They don't vote because they don't try, because they don't want to be embarrassed, or for some other reason. This effect, which represents about 5% of the potential voters, is pervasive and persistent. These considerations should guide our efforts to educate citizens for effective participation.
Sampras.
About the first effect being transitory.
Since this is a summary paragraph, sir, the specific use of transitory here clearly refers back to analysis in this 110-page document, which I do not have freshly in my mind right now. So I can give you my understanding from the dictionary and as a term from plain English of transitory, but I cannot give you a precise characterization of what transitory means in this context, in this 110-page report.
All right, sir. The only reason I asked was because this was a report that was introduced on your direct. If you can't, you can't.
I can, if it's fair to interpret your question as what does transitory mean as a word in English, I can do that for you.
Well, what I really meant was, what was your understanding of what it meant in this article that you used on your direct examination and that you referenced to me when I took your deposition?
I can characterize that generally for you, again, with the caveat that this is a report based on numerous statistical analyses, not all of which I have in my head. But the general sense of that term here is that certain of the influences on voter behavior that were observed in this analysis appeared most strongly shortly after the introduction of a new voting method and became attenuated thereafter. In other words, there was an initial spike and then things were not quite so strong, or that they were somehow different, but I can't give you any more detail than that.
Okay. Mr. Beck asked you some questions about the butterfly ballot. Do you recall that?
I recall that he mentioned it, yes.
And are you aware of any suggestion that the butterfly ballot led to undervotes?
I don't recall that suggestion specifically. I recall numerous suggestions in the news media, which are really my only source of information on butterfly ballots, that butterfly ballots influenced voter behavior in a variety of ways.
Do you recall that it was influencing voter behavior that maybe lead some people to vote for two presidential candidates?
I believe I do remember that.
And that would not result in what we refer to as an undervote or non-vote, would it?
Voting for two presidential candidates would not be what we are calling an undervote here.
Okay.
Although confusion about how to vote for the single candidate of one's choice might conceivably cause one to skip voting for either one. But this is not something that I know as a statistician. It's an issue that one could study. I have not studied it.
And indeed, you haven't seen any assertion, even in the press that you read, that the butterfly ballot caused people not to vote at all, as opposed to vote for two people.
As I testified a minute ago, sir, I recall a variety of propositions about the butterfly ballot, and I have no clear recollection, one way or the other, of whether I've seen that one.
Okay. Have you made any attempt to determine, with respect to the Miami-Dade vote that you mentioned, the Miami-Dade precincts that have not been recounted, have you made any effort to project or estimate how many of those uncounted votes would be votes for Governor Bush and how many would be votes for Vice President Gore?
I am not entirely sure that I have done it for the net effect of those two, and I guess implicit in that must be then the additional votes for Gore and Bush, but only for But what I had in mind was the net effect, because I understood the claim of potentially 600 net Gore votes to be about the net effect and not about the individual totals.
Okay, so you focused on the net effect, and that's fine.
Yeah.
But what I'm asking you is, with respect to the 9,000 ballots that have not been counted, and you understand that it's about 9,000 ballots, do you?
Yes, I do. Roughly. I
roughly.
believe that's an approximation.
Approximately. The approximately 9,000 Miami-Dade ballots that have not been manually counted, what would be the net effect on terms of presidential votes of counting those 9,000 ballots, in your opinion?
Your Honor, the Secretary and the Commission objects to any sort of statistical presentation of what the votes would be for one candidate or another as being irrelevant under the Florida statutes. The only standard is a manual count, which, as you know, we maintain has to be done on a statewide basis. So having this witness testify as to what he thinks one person would or would not have won in the county is irrelevant under Florida law. We object.
Well, I understood the witness to say he had not conducted a thorough statistical analysis of this, and I don't recall him having testified concerning this on direct. But if he...
That's correct, Your Honor.
But if he did, then I would suppose it's a subject matter. What's correct or not?
You're correct, Your Honor, that he did not testify about a statistical analysis to come up with such a projection, and this is beyond the scope of direct examination.
The very first thing I wrote on my notes, Your Honor, was his testifying about how there were heavily Democratic precincts that were counted, and then there were Republican precincts that weren't counted, and he talked about 48% to 52% and 75% to 25%.
Well,
And I think that related to Miami-Dade.
No, he was testifying that with respect to whether or not that was a valid approach to project the 600 vote increase, that I understood this witness to say that he said that in his opinion, no, because it was based on a false premise, and that is that if the that would be dependent on if the proportion of the net were the same, and pointed out that in the 3 counties that had been selected, I believe that those were, the vote there was were greater than 75% to Gore versus roughly 25% to Bush, versus countywide the vote was 52% to 48 the other way. Therefore, there was no basis for any projections from those precincts. Did I misunderstand what you said?
No, Your Honor, that was it exactly, and I wish I had said it that way.
All right. But did you testify
Objection,
that you
Your
had
Honor.
made a statistical analysis, sir, so that you could project?
No, sir.
All right. That's my recollection, Counsel.
And I just want to follow up on the last question. Could I just have that question answered back, because I wasn't sure I heard it? Did you say to the court that you had not done your own analysis of what those votes would be?
No, sir. I
Your Honor, he
understood.
said that he wasn't asked on the direct examination. That was the objection. That's beyond the scope of direct examination.
I understood Your Honor's question to be, did I testify to a statistical projection?
Yes,
And I
correct.
answered no.
Your Honor, may I ask him whether he's done such an analysis?
Your Honor, I would like to reiterate our same objection. I don't mind being overruled, Your Honor, but I do not believe it is the least bit relevant to have a statistician sit up there and testify as to what the result difference would be in one county. That is not the issue that is before the court. Under the statute, they have to demonstrate that there would be a difference on a statewide basis, and we believe, Your Honor, that the only basis under Florida statutes and Florida law is a manual recount of the entire state, if you can do such a thing, which we also question.
Well, that's a matter of argument, but I don't know at this point. We're still trying to take evidence, and whether or not there's a legal basis is a fact determination. I frankly don't know. It was my understanding the witness said he had not undertaken and done a thorough statistical analysis of this, and If that is the case, I don't know how he can express an opinion. And frankly, it's outside the scope of Cross. But your question is, you want to ask him if he's done a thorough statistical analysis of this?
Let me start with that.
Even though we're not going to get into that?
Yes, let me start with that, if I may, Your Honor.
Yes, sir. Okay.
Have you done what you would consider to be a thorough statistical analysis as to what the net votes would be in the presidential election if the precincts in Miami-Dade that have not been manually counted were manually counted?
Can we specify, are we talking about in that county alone, or are we talking about statewide?
I'm talking about the votes in that county alone, although obviously the votes in that county alone, if they were enough, would affect the statewide election.
Your Honor, I would object again that they would only affect the statewide.
Well, that will be a matter of argument, and I understand that would be his position to argue, but we're trying to figure out the facts right
It's
here.
not appropriate for someone to try to make someone else their own expert, and it's clearly beyond the scope of direct. And Mr. Boeis and his people are very interested in moving this along. This is not moving it along.
Let me just ask the question. Have you done a thorough statistical analysis of this particular matter relating to this particular county?
I have not done a thorough analysis
Thank you
with
very
a
much.
conclusion.
Okay, all right.
Okay. Now, can I ask him whether he's done a preliminary analysis of that?
I think it's all irrelevant whether he's done a preliminary or not. If he hasn't done a thorough one, he has nothing of any probative value for us here today, sir.
All right. Would you agree that the only way to tell, in fact, what those ballots represent is to look at the ballots themselves? You cannot tell that purely from a statistical analysis.
Your Honor, I'm going to object. We're into argument now. This is not cross-examination of a statistician. We want to move it along.
I call this being in the scope of his direct.
Right.
Rephrase that. Let me hear.
I thought it was fairly raised by his testimony, Your Honor, but I will accept the court's guidance if you think it's beyond the scope. Okay.
If you want to rephrase it, I'll
Okay.
try it one more time.
Okay. Do you believe that the only way to tell for sure what the votes are in the 9,000 uncounted Miami-Dade votes, who those votes were cast for, if anyone, is to look at the actual ballots?
So that's outside my professional expertise as a statistician, but as a citizen watching television, I can't say I saw any process that I would characterize as telling for whom those votes were cast for sure.
I was meaning to talk about the court reviewing those ballots, and I take it that you would have confidence that the court was able to look at the ballots and make a determination as to whether they should be counted.
I believe he was brought as an expert. Now he's testifying. You're asking questions about him as an individual citizen, so I think we need to move back into his testimony as an expert.
I'll move things along, Your Honor. Thank you.
Does that mean you're done?
It does.
Oh, all right.
Judge, I have just a couple of points. First, when Mr. Boeis was asking you whether you've done this thorough statistical analysis that I also was asking you about, I think you indicated you were first contacted by me or one of the members of my team about 9 days ago. Is that right?
That's about right.
And the kind of thorough analysis that we were discussing that would have to be undertaken in order to really find out what the cause is of these undervotes. Was that humanly possible to do in 9 days?
No, sir.
If one were to undertake that kind of analysis, would it still be ongoing when the Electoral College met and decided who was going to be the next president of the United States?
Sustain his objection to ask and answer.
We are moving faster. Patrick, could you put the chart up on there and I need you to flip me over to, there we go. Thanks. Mr. Boeis was asking you whether you remembered how many races were in each column. Do you recall that?
I do.
On the sample ballot you looked at, and just you've got 4 races in each column on your chart, right?
That's right, although I should mention that this chart is not to scale, so if one were to look, as I recall, at the ballot, the races, there are 4 races shown here, but they don't sit on the ballot book exactly next to each other in the way that they are shown here. This is the right order.
And of course, the ballot book doesn't say how many votes one person got. But you've got a chart summarizing the results of the vote, right?
Yes, that's correct.
Let's look over, please switch us to the ballot. How many races were in the column 1?
1, 2, 3, 4.
And how many races were in column 2?
1, 2, 3, 4.
So is that the same numbers that you showed on your chart?
Yes.
Thank you. That's all I have, Your Honor.
Thank you very much. May the witness stand down without objection. All right, at this time, would it be appropriate to take a, well, we got so many people. Is 10 minutes satisfactory? I like to stay on the hours if we can. All right, let's stand in recess until 11 o'clock.
We have been watching the proceedings in Leon County Circuit Court, where they're holding the election contest, the Gore camp contesting the results of the Florida election. This is Judge N. Sanders Saul announcing that we're going to have a break right now. I'm Patty Ann Brown. Thanks for staying with us.
Yes, Your Honor.
And, of course, the big question here is 14,000 ballots in Miami, Dade, and Palm Beach counties, which the Gore camp wants to be recounted. And, of course, N. Sanders Sauls, the judge, will decide that case, which could decide the presidency. Both sides have said they will, in fact, appeal this to the Supreme Court, regardless of the decision. And, of course, after this break, we will have much more and wrap this entire thing up for you. Stay with us.
Log on to CNN.com. Up-to-the-minute, in-depth, interactive, global coverage of the day's major stories. Politics from Capitol Hill to Main Street. Weather, stocks, and scores. Everything you need to know whenever you want it. Get it all at CNN.com.
Business Unusual. Sundays on CNN. CNN Golf Update in association with Rolex. Worn by champions all around the world.
We're back with cricket and action from day 4 of the second test between Pakistan and England in Faisalabad. The England chased a Pakistani total of 316 and they reached 294 when Annie Caddick was out there. Darren Guth helped the visitors' cause, hitting an unbeaten 19 with the help of this 4 off Danish Canera. Craig White also kept things going, making 41 before being bowled by Shakleen Mushtaq. England all out for 342. Once back at the crease with the bat, Pakistan set about a comeback with a passion. Abdul-Razak taking Ashley Giles to the boundary for 4. And Giles was the victim again here as Salim Elahi reached his half-century in only his 6th Test match, the 50 coming off only 82 balls. He'd eventually fall to Giles, caught by Alex Stewart for 72. But Pakistan headed into the final day on 186 for 2. On to NBA action from New York, while Paul McCartney was on hand to see the Knicks game against Minnesota. Kevin Garnett doing some damage early on, reverse slam here. But the Knicks were up by 8 at that point, and they were up by 4 at the half, helped by Allen Houston, who had 20 points after 2 quarters. Third quarter, Knicks up 2. Garnett again, this time with a finger roll, 2 of his 21 points. But the story in this game was Allen Houston. He shot 16 for 20 from the field, had 37 points, 17.
Was also cross-examined.
And some interesting things came out of this. He was pointing out that statistically, he called it a false premise by the Gore camp that they can project from the 20% of the vote already counted in Miami-Dade and assume that Gore was going to get 900 votes more than Bush once they counted the entire county.
2 different math experts, 2 different conclusions.
Exactly, and it's not over yet. But let's go right now to Brett Baer, our own correspondent standing by in Tallahassee. Brett?
Patty Ann, Trace, hi there. After 2 hours of testimony from Dr. Laurentius Murray, the Bush campaign's witness, by all estimations, he was a very, very crisp and clear witness. Of course, an opposing side, a statistician who was trying to tear apart the Gore witness from yesterday, Professor Hengardner, who was trying to say that perhaps the machines, the voting machines, caused some of the problems that we saw in the ballots with the dimples and that sort of thing. And Professor Hengardner yesterday said that the percentages statistically indicate that places like Palm Beach County and Miami-Dade County, there were a higher number of undervotes when compared to other counties across the state. Now, Dr. Murray spent a lot of time really tearing apart that testimony, and the Bush campaign attorney Phil Beck did, as he did yesterday, a masterful job of trying to steer this witness into tearing apart that testimony. You saw David Boeis try to take some of the credibility away from Dr. Murray. The question is whether he managed to do that. At one point, you saw Judge Sanders Sauls essentially reiterate what the witness, Dr. Murray, had said numerous times, suggesting that Judge Sauls was paying clear and close attention to what Dr. Murray was saying. So all of this goes to the bigger picture that the Gore campaign needs desperately for Judge Sauls to order a hand recount of about 14,000 contested ballots in Miami-Dade and Palm Beach counties. They believe in those ballots are the votes for Vice President Gore to win this election. And without that order and without this trial getting to that point, their contest is essentially over. No matter what happens, we're going to see an appeal to the Florida Supreme Court. But right now, it's tough to say whether this is going anywhere that the Gore campaign likes. Trace?
Brett, talk about the timeline a little bit here. We've got nearly 2 hours of testimony, 1 witness so far. The Bush camp saying they could present as many as a dozen witnesses today. They might cut that list. Are we looking, is it possible to get this thing done today?
It is possible. Judge Sauls had said that he really wanted to wrap everything up today. Perhaps we're dealing with a dozen witnesses, but that may be a shorter number, as the Bush campaign says they are planning to cut down the number of witnesses they call. Also, the Gore campaign may stipulate a few things when witnesses get up there in order to speed things along. Judge Sauls saying he really wants to wrap this up today, and then, of course, you would wait another day for a ruling from the judge here. But this is excruciating by some estimations, definitely, because it's just taking a long time to get to the details of all of these witness testimony.
Brett Baer, live in Tallahassee. Brett, thank you.
All right, and now we have 2 legal experts standing by to discuss what we just saw in court. We have James Portnoy, a Democratic attorney, and also Sophia Nelson, a Republican attorney. Thank you both for joining us. And let's ask you just for general reactions. First of all, let's start with Mr. Portnoy.
To the hearing?
Yes.
Yeah. Well, at this point, I think the Gore camp is trying very hard to demonstrate that there was a systematic problem in at least the contested counties. and that a manual recount is going to be necessary in order to discern the real intent of the voters. But I'm not sure that they're succeeding as well as they had hoped. I mean, it seems clear that the Republicans have at least cast some doubt on that claim, and that Judge Saul seems at this point to be sympathetic. So we may very well need the Florida Supreme Court to resolve this.
Well, I don't disagree with much of what he said here. I think that the Republican counsel has done a very masterful job with the expert testimony and taking apart as far as what the Gore experts have said and putting on their own witnesses that I think have done a very good job as well. And I think I see a little frustration with David Boeis, and I agree that I think the Gore folks aren't having things go as well as they'd like. And I do think Judge Sanders Saul is, I would agree he's a little bit sympathetic probably to our position in all of this.
We should warn both of you folks, we are looking at live pictures now of the courtroom in Tallahassee, still awaiting for Judge Sanders and Sanders Sauls to reconvene here. Let me ask you, Mr. Portner, you have said that you still think that Mr. Bush will win this contest because you think, quite frankly, the Florida courts have done a lousy job.
Well, I think that the Florida courts and Florida officials collectively have not managed this process efficiently. Now, part of the problem, of course, is that the courts can only take cases as they're brought to them. But I think it's clear that nobody has taken a circumspectral view of this thing, looked on it from on high and said, okay, how do we get through this thicket in time to have a resolution before Election Day? And the litigants really have not had much opportunity to do that. They've been in a fairly reactive mode. And the court hasn't done it. The state hasn't done it. So we're lurching along, and that's the situation we face today.
Again, I agree with James. He's making my job very easy here today. We don't disagree on a lot. I think that, quite frankly, though, the ruling I'm interested in is what the U.S. Supreme Court is going to do with regard to whether or not the Florida State Supreme Court overstepped the bounds of Article 2, Section 1, and then 3 U.S.C. Section 5, dealing with the Florida legislature and their powers versus the judiciary. So it'll be interesting to see. I expect we'll have a ruling sometime early this week, hopefully as early as Monday. I don't have any inside information on that, by the way.
Talk about, if you would, both of you, just talk about the attorneys here. Have they both done well at expediting this process, or are the Republicans trying to stretch this thing out a bit?
I would say both those things are true. Clearly, the Democrats have an incentive for expedition and the Republicans have an incentive for delay. But any trial lawyer will tell you that that's often the case. We're looking at the height of advocacy. There are no better lawyers in this country. You'll never see a better example of the way trial work is supposed to be done. They're responsible. They're doing their best to do what their professional obligations require. But it is true that in this case, running out the clock helps the Bush camp. And as a consequence, his lawyers have no incentive for expedition and may even have an incentive for delay.
Well, James and I were talking. I think the Gore lawyers, quite frankly, hurt him when they didn't allow the original certification to stand, because had they done that, meaning the November 14th certification, Gore would have then had more time to go forward with the contest. So that's my opinion on the lawyering from that aspect, that I think they should have allowed Gore to have more time to put together this, this contest period.
All right, Sophia Nelson and James Portnoy, thanks so much for joining us. And please stay with us. We might want to go back to you for more analysis later on. But right now, we're going to take a quick break. And as you saw, things might be starting up again in the courthouse soon.
Visible plans to move in.
From New York for her marriage to the Prince of Monaco, the beautiful Philadelphia motion picture star Grace Kelly is interviewed aboard the liner Constitution, producing a mob scene that must remind her of the movies.
Well, James, as I said before, just getting married is a very big step for any girl, and I'm, of course, I have a great many feelings about that, and it's a very exciting thing, and I'm very, very happy. Of course, I'm a little sad to be leaving home, but I hope to be back quite often.
So almost all the Kellys are going except one, Lizanne. She can't make it.
My sister's expecting a baby the first part of May, and she's just heartbroken that she won't be able to be with me.
Would you repeat for us the status of your citizenship now that you're going to Monaco?
Oh, when I'm married, I will have a dual citizenship. on marrying His Highness. I will become monogamous, but I will also retain my American citizenship.
Does that go for your children, too?
I don't know about that as yet.
Natalie, how's your French?
Comme ci, comme ça.
Colonel, it's been a great delight to be with you and these distinguished friends of mine today, and I wish very much that I could come down here this summer instead of having to spend the summer in the hot capital of the state of New York.
We have a feeling that you're not going to come here very often as governor. You're coming here in a more important capacity as president of the United States.
That is the most important statement that has been made during this luncheon.
And probably the most truthful one.
Legal scholars on both the left and the right of this issue.
And let's go first to James Portnoy. One of the main reasons why the Gore camp is going through this is because they are assuming that they would pick up enough votes in a full hand count of Miami-Dade County to give Gore an extra 600 votes, which was, of course, put him over the top since Bush is leading by 537. But what we heard this morning from the statistician for the Bush camp is that that is, in the statistician's words, a false premise, because the initial hand count of 20% of the county was done in heavily Democratic districts, and that you can't project that those results are going to hold because some other districts went to Bush by 80% or more.
Well, that's certainly true. But the Gore camp isn't relying solely upon the votes in Miami-Dade. There are also the uncounted, or the votes from, I guess it was Broward, that weren't accepted by the Secretary of State. There are other piles of votes out there that gradually could be cobbled together to add up to the margin, even if Miami-Dade doesn't come back big enough. But at the end of the day, what other strategy is there? If you don't count any more votes, Governor Bush ends up ahead. You have to count more votes if you want, in support of Vice President Gore, the outcome that he believes and that I believe the American people, or at least the people of Florida, actually opted for.
Ms. Nelson, how is it that we can take two different math experts, the attorneys, and get two different conclusions?
Well, you and I both know that you can play with statistics any way you want to. You can. That's why you have expert witnesses. You want one to get up on the stand. That would be the Bush side that says, look, the machines were functioning properly. Statistically, the averages came out correct. This happened all around the rest of the country. They're undervotes. Sometimes people don't vote, et cetera, et cetera. Then, of course, the Gore folks want to show some doubt and cast some doubt that perhaps there was a machine error, perhaps there was demographic error with African Americans in one part where those in wealthier communities had better access to ballots, et cetera, so that they can cast doubts. I mean, it's just simple putting on your witness to further your point of view. It happens all the time in litigation. It happens every day in this country. Depending on what the issue is, it doesn't matter.
All right. Thanks both James Portnoy and Sophia Nelson for joining us.
Thanks again.
Thank you.
Joining us now from Washington to talk about the legal ramifications of all these court fights, our old friend, Georgetown University Law School professor Paul Rothstein. Professor, thanks again for joining us. Your take on what's going on down in... Yeah, we're doing well down here. We're waiting for the break to the court to resume down there. What is your take so far on this morning's proceedings?
Well, I was watching it from beginning to end, and several things strike me. First of all, the Republican case is prepared much better, and the presentation is much better than the Democrat case. I think that statistical expert was prepared in a much better fashion and actually kind of creamed the Gore statistical expert. And it's surprising because in the United States Supreme Court case, looking at the two briefs, the Gore brief was so much more sophisticated than the Republican brief. So apparently there's some unevenness in where they're directing their effort. But this contest is make or break for Mr. Gore, this one before Judge Sauls. I do think Judge Sauls is tilted against Gore because in those judicial rulings, evidentiary rulings, where the judge has discretion to go either way, he has called them against Mr. Gore, against David Boeis. Two in particular I would mention, which I think are questionable. In one, Mr. Boeis wanted to attack the Republican statistical expert who had said that you cannot conclude from the fact that with the punch hole voting machines, there's a much larger number of undervotes than with optical scanners, where you actually fill in with a pencil a black mark. You can't conclude from that there's something wrong with those machines. There might be some other cause. We don't know, but there might be for this difference. And Mr. Boeis wanted to show that this same expert had applied his same statistical standards in another case to claim that there is no causal relationship between lead in lead paint and defects in children's intelligence who are exposed to the lead paint, when actually science now believes there is a causal connection between those two things. So, and Mr. Boeis was not permitted to ask that question, and I think that it really is a fair question. The judge thought it was irrelevant, but it really shows that sometimes this standard that this guy was applying can make a wrong call, and he is applying it here and saying there is no connection between the kind of voting machine and the undervotes.
Right.
That was another bad call too. It seemed to me when he wouldn't allow Boeis to ask this expert, well, if you dispute our projections about what the Miami-Dade vote would be for President Gore, if you projected from the little sample they did, if you dispute that, what do you think Mr. Gore would pick up? What would be the net gain if you projected from the little sample that they did? And the judge said, oh, that's beyond the scope of what he was asked in the main in the direct examination. Well, actually, he had raised the general subject in the direct examination by disputing the Democrats' projections.
Okay. Well, a lot of legal language going on, and, you know, we're getting down to individual ballots here, but everyone counts. I mean, we're down to a 537-vote lead for Bush, and that's what this hearing is all about, is Gore trying to come up with a few more. Looks like we just lost our signal from the courtroom, but we are on a break right now, reminding people we will be going back to that. But in the meantime, Paul, let's ask you about the other court case going on, the U.S. Supreme Court case. What was your take on how that's gone so far, and the judges, you know, working this weekend, the justices of the Supreme Court on that case?
It's really problematic as to how that's going to come out. You really couldn't tell. There was some sentiment from the questions of the justices that they were maybe considering pulling out of the case altogether, but then at other points, the conservative justices, Rehnquist and Scalia, seem to be leaning against Mr. Gore's side. The liberal justices, Ginsburg and Souter and Stevens.
Professor, we're going to have to cut you off right there.
Way, so
Judge N. Sanders Sauls reconvening the courtroom. Let's listen in.
Are we ready to proceed?
Yes, Your Honor, one preliminary matter, if I may.
Yes, sir.
Preliminary matter. From a one verified motion for pro hoc vici from Manuel Klausner, who is in good standing with the California Bar. He has not appeared in Florida courts in the last 2 years. And he filed a verified motion yesterday. He's right there, sir. We asked to move him pro hoc vici.
Well,
thank you, Your Honor.
Mr. Kitchen.
Judge, quickly, we yesterday expressly asked you about the opportunity to go through plaintiff's exhibits that have been offered, admitted, and make sure everyone's on the same page so that the record will be clear.
Yes.
The 388 ballots that were undervotes that were actually counted in Dade County, we've now had separately marked as plaintiffs 59 for identification. Out of an abundance of caution, we want to move 59 in. It may already be in, but so that won't be.
Without objection, so ordered.
Very good. Now, Your Honor.
Yes, sir.
I'm not sure. I'm a Terrell. I'm sorry to address Your Honor, but is the exhibit that the plaintiffs have offered actual ballots that are undervotes? I couldn't hear it.
Yes, yes.
Yes, sir.
Well, I assume they want to put in an exhibit number, but as far as I know, those ballots are still where they're supposed to be, and apparently are separated and kept in a different place, so they're available in the event we need them.
My point is, I do object to Governor Bush to any admission of Miami-Dade ballots for reasons that will become clear in the testimony of my witnesses. At some point.
All right, this time then there is an objection, so we'll have them. They've been identified with an exhibit number, and then we'll see about whether or not there's a subsequent admission. Just make a note of it. All right.
And Your Honor, we have objections as well. We have it in writing, which we can just hand out and distribute to their exhibits on behalf of the Secretary of the Commission. And they can just be dealt with.
All right, I believe that what we said is that we would give them preliminary admission subject to determination of any specific objections.
We'll just hand them up. Your Honor. Thank you.
All right. Mr. Beck?
George W. Bush and Dick Cheney called John Amon as their next witness.
Ask him to come forward and be sworn. You'll allow the clerk to swear you in, sir?
Please raise your right hand. You solemnly swear that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please be seated.
Be seated, sir. You may proceed.
Sir, would you please state your full name and spell your last name for the record?
My name is John Amon, A-H-M-A-N-N.
And Mr. Amon, what do you do for a living?
At present, I'm a rancher in Oregon and California. And I also have a small elections supplies company in California.
Have you had experience over the years with punch card ballot machines?
Since 1966, yes, sir.
And have you been asked by me to come here and offer testimony concerning the design and operation of punch card ballot machines?
Yes, sir.
And particularly, have you been asked to come and give testimony about how indentations and dimples can find their way onto ballots used in punch card machines?
Yes, sir.
You have to speak up just a little bit. Before we get to that testimony, I'd like you to spend a few minutes describing your background in the industry and try to be as brief as you can while still giving the court a good grounding in your experience. So starting out with your first job that was in this area, and then kind of run through chronologically as briefly as you can.
I joined IBM in February, as I recall, 1966, and I worked in the tab card plant in Campbell, California. On or about May, June of 1966, I was asked to assist in the rework of the votomatics that IBM had built and were used in the primary elections in 1966. We did that, and we continued to work that summer on the votomatic. I installed and was assisting in the installation and rebuilding of all the equipment that went into San Bernardino County. I was in charge of the rework operation. After that, I made about 85 suggestions as to how they could improve the product. For about 2 months, I was asked to work on the crimped hinge, which was an idea they had, which they thought would speed up the assembly of the ballot pages. In doing that, I designed the crimp hinge, patented, and I didn't patent, but I worked on the mask punch and the crimper and made a single unit out of that crimper puncher. I then was asked to go back to the engineering department in Dayton, New Jersey, for IBM, and become the responsible engineer for IBM to assist in developing and debugging the IBM votomatic. I did so. A year later, they sold Los Angeles County, and they sent me back to California, and I installed Los Angeles County.
You say you installed Los Angeles County. You mean you implemented the changeover to the Votomatics in Los Angeles?
Yes, sir, that is correct. And
What year are we in now?
We are in 1968.
Okay.
And at the end of 1968, IBM exited the voting equipment field and decided to concentrate on computers. Three of the salesmen and the chief programmer for IBM, Ken Hazlett, decided to form what was then known as Computer Election Systems, CES.
So CES, and this was the end of 1968, beginning of 79.
69, yes.
I'm sorry, 68, 69.
Right.
And did you go with CES?
Yes, they asked me to come with them and join them, and they did make me a minor partner in the company. I was the engineer that actually designed, developed, and built all of their equipment for 7 years.
And so that brings us up to, what, the mid-70s?
That is correct. During that time, we developed the Model 3 concept, which is what most of the counties here in Florida are using. And the 3P was developed the year after I left, after we installed Cook County and precinct ballot counters, which I also helped design and develop. And that is the unit that you have down in Dade County, the 3P. After that, I worked 2 years for another company, Consolidated Foods Corporation, as a plant manager. And approximately June 1978, my wife and I decided to start our own little supplies business and go into business. We called our company Election Supplies Limited. Within 2 years, I reinvented the Model 3, basically, and we call it the Model 5. It was a streamlined, more compact version of the Model 3. We put a full 5-year warranty on it. I also patented the new stylus, which was stronger, had more flexible tip, had virtually no breakage on the tips of that stylus, and many of them were sold and distributed throughout the state of Florida. We also sold from our company at that time in the mid-'80s approximately 6,000 new punch frames to Dade County. So we also had our labels, a very large instruction label, which you saw here in the back of the booth yesterday. That was from our company. That was our design and development. So that was to aid in making sure that the voters turned their card over and checked the backside of the ballot for hanging chad. And it was thought to be a very good improvement. We've sold a lot of those, had sold a lot of those. We continued with Election Supplies Limited until Business Records started to buy up all the small voting election machine companies. We continued as ESL until 1986, at which time we did merge with Business Records. My wife and I had a 5-year contract to continue managing our business. We manufactured all the voting equipment, punch card voting equipment, and booths, developed a new Optec ballot box for the Optec, which is still used with the Eagle, I understand, in some locations, as well as a new electronic voting machine, which I'm listed as a patent holder on. I have 11 patents, actually implemented over 50 design changes in new pieces of equipment and gear for the Votomatic system, including the semi-automatic crimper, pneumatic crimpers, the new auto hinge feed crimper, and so forth. This is the auxiliary equipment which I have serviced here in Florida just this last March in about 5 counties. We sold to Business Records, as I mentioned, in '86. At the end of 1991, they felt that they could go ahead and manufacture all of our equipment on their own. They didn't take any people. They transferred it to Texas. A year and a half later, I received a phone call that said, "John, I don't know how you did it, but our hat's off to you." By the end of the week, everyone in their department had been fired, and they decided to send the equipment and all the manufacturing back to Berkeley, which is where most of it began. And,
so did you continue then working in the field in the 90s?
Actually, in the early 90s, I had a golden parachute with Business Records not to compete, and a non-compete clause which went for about 3.5 years. In 1996, I was asked by Ed O'Day, one of our past salesmen that I had known. We used to play guitar together and sing at the county clerks meetings and the supervisor of elections meetings here in Florida. And Ed says, "John, they're trying to kill punch card voting. you need to get back in the business, and you need to start making the crimp hinges and the masks. And while you're at it, can you help me with my voting booth? And I did, and we have. And first year and a half, we sold, I think it was 5 million crimp hinges and about 500,000 masks.
Are you still active in the business today? I think you said that primarily you're a rancher at this stage.
Primarily a rancher. We have one full-time employee in Napa, California, who basically builds the lamp assemblies for both ES&S and for Ed O'Day in his voting booths. And we do have the crimp hinges manufactured. The company's been making them for the last 20 years. And we do our mask blanking in our plant, so it's a small involvement.
Okay, now, with all your years in the industry, are you familiar with which kind of voting machines are in Dade, Broward, and Palm Beach counties?
I think I am, yes, I have seen them.
Which models are in Dade County?
Dade County has the 3P voting booth.
Is that the one with the plastic case?
Yes, that's why it's called P for plastic.
Is that the one that we saw up there yesterday?
No.
Which one was that?
That was actually, that was a late model 3A. I recognized it. That was my manufacturer out of our plant in Napa.
And the 3P was made by, was that CES who made the 3P?
Yes. As happens when anyone leaves an organization, other people have other ideas and they say, let's make it cheaper. And cost reduction was to make it out of a plastic case. And so they did.
And then in Broward, what kind of models are in Broward?
Broward has predominantly Model 3As.
That's the aluminum?
Yes, that was a 1981 or 1971 patent, I believe, 72, yes.
And was that the kind of machine that was up there in the stand yesterday?
That type, yes.
Are there any other kind of models that you know of in Broward?
They have various, they may have some Model 5s. I believe they do. I think I remember seeing those are some of our late model units they picked up used. I don't believe they purchased them new.
How about Palm Beach? What kind of models do they have?
Palm Beach has the 3As also, and I believe they have some Model 5s. And I know they have the Polestar, but I don't believe they have any 3Ps.
And even though you've not been involved in manufacturing the Polestar units, are you familiar with the Polestar unit through your years of work in the industry?
I am familiar with the new one somewhat. Some of the previous ones I really didn't get a chance to look at.
Do you understand that the Polestar units that are in Palm Beach in use were purchased in approximately 1995?
That's what I understand, yes.
And are you familiar with that unit?
I have seen it. I have voted on it, test voted on it, and that's about the extent of it.
I'd like to put up on the screen an illustration that we worked on, which is our Exhibit 513. And you can either turn back or to the screen, or you've got it in front of you. Would you please describe for the court what the various things are that are shown here in this illustration?
May I get up and
you guys?
Yes, very good. We have here actually it's an oversized stylus because this tip is only 50 thousandths diameter.
The tip is only what?
50 thousandths in diameter.
50 thousandths of what?
A round, that's the diameter.
Okay.
It's stainless steel. This is a rubber body style SBR rubber. Very flexible. These are your T-strips sitting, or pardon me, template sitting on top here.
The gray things show a cross-section of the plastic template?
Cross-section, usually with hash marks. You show that on a drawing, but anyway, that's your template, your template holes. Our guide section is not nearly that vertical, or I should say, angled. We have a very, very shallow guide, and the vertical portion of the template hole is very much straight up and down. That's to give.
John, can I ask you to step to the other side so the judge can see the diagram?
You betcha. Sorry. Anyway, that's your template, and then you have the ballot card underneath with your little breaks in here. Those are your CAD being outlined. These are your T strips, and we call them T strips because they actually are molded. A compounded rubber, which is molded.
I have to object to any testimony regarding any rubber aspects or the T-strips. I give the court a copy of his deposition on page 63. He was specifically asked about these issues, and he said, and I quote from line 8, "Well, we have quite a few rubber parts in the Votomatic, as you know, the flexible body stylus, the T-strips, but I don't consider myself an expert. I have to rely on chemists and also people such as 3M who do have good engineering staff. I assume that's why they had a chemical engineer here yesterday. Any testimony about the qualities of the rubber, the T-strips, which he said he was not an expert about, we would object to both as the fact that there is no foundation. He's acknowledged his lack of expertise, and also that it would be cumulative, Your Honor."
Overruled.
Go ahead, please.
I understand he's the man that you designed. This was your design?
Yes, sir.
And he's going to testify about his design, and I don't believe that I've heard any questions concerning his being asked about the properties of the rubber itself. He's merely said that these are rubber T-strips, and I assume we're going to find out at some point where he got them and what his specifications were for.
I very much appreciate the court's order. The only thing I'm talking about is the rubber aspects of any of the parts of the machine. We understand that he's going to testify about the mechanics.
At the appropriate time, you may have an objection.
Thank you, Your Honor.
Yes, sir. Go ahead.
These are the T-strips, as I was saying. They're T-shaped, rubber molded parts. And this is simulating the plastic part of the punch frame. You can see there's quite a distance between the T-strips and how far you go down here on the plastic. There's a crossbar at the bottom which joins these together. Then there is an open space below that, which gives you a substantial accumulation area for those T-strips, or for the chad to accumulate beneath them. In fact, in the Model 3A, there's a substantial area beneath those, if you don't mind my saying so. In fact, if you calculate it, there's 90 cubic inches plus of storage space in a Model 3A or 3P. If you calculate the width of the chad by the length, by the width, by the thickness, you have approximately 1.5 million pieces of chad that can be accumulated in a Model 3 vote recorder.
Okay, now let's just, with my illustration here, we've got here, take a look, the stylus is going to, let's see, comes down, you can see there, what's happening now in the machine that you designed?
This is the basic design is that the rubber actually holds the chad while the corner points are being broken. Okay? If there is a weakening of the rubber or wear in the rubber.
I just want to, we can get to this later. I want to just now talk about what happens in a normal voting process.
Normal voting process, this is what happens. The chad is broken loose because the rubber has held it there. And then as the voter pushes it in all the way down, the chad then goes between the rubber T-strips. You can see the rubber T-strips riding on the barrel of the stylus. And the chad then falls down to the bottom of the voting device, which can be almost an inch distance down
Okay,
below.
you can resume your seat now, please. In your work at IBM and in your work over the years in this industry, do you work with the actual ballots that are used in elections?
Yes.
And do you have to become familiar with the characteristics of the ballots in order to design the equipment that's going to be used when people cast their votes on those ballots?
At IBM, yes, you do. And at IBM, I actually did some of the design work on the ballot card itself and the location of it, et cetera. Change the specs.
Are the ballots susceptible to having imperfections appear on them through various ways?
There can be flaws in the paper. There can be nicks or dings in the manufacturing, if that's what you're referring to.
Well, once you get beyond the manufacturing, even if you assume that a ballot comes in perfectly pristine condition with no nicks or dings anywhere in it. Is the ballot itself of such a nature that it's easy or hard to make impressions and further nicks and dings in it?
There are basically two types of ballots. Yes. Okay. There are basically two types of ballots. We have the demonstrator ballot and we have the official ballots. And I think the testimony has been already that the demonstrators are made with the tools that get worn and gives you a higher burst test. And the official ballots have a lighter punch-out requirement because the tools are new and the blades are sharper. And so it is possible in rough handling, if they're not handled properly, you can get nicks and dings or fingerprints in the ballots, yes.
What kind of things now, and I don't want to limit you to dimples made by a stylist, but rather could you explain to the court what kind of things could happen in the normal handling of ballots by court personnel, not court, but election personnel, and the voter herself, and then further handling of the ballots? What kinds of things could come into contact with the ballots that could cause indentations and could cause a chad, for example, to be pushed out a little bit but not completely dislodged?
Well, as you know, the ballots are first received from the manufacturer in a cardboard container. And though it says right on those containers they must be stored in a type of environment which is cool, dry. You don't want to get them wet because they can expand and curl and warp. So they're stored properly. When you go to transfer them to the precinct, you need a transfer carrier or case if they're taken out of that carton, which usually they are, and put into a transfer case. That transfer case that you design has to have edges on it and padding inside of it so that the card is not damaged by the follower block, which is the typical type of steel slide, steel tray slide, which is put into those type of transfer cases. And then when it gets to the polling place, depending on what type of ballot you have, either a fold over or you have the short stub ballot with a ballot envelope. Normally that ballot is placed inside the envelope so it can't get handling damage by the voter or by the precinct officers.
Do you know which kind are used in Florida in these three counties?
They're using the fold-over ballot, which the fold-over ballot, the top stub folds over after it's used to hide the hide the write-ins on the top of the stub. And I do not know if they put that into an envelope. I don't believe they do. They take it out and then put it into the ballot box, as far as I know.
But in any event, before the voter puts the ballot in the machine, whether it originally comes in an envelope or not, is the voter then handling the ballot?
Yes, definitely the voter is handling the ballot.
And I suppose you've seen on television, as we all have, over the last few weeks, these illustrations of different kinds of imperfections that could appear on chads in a ballot, where sometimes they're sort of like pregnant or pushed out, but they're not detached in the corners, and the various variety of imperfections. Could those kinds of things be caused by handling of ballots?
Yes, they can. Some can.
How would that happen?
Well, as an example, in some precincts over the years when voting gets very heavy, they will issue the ballots to the voter, who then in turn stand in line, possibly for as much as 30 minutes or so, while they're waiting to get into the voting booth while another person votes. And while you're waiting in line, cards actually pick up the moisture off your hands, for one thing. And if they can pick up the moisture off your hands by handling them with your fingernails, your ring, or whatever, you can cause dents or dings in the ballot. This can happen.
How about after the votes have been cast and the ballots have been collected, and then they're further handled by the voting personnel in order to be put into the machines? Can further dings and nicks and imperfections occur then?
If you're referring to the ballot inspection boards or in the precinct where they actually sit there and count them, depending on how they're handled in the precinct, they tear off the stub, lay them on. If they don't tear off the stub properly, you end up with a big wad of card still sitting on the ballot card. In fact, it's thought that, I won't say it's thought, it's been, I've seen it happen before where people would tear off the stub and actually remove part of the card. Or in tearing off the stub, you're pushing down with your finger. This is in the precinct. When they're doing it, you're tearing off the stub, you can move or get your finger on the chad when you're doing that. So it has to be handled carefully so you do not disrupt the ballot, the chad in the ballot when you are tearing off the stub. And this is something that has to be done before they can be processed through the card readers.
Then once they get into the card readers, we've all heard about how the chads get dislodged, but sometimes do chads only get dislodged partway, like so that they're those hanging chads where there's two corners are still there, or even one corner, but the chad hasn't quite come loose?
Yes.
Do the folks who work for the election boards, before they put the ballots in to the machine to be counted, do they do anything to take off those hanging chads, or whatever the term is for these chads that are hanging by one or two corners?
Yes.
And when they are doing that, when they're manipulating the ballots, say in row 2, and pulling off the loose chads so they won't gum up the machine, is there the possibility that in that process they might touch a chad somewhere else that could leave an imperfection?
Yes, that is possible.
Now, does it sometimes happen that when the ballots are run through the counting machine, that notwithstanding all the work that the people have done, there are still some loose chads that sort of get in between ballots?
That can happen as well, yes.
And if the machine, if they happen to sit behind another chad in between the ballots, what effect, if any, would that have on the other ballots that they're next to?
If it's going through the card reader, which of course that's the way you normally count them, and if you have hanging chad on one card and you have open holes in another card next to it, and it's being roller fed and air separated, hopefully, that sometimes don't always air separate so well because of the fact that there's too many chad hanging in this card, it may be introduced into the hole in the card next to it. You can get damage, or you can actually have the chad from this card come off in the hole of the next card if it happens to be punched the same way. So,
could it also, if you have a hanging chad and you've got the ballots next to one another and they're pressed against one another, could the hanging chad from one that's kind of folded on top of that ballot cause an indentation in a chad on the ballot right next to it?
if you have 1,000 or so cards up in the hopper and they're all coming down, that would put a lot of weight on it. There's a possibility that that could happen.
Now, of course, is it also possible that somebody can make a dimple, for example, in a chad with the stylus that is used in the voting machine?
Yes.
Now, in your years of working with these cards, the actual ballots, and the voting machines, have you come to any conclusions about how likely it is that someone who's actually following the instructions and putting the ballot in like they're supposed to and attempting to vote would instead end up leaving a dimple instead of punching the chad through?
Objection, Your Honor. This is outside his expertise. He was designated as a mechanical engineer. He's now talking about psychological issues, clearly outside the scope of what he's been submitted to this court for.
I can ask this question. Go ahead, answer that question.
At IBM in 1966, we conducted extensive studies on human factors and how the voter rolls in. If he's right-handed, he tends to roll in, and because of the way the hand works, you tend to pull towards yourself. And as a result, templates get worn. They can, because you're rolling in. And sometimes people actually come over and they will set the stylus down basically in the hole. And what the voter doesn't know sometimes is that chad break point is can go as low as 150 grams. It's about 6 ounces. If he goes in and taps it, it's quite possible you can dimple the ballot and have no intention of actually voting. Conversely, the upper limit is 350 grams on your Chad burst strength. And you have to punch. It takes about almost 3/4 of a pound to punch down, which if you take the weight of your hand, it punches real easy. But if you just touch it, you haven't voted. And does that answer your question?
Yeah. Now, if somebody, for example, were to put the stylus through the hole next to Al Gore's name, and then they're making up their mind whether they want to carry through with that and actually vote for him, and then decide, you know what, I'm a Democrat, but I just don't like this guy, and they pull the stylus out, could that leave the kind of indentation you're talking about?
Depending on if he comes back and touches it hard enough, he may unknowingly have dimpled it. It's 1 or 2 ounces. It's that finite. It's a small amount of force that's required. Yes.
Now, we have these various ways that Chads can have imperfections that you talked about, including the dimples that could come from a stylus. If someone were so inclined, are there means by which you could figure out whether a particular imperfection and a particular Chad came from a stylus versus one of all these other causes that you've talked about?
Definitely.
How would somebody determine that an imperfection and a particular Chad came from a stylus versus one of these other possible causes?
Well, it's rather simple. If you're using a needle point stylus, you will actually see a needle point in the center of the Chad. And if you look at the Chad, it will look like the old-fashioned two-man tent. It actually creases right in the center, and you'll see the needle point going right through the center of the Chad.
And can you look at that with your naked eye, or do you have to do something else?
Preferably, it'd be much easier, especially for older people, to use a magnifying glass, a very strong magnifying glass, or a low-powered microscope.
And would you be looking not just at whether there was some form of impression or the Chad had been pushed out a little bit, but actually looking for a witness mark that you could match up with the stylus tip?
Yes, that does show, especially on the, in the serrated stylus, you don't have the needle point, but you will see, because the rubber is black, and you push on it with this 50,000 or 40 thousandths diameter tip at the bottom of the serrations. When it makes contact with the rubber, it does leave slight blackening right there. You can see this dimple in the Chad without breaking the Chad loose. And I've observed those and done tests with it, and it's also true of the absentee voting punch as well that is used. You push on it, you can actually see the little impression on the Chad.
Now, from your experience in the industry, we've been talking about how it's possible to leave an indentation with a stylus. From your experience in the industry, the fact that there is, let's say, a particular Chad that we're confident the imperfection did come from the stylus, does that mean that the person intended to vote but was unable to push that Chad through?
I seriously doubt that the voter would be unable to push the Chad through on a normal voting device.
Now let's talk about how it might be possible for somebody to attempt to vote and just not push the Chad through. Were you here the other day when one of the witnesses for Vice President Gore talked about how sometimes people will not follow the directions that your company prints up and they put on the back of the machine, and instead they'll put their ballot on the top of the unit? Does that sometimes happen in your experience?
If I may go back to my experience, in 1968, I don't know how many hundreds of precincts I actually observed in the Robert Kennedy election, but in Los Angeles, out of a whole precinct, we would have maybe 2 cards. And invariably, every other precinct, there'd be 2 cards that 2 voters had voted upon, that they had all hanging Chad.
Okay, now, let me just stop you there. You say they had all hanging Chad.
That's correct.
If somebody doesn't follow the directions and puts the ballot either on the top of the ballot folder or off to the side. Is there a pattern that shows up of chads that are not fully dislodged?
Very definitely. Normally, if the voter doesn't use the vote recorder, what normally happens is the pattern will be very definite that they've either hung most of the chad or they've either got dimples or they hang it. And so the whole card will be that way. And this is how they were in 1968, those cards we had there.
In your work with different voting officials in the different states, have you become familiar over the years with the regulations that are in place in order to evaluate whether an imperfection in a chad should be treated as a vote?
I am familiar with those, yes, not in every state.
Are you familiar with the California
Yes, sir.
regulations?
Very definitely.
I'm going to put up on the screen our Exhibit 52.
Sure. Your Honor, I presume he's given legal testimony of what the standard is in California. We're okay if he wants to talk about Texas as well.
They can put up
an objection?
Yes, Your Honor.
What is it?
Objection is calls for a legal statement from the witness.
Overruled.
Thank you.
He's testifying about his experience and what his knowledge is of the standards.
Is this the front page of the California standards?
It appears to be.
I'm going to skip over to the 29th page. And does this page contain information about the standards employed in California to ascertain voter intent according to these imperfect chads?
Yes, it does.
Where, you just tell me where on the screen and then I'll blow it up so everybody can see it.
Well, when voter marks his ballot by indentations, impressions for all races and measures.
So this is
it's number 2, yeah. Number 1, yeah.
Okay, we'll do it here. Oops. And what does this say here?
Voter marks his or her ballot by indentations, impressions for all races and measures, and there are no overvotes. It shall be counted.
And then, see if we can focus over under the notes column for that same indication.
It says voter intent can be determined.
Okay, so
duplicate the ballot, and then it goes in with the ballots to be counted by machine.
So this situation, do you understand that this situation deals with that hypothetical we were talking about before, where somebody doesn't put the ballot in the machine?
And that conflicts with another provision of this law, the provision that says there shall be, under certain circumstances, recounts. And then there's a rather detailed description of the process that's necessary. The timeline for when you can ask a recount is on the 6th day.
Up to.
Yeah, up to. And it would be impossible in a populous county to, in one day, do what the statute instructs must be done when there's a recount.
She makes a very strong point.
Well, you can ask for the recount right away after the election, and it's up to you to decide when to ask for that recount, and it's completely in the discretion of the county canvassing board as to whether to grant a recount or not. If you wait till the last minute and ask for something to be done that can't be done during the time available, and then they say no because there isn't enough time to do that, that's your responsibility. We have to have standards that guide us, and there are timetables and limits on which all of these things can be done. If you decide to throw a pass at the last minute and you don't have enough time to get your team on the field, that's your responsibility. We have to have an orderly process here, and everybody should want that, and we shouldn't be changing things after the fact to benefit one side or the other.
What will the Supreme Court do, and when will they do it?
If I knew that, I wouldn't be sitting here now. I'd be using those processes of prophecy to become a trillionaire. I don't know what they'll do. I suspect there's a good chance that they will say, you know, we didn't really need to take this case. There's no real federal urgency. And I suspect that whatever they do, they'll do it quite soon.
Monday, Tuesday?
Tuesday, Wednesday, Thursday, I don't know.
But this week?
I would be surprised if it was longer than this week.
What will they do and when?
Well, I'd like to answer that the same way. I certainly don't know. We did our best and put our arguments before the court, and they will decide. I'm rather encouraged that the Gore people would like the court not to decide the case. That gives me some comfort and encouragement. I think that they will decide the case, and I think it will be soon.
And you think it will be decisive?
Well, I think that the court will decide the case and give us a decision. I just don't want to predict what they're going to do, but I do think that they're going to give us a line of decision. The justices were very, very well prepared, as everybody in America knows. They're ready to decide the case on the merits.
Ted Olson, Larry Tribe, thank you very much. Thank you for representing your clients and sharing your information with the American people this morning.
Thank you, Tim.
And we'll be right back right after this.
CNBC Asia. Profit from it.
Have impugned a state Supreme Court the way you are doing in this case.
I would emphasize that what the Florida Supreme Court did is basically essentially say, we're rewriting the statute, we're changing it.
It seems to me that as a tiebreaker, as a way of shedding light on the provisions that are in conflict, so long as it's not done in a way that conflicts with a federal mandate, they're not violating any.
Mr. Tribe, I don't agree with that. I don't think that the Florida Supreme Court used the Florida Constitution as a tool of interpretation of the statute.
With us for the Bush campaign, Attorney Theodore Olson. For the Gore campaign, Attorney Lawrence Tribe. Olson and Tribe, the lawyers who argued before the Supreme Court on Friday, with us this morning.
But first, will the Republican-controlled Florida state legislature now be involved in this campaign on behalf of George W. Bush? Joining us, the Speaker of the House of Representatives of the state of Florida, Tom Feeney. Mr. Feeney, welcome.
Good morning, Tim. How are you today?
Good morning. Will there be a special session of the Florida legislature this week to appoint electors in the presidential race?
I can't guarantee that we'll begin this week, or actually can't guarantee we'll begin at all. I will tell you that the Florida House of Representatives has hired some of the best and brightest scholars in the country to advise us of our duties under Article 2, Section 1 of the Constitution. I've been reading the Federalist Papers, James Madison in Federalist 45, Hamilton in 68. The bottom line is I'm convinced we have a duty to act unless the U.S. Supreme Court resolves this matter with finality in the next few days.
If, in fact, the circuit court in Florida says that Al Gore should have a recount of those 10,000 non-votes in Miami-Dade County, and they show that Al Gore is ahead, would the legislature go forward and still appoint electors loyal to George W. Bush?
Well, again, I have a sister branch in this. We're relying on the Florida Senate. I think they've hired an expert that has advised them, the same as ours have, that they have a duty and obligation in this regard. The problem isn't who's ahead, and you said that we might get involved on behalf of George W. Bush. The real problem is our obligation is to the people of Florida to make sure that we don't get left out of the Electoral College process. And actually, Title III of the United States Code says that when you have this sort of chaos and you don't have a final determination of all the contests and controversies, or when you have a change in the law after the election day, that Congress could reject your electors and you may not participate. That's why Madison in Federalist 45 explained that the state legislatures must be prepared to be involved, and that's precisely what Article 2, Section 1 of the Constitution requires.
But if the Florida Supreme Court were to declare Al Gore the winner, would you go forward and have an alternate set of electors?
Well, I think at this point the only thing that could deter us from doing our constitutional duty would be if the United States Supreme Court renders a decision that brings finality to this. The bottom line is, Justice Scalia and others pointed out the other day, this is not a matter for the Florida Supreme Court to overturn the legislature, as in many cases it is in interpreting state law. Article 2, Section 1 gives this power, a plenary power, which means absolute and whole, and it can't be abrogated by another branch, to the Florida legislature, not to the state of Florida. So we have an obligation that cannot be interfered with either by the executive branch or the Florida Supreme Court. If you listen carefully to the argument on Friday, I think you found that this is an unusual situation, but it is the Constitution.
So it sounds like you'll listen to the U.S. Supreme Court, but not the Florida Supreme Court.
Well, on a matter that the U.S. Supreme Court may, and by the way, when we filed our amicus brief, we asked the U.S. Supreme Court to decide that this was not a justiciable issue for them. The Bush campaign asked for them to decide it was a justiciable issue. But we want the U.S. Supreme Court, if possible, to just acknowledge Article 2, Section 1 and say, in effect, the Florida legislature has been instructed by Title III of the United States Code and by the Constitution to resolve chaos like this, and we're going to rely on them to do it.
It sounds as if the Florida Senate, headed by John McKay, is a little less anxious, more reluctant to go forward than you are.
Well, I don't think any of us are excited about this. This is a hot potato that's been dumped in our lap by the United States Constitution. It's not, this is a duty that we absolutely believe we have. We've got some of the best advice in the country telling us this. Even Professor Tribe, Al Gore's #1 lawyer on Friday, when Justice O'Connor asked him to specify whether or not we could act, he said, I don't know. That's a pretty strong acknowledgement from the #1 lawyer for Vice President Gore. And the bottom line is the Florida Senate is being very deliberative. They're studying the recommendations of the Joint Committee, and I think they're acting prudently. We'll be prepared to act when they are.
Will this take the form of a legislative bill or a resolution? The difference being the governor would not have to sign a resolution, he would have to sign a bill.
The timing and the details of when and what we will do, what the Constitution requires us to do, have not been worked out. My own personal view is that this should be a resolution. If you believe, as Scalia implied the other day, and as I believe, and as all of our experts testified, that this power is plenary with the legislature, then you would use a resolution, because a bill may require the governor to either veto it or sign it. And so under the theory of our founding fathers, I think probably a resolution is the appropriate way to go.
If in fact the deadline is December 12th, how much time do you need to pass a resolution before December 12th?
Well, depending on whether you could get folks to waive the rules and act promptly, as short as 2 days, but my preference would be that we not wait until the end here. We could always stop a special session if the U.S. Supreme Court somehow resolves this. I believe that our duty will not change between now and December 12th. There are some 20 to 30 lawsuits now. There are all sorts of contests. The average contest in Florida takes 17 months to resolve. I'm afraid that not everybody in the Gore camp, but maybe some, would like to see Florida not participate on December 18th when the votes are cast. And I think we have a duty under the Constitution to make sure that Floridians are represented.
Well, Mr. Feeney, the 12th is a week from Tuesday, so you're going to have to act this week if you want to play a role.
Well, Tim, I'm prepared to go, and it's not because we're anxious to do it. It's because I believe that we're obligated to do it, and I'm prepared to go at any time.
Isn't, in fact, there a war between the Florida legislature and the Florida Supreme Court? They have declared unconstitutional the Governor Bush's school voucher program, a death penalty bill, parental notification for abortion for girls seeking, for parents for girls seeking abortion. There's been a lot of hostility between the legislature and the Supreme Court of Florida.
Well, but it's not personal hostility. Actually, Justice Wells, the Chief Justice, came and swore me in as Speaker of the Florida House. He's a friend. I count several of the justices as friends. I think there are some philosophical disagreements. You're always going to have a tug of war and a power struggle between the three branches of government. But none of this is personal, Tim. I do believe in this case, when they changed the statutory deadline for resolving the vote count, and when they told the Secretary that she may not exercise her discretion, that they changed the law. And the problem with that is that Title III, Section 5 says if you're going to have an election to pick your electors, you can't use law that was changed after the election. That's when mischief occurs. So we've got two problems. We've got a change in the law after the election that was imposed by the Supreme Court. We've got the fact that these contests could last for months or even years. Either one of those would be enough reason for the United States Congress to say, under Title III, Section 5, we don't have to let Floridians participate in the election. That's the constitutional issue that we have to deal with. with.
As you know, this is very controversial. You had a public hearing on this, and Reverend Richard Harris of Ball Glade, Florida, testified. I want to show a portion of that and give you a chance to respond.
If you sit here today and put in your personal agendas and your personal will and try to force that on the people of this great state of Florida, then you will be no better than the thieves that walk into a bank and rob that bank with a gun.
The Florida legislature trying to steal this election for Governor Bush is this strong insinuation.
Well, in the first place, the last thing we need at this hour are ad hominem or personal attacks. I would commend Reverend Harris to Federalist 45, authored by James Madison, who said that the legislatures must resolve these sorts of problems. And Federalist 68, where Alexander Hamilton said that in order to avoid tumult and crisis in selecting the president, that the state legislatures must be involved. The bottom line is we're not trying to steal any election. We are trying to preserve the election as it was conducted under the law that existed before the Florida Supreme Court changed it, and I think we have a duty to do that.
And you will act this week, probably.
Well, I'm prepared to act at any time. Again, I've got a sister branch in the legislature. We're a bicameral legislature, as most are. It's not unusual for the Florida House, just like the lower bodies of most chambers, to act a little bit quicker. We're sort of like the House of Commons. We're closest to the people. We're all elected every 2 years. So it's not unusual, and in this case, we're prepared to go a little bit sooner than our brethren in the Senate.
Speaker Tom Feeney, thanks very much. And with us now, the Republican vice presidential candidate, Dick Cheney. Welcome to Meet the Press.
Morning, Tim.
You just heard the Speaker of the House of the Florida Legislature. Would you encourage the legislature to go forward and select a slate of electors, pledge the George W. Bush, who would cast their votes for Governor Bush in case there's still legal turmoil in Florida?
Well, Tim, we clearly don't control the Florida legislature. I think is demonstrated by the fact that the brief they filed with the U.S. Supreme Court took a somewhat different tack than the one we took. They do have a constitutional obligation and responsibility that I think Speaker Feeney articulated very clearly. They've got to take whatever steps they think are appropriate in terms of carrying out those responsibilities. And I think they're doing that. But I'm not in a position to be able to predict what the final outcome is likely to be there, nor to say, you know, you should do A, B, C, or D. Those are decisions they'll have to make as independent actors in this drama that we're all part of.
He seemed to suggest that if the Florida Supreme Court declared Al Gore the winner, it wouldn't be relevant to his thinking that he would obey the U.S. Supreme Court, but that the Florida legislature is paramount to the Florida Supreme Court. What would that mean for the legitimacy of your administration if you won by electors cast by the Florida legislature rather than those approved by a Supreme Court of Florida?
Well, let's remember what's already happened here. There are electors that have been selected. There has been a count and a recount and a certification. The electoral process has been followed. The laws of Florida have been followed. The Supreme Court intervened, added 12 days to the period of time. We went through that whole process, and we still emerged as the certified winners of the Florida election. I don't see anything that's going to change that. Now, Al Gore has decided to go back in and use the courts to try to overturn this certified presidential election. First time that's ever happened in history. I see the legislature, in effect, saying, look, here we are nearly a month after the election. We still don't have a concession from Vice President Gore. The matter's still in the courts, being debated, and they could end up on December 12th having to act under their obligations and responsibilities under the U.S. Constitution.
But the U.S. Supreme Court could say that Al Gore is right. There should have been a manual recount. And the Circuit Court in Florida could say, count those 10,000 votes in Miami-Dade. And the judge in Seminole County could say those 15,000 absentee ballots shouldn't count because the applications were incorrect. And you would have a situation where the Florida Supreme Court will say Gore won, and the Florida legislature say, no, Bush won. And you have two sets of electors come to Washington.
Tim, I mean, you know, it could snow in Miami tomorrow, too. I mean, these are all hypotheticals. What we have to deal with are the facts. The facts are that we've been through this very long and involved process. We've followed the law, the statutes of the state of Florida, the Supreme Court of Florida. The whole electoral process has been followed very, very carefully here. And the conclusion is that George W. Bush won the Florida election. And we have been certified the winners. Now, Al Gore's back in court trying to overturn that. We're in arguing our side of the case. But to predict, you know, if this, then that, if we've learned anything in the last month, it is we ought to be very careful about making those kinds of predictions.
The Miami Herald front page story today, what if the vote were flawless? Without hanging chads, voter mishaps, Gore would have had edge. The Miami Herald calculates Gore would have won by 23,000 votes. if all those dimpled ballots and swinging chads were counted on his behalf. The thesis of the story that more people went to the polls in Florida with the intent of voting for Al Gore than the intent of voting for George Bush.
There's a process by which we cast ballots, count ballots, make decisions, and that process has gone forward. I have not seen the article, so I don't know what it argues, but the notion that somehow we had all of these people vote or intended to vote and their votes somehow didn't get registered, I just don't think it's valid, but it's being tested in court anyway. If we're going to go down that road, why don't we say, look, NBC and the other networks made an early call on election night, decided that Al Gore had carried Florida, and announced it before the polls closed. And thousands of Republicans in the panhandle of Florida who would have otherwise cast their votes for George W. Bush and myself stayed home because they've been told, well, I know that you guys announced the result before the polls even closed.
But can you prove that thousands of Republicans stayed home?
There's been statistical analysis that's just as valid as the statistical analysis in the Miami Herald this morning. What we have is we've had votes, they've been cast, there's a process for counting, a process for recounting, a process for certification. We've been through that process, and we now ought to get on with the business of putting together the new government.
Why not agree to a statewide hand recount overseen by former President Ford, former President Carter, so that once and for all you can get a clear, honest, statewide count, and people can say, and both campaigns agree to it, and then there's legitimacy to whoever wins.
Well, let's see, what are we going to do with the hanging chads, the dimpled chads, the intent devising, trying to devise? There are no clear standards for how that ought to be handled. If you go look at what happened in Broward County, there's a brief I just happened to read in the last day or two that we filed with respect to the Broward County recount, where they changed their standard after they started the counting process, where the 3 individual supervisors used different standards in terms of evaluating the so-called dimpled chads. It's virtually impossible to have an objective process for undertaking that kind of overall statewide recount. We think the right answer is that, in fact, the ballots have been counted and recounted, in some cases counted 3 and 4 times, and the results have been certified in accordance with Florida state law. Let's get on with it.
You think Al Gore's a sore loser?
I don't want to get personal about Al Gore. He's, I think I understand, I think all of us understand how difficult this is for him. With the enormous investment he'd made in the campaign, it would be hard for anybody to go through that process. I do think that it's time for him to concede. So far, he's chosen not to do that, to pursue other avenues, and clearly that's his prerogative. But I think long term, I think history would regard him in better light if he were to bring this to the close in the very near future.
3 times in our history, 1824 with John Quincy Adams, 1876 with Rutherford B. Hayes, 1888 with Benjamin Harrison. We've had presidents who lost the popular vote but won the Electoral College. All 3 were one-term presidents. And in fact, Rutherford Hayes was called his fraudulency because of the discussion, debate that went on post-election as to who should win the electors from Florida, ironically. How concerned are you that if you do win, that your presidency will never have a fair chance and it'll be destined, like the other 3 who lost the popular vote, to simply one term and a very ineffective 4 years?
Well, but I can recall some other presidents, Thomas Jefferson, who emerged from a very complicated, convoluted process, some 36 ballots, I believe, in the House of Representatives before the decision was finally made. That he'd won the presidency, an enormously successful president. So I think there's evidence on both sides, Tim. It'll be up to what we do with it. It'll be obviously a challenge in part to how well we govern, to our ability to build bridges to the opposition, whether or not the country will come together. I think the prognosis is pretty good because I don't believe the country is deeply divided. I think this is a time of relative peace and prosperity in America, that we should be able to pull together. We don't have the kinds of deep divisions that in times in the past, in centuries past, have been such an important part, if you will, of dividing the nation north and south over the slavery issue or other kinds of issues that have been historically very, very difficult for us to deal with as a nation. We are united as a people. We are the most powerful nation on earth. We've got phenomenal success for the last 200 years, and we can build on that and move forward. But it's going to be hard, difficult to do. But I think the notion that somehow it's doomed to difficulty, or that the next administration is bound to be only a one-term administration, I don't think that's a valid judgment. I don't think anybody can make that forecast.
Governor Bush, and you campaign on a platform of a $1.3 trillion tax cut. Now that the Senate is 50-50 Democrats, Republicans, and the Republicans control the House by 8 or 9 votes, won't you have to scale down your tax cut in order to pass it?
Well, I would think clearly you're going to have to work very hard with a 50-50 Senate. I could end up living on Capitol Hill as the vice president with a tie-breaking vote, president of the Senate. But circumstances have changed too. There's growing evidence out there, Tim, that the economy is slowing down. We're seeing in automobile sales. There's a lot of other areas, earnings falling off for corporations. And we may well be on the front edge of a recession here. And I would hope that would change people's calculations with respect to the wisdom of the kind of tax cut that Governor Bush has recommended. That we do, in fact, need to take into account those economic circumstances.
Do you think we're on the front edge of a recession?
I think so. Now, I'm not an economist. I just am following it enough to know and to see out there that there is growing evidence that the economy is slowing down. And I would think the kinds of tax changes we recommended, and that Governor Bush recommended, especially in terms of reducing marginal rates, for example, are in fact exactly what needs to be done with respect to providing the kind of stimulus to ensure the resumption of long-term economic growth.
But in reality, with a 50-50 Senate and a close, small majority in the House, you're going to have a moderate, mainstream, centrist governance, aren't you?
Oh, I think so.
Much more than the conservative principles that you adhere to, or Tom DeLay or Dick Armey. Are you going to be sitting on Tom DeLay and Dick Armey, trying to keep them in place?
They're both good friends of mine. I served with them in the Congress when I was the whip briefly in the House of Representatives. Tom was going to be my chief deputy whip. Dick Armey's been my congressman while I was in Texas for the last 5 years. Dick Gephardt's a good friend. I've known Dick. We came together to Congress about the same time. So it's entirely possible. I worked years ago, Tim, for the governor of Wisconsin under two circumstances. Under one circumstance, we had 2/3 control of the legislature. And the next session, it was 50-50. 50-50, we got a lot more done because there was much more discipline, because everybody had to work together. That was the only way anything was
And low expectations.
And low expectations. But I think there's no reason in the world why we can't do exactly what Governor Bush campaigned on, and that the very closeness of the ballots in the Congress will, in fact, be a spur to cooperation rather than a bar to it.
But true conservatives out there might be a little disappointed because in order to get someone on the Supreme Court, for example, they have to be confirmed by the Senate. You're going to have to stay to the center.
Well, I can assure my conservative friends that there'll be a strong conservative voice in the councils of the administration. But in the final analysis, Governor Bush will make those decisions. I think he's had an excellent track record in Texas. He's been very good at achieving worthy objectives by bringing people together, even when the other party controlled both houses of the legislature. And there's no reason in the world why we can't do that in Washington.
Trent Lott, the leader of the Republicans in the Senate, and Speaker Hassett were in Texas yesterday. Lott refers to Governor Bush as President-elect Bush. Should the country?
Well, we're getting close to that moment. The Governor Bush at this point still prefers Governor Bush, and that's the way we're referring to him, and that he's asked the staff to address him. We've not yet crossed the Rubicon, so to speak, to the point where we feel comfortable using the other title. By the way, did you notice the feather in Trent's hat yesterday?
Quite impressive.
Mississippi cowboy.
When will you make appointments to the cabinet? Secretary of State, Attorney General, Secretary of Defense?
As soon as possible. We've spent a lot of time. We spent 6 hours with General Powell this past week.
He's going to be Secretary of State.
Well, we haven't made any announcement yet, but he clearly is a man we're consulting with extensively on all of these issues. We spent a lot of time yesterday with Speaker Hastert and Leader Lott on a lot of the same questions. Governor Bush is spending a big chunk of his time on all these issues. We have not yet set a timetable in terms of an announcement. Right now, it has more to do with making decisions and getting people signed on and committed rather than anything else in terms of pacing the timing. But I would expect that certainly within the next couple of weeks, we'll be able to start making some announcements.
You'll have some well-known Democrats in the cabinet?
We are casting the net very broadly, and Governor Bush has given us directions to do exactly that, to look at, maybe he wants a cabinet that represents the best in America.
So blacks, women, Hispanics, all be represented?
Is diverse and in every sense of the word, politically and in terms of ethnic background and experience. Those are all valuable commodities and dimensions that he wants us to focus on, and that's exactly what we're doing.
Let me turn to your health. November 22nd, you had a heart attack, as you well know, better than I do. Governor Bush appeared on television at noon, and this is what he had to say.
Turns out that subsequent tests, blood tests, and the initial EKG showed that he had no heart attack.
Now, this is 2 hours after you had undergone surgery to open up an artery. people at the hospital, your doctors, knowing full well that you had a heart attack. Why would the governor tell the nation something wrong?
But let's remember, the governor's in Texas. When I went into the hospital that morning, walked in under my own steam, by the way, Tim. The heart attack label is appropriate in a technical sense, but as heart attacks go, it was not a big deal.
But a fourth heart attack's always of concern.
Always of concern, and that's why I went to the hospital. But the early test in terms of electrocardiogram, enzyme levels, and so forth showed no change. I talked to the governor on the telephone, and that's the information he had from me during the course of the day. After that, I then went in and undergo the angiogram, which is a decision we made after I talked to the governor. The doctors recommended it. We didn't know for sure whether there was a problem, but it was worth going to check out. It had been several years since I'd had the full-up angiogram. So we went in. We discovered while I was in there that there was, in fact, a narrowing in one of the branch arteries. That's when they went in and put the stent in. And I did not know at that time even that there'd been any change in the enzyme levels. And we were really focused on it because we're in the room doing the procedure. It wasn't until later that afternoon that I became aware, for example.
So you insist there was no intentional attempt to mislead the country?
Absolutely not. And we had sent the doctors out twice that afternoon to brief, to make sure that everybody understood what
the first time they said there wasn't any heart attack.
Well, that's what was the, they didn't say there was no heart attack. They said there's been an elevation in the enzyme levels, which is the technical term.
They came out at 4:45 to clarify.
So use the exact same words so nobody can say we misled anybody.
In July, when you were on this program, I talked to you about your bypass in 1988, and after which time you served effectively as Secretary of Defense, I might add. Right. And it's eerie, it's almost prescient, what you talked about. Let's just watch that for a second. Bypasses usually last 10 to 12 years. Will you be in need of another one soon?
Well, that used to be fairly standard guidance. If you can manage your disease properly, which is much more feasible today, then that either extends the time before you have to do it again or obviates it altogether. There are other options available, like stents, for example, that weren't around 10 years ago, where you go in and do a catheterization and insert a stent in the artery to keep it open. So there are a lot of possibilities like that. With luck, I'll never need anything else. But if I did at some point, one of those procedures is a possibility. But obviously, if I thought that was imminent, I wouldn't be here today.
You called it.
I said stent procedure was possible. I'm delighted the technology's there. What they were able to do for me is something that would have been almost impossible 10 years ago.
But you also said if I thought it was imminent, I wouldn't be here today. Right. It turned out to be imminent. Should you be here today as Vice President based on your health?
I'm here based on the strong recommendation of my doctors, first-rate cardiologist and internist who followed my case for years, who would never advise me to proceed as I am if there was any doubt about my capacity to do the job. My health is that of a 60-year-old, nearly 60-year-old man. I do have a history of coronary artery disease, but the angiogram, among other things, showed there'd been no progression in the artery disease over that last 12-year period of time, except for this one narrowing, which has now been repaired with a stent. So if anything, Tim, according to the doctors, I'm stronger and healthier now than I was 6 months ago because we've gone in and done that procedure. So I'm very comfortable with my current circumstances. The doctors have given me the green light to proceed. If I had any doubts about that, or if they expressed any doubts or reservations about my capacity to do the job, I would not do it.
You'd step aside?
Absolutely.
When will this all end? When do you believe that George W. Bush and Dick Cheney will be able to say, we are President and Vice President-elect?
Well, I think we're getting close. I would hope that it'll get resolved within the next few days. December 12th is a date that a lot of people have focused on. I think hopefully it'll be over and wrapped up by then. I would hope it would happen sooner. We really, from the standpoint of transition, a lot of people do not understand we're down to only about 6 weeks left. It is very hard to put together a complete government for the United States, tougher than it's ever been because of the complexity of issues and clearance procedures required. We really, really need to get on with that as quickly as possible. And we are, I think, rapidly approaching the point where there will be damage to the nation, at least to the capacity of the next government to function, if we don't get this resolved shortly.
You've been extremely visible, leading some to suggest that Dick Cheney, in fact, is de facto president. and George W. Bush is simply in the wings and that you're going to be running the government?
Well, you know, the same people that are saying that are the ones that criticized him when he picked me last summer because I wasn't from a big state or I wasn't going to help him in terms of the Electoral College. Now people saying nice things about me, they turn around, they don't give him credit. He deserves the credit for the fact that I'm here. He's very heavily involved in all of this. We talk several times a day on the telephone. I think he's going to be a very effective executive because he grabs people, puts them on a problem, gives them their head and says, go solve it, and then holds you accountable for your performance. It's the way I like to work. And if it's working well, he's the one who deserves the credit. He's the candidate. He's the man who put together a very successful national campaign strategy. He's I think, about to become the president-elect of the United States. And to the extent that we've had any success at all, George W. Bush deserves a lot more credit than I do.
You've introduced 2 words to the American political lexicon: big time.
Right.
Any comment?
No comment, Tim.
Dick Cheney, we thank you for joining us. And the next time you'll be back, you'll be Dick Cheney or Mr. Vice President.
I hope so.
Good to see you.
Thank you.
Coming next, The View from the Gore Campaign with the Democratic leader of the House of Representatives, Dick Gebhardt. Then, the 2 lawyers who appeared before the U.S. Supreme Court on Friday. For the Bush campaign, attorney Theodore Olson. For the Gore campaign, attorney Lawrence Tribe. They are all coming up right here, a special edition of Meet the Press.
Meet the Press is sponsored by Morgan Stanley Dean Witter. Move your money. Get well connected.
CNBC Asia. Profit from it.
With business threats and possibilities just around the corner, the new Nokia 6210 with WAP makes you ready to hit your targets.
In many countries, on many projects, with many communities, Chevron has made a commitment to be a global energy partner that keeps its promises, that keeps its word. Chevron, the symbol of partnership.
The next generation of wireless communication is here, and technologies from Agilent are helping make it all possible. We've taken the fiction out of science fiction. Agilent Technologies, dreams made real.
Meet the corporate gurus from all over the world on Money World.
It's a great era for Asia as we move out of the old world economy.
Find out what's redefining the new economy.
The age we live in is really, in many ways, defined by information.
What's shaping new business models?
Times are changing. Big in this world is better.
What are the new ways of creating wealth?
It's nothing.
Sunday, only on CNBC Asia.
Swap Box is now bigger and packed with even more market talk.
Bringing you the latest market news.
The auto sector, that's one to watch out for.
China-backed software maker.
Stocks to watch.
It's kind of floundering.
Guest analysis.
What sort of hike are we talking about?
We only expect 25 basis points.
Easing the restrictions on dual listings.
We're very, very bullish about our numbers in Asia.
So be sure to profit from the extended Squawk Box weekday mornings only on CNBC Asia.
And we're back. With us now, the Democratic leader in the House of Representatives, Dick Gebhardt. Welcome.
Good to be here.
A clear majority of the American people now say that Al Gore should concede. Why won't he?
Because a majority also say that they want an accurate vote. Everybody's interested in getting this over with. I don't know of anyone, I haven't talked to anyone that doesn't want this behind us. But I think the American people clearly want to get the accurate result. They want all the votes counted. They want to know who won. Al Gore won the national popular vote by over 300,000 votes. There's really about a 100-vote margin left in Florida, and if the Miami-Dade ballots would be counted, if the court decides to count them, we're going to find out who actually won this election. And I think everybody wants to know that.
The Vice President himself has said it's not the popular vote nationally, it's the Electoral College that counts according to our Constitution.
Sure.
In terms of Florida, the Gore campaign wants to count the 10,000 no votes, if you will, in Miami-Dade, but there were 175,000 of those non-votes in the state of Florida. In 8 counties, a higher percentage than there were in Miami-Dade, but those are Republican counties. In all fairness, if you count those 10,000, why wouldn't you count all 175,000 in Florida, or for that matter, all 1.5 million across the country? For example, in Oregon, Al Gore won by 6,000. There were 30,000 non-votes for president. In New Mexico, he won by 400. There were 6,000 non-votes for president. New Hampshire, Bush won by 7,000 votes. There were 10,000 non-votes. Why not count all the non-votes in Florida and across the country?
Well, Tim, from the beginning, Al Gore asked the Bush campaign to agree to have a total hand recount of the state of Florida. It's interesting, right now the Republicans are asking for a hand recount in New Mexico. So it is clear that that should have been done from the outset. Al Gore offered that 3 times. The Supreme Court of Florida asked the Bush campaign if they didn't want a total recount, hand recount of the state of Florida. So clearly that could have been done. It still could be done. It may be the best way to resolve it. But right now you're in a legal process, you're in a contest, and so what's at issue is Miami-Dade and Palm Beach, and that's what the Gore campaign is asking to be recounted. But I think they'd be happy to recount the whole state.
If the Supreme Court of the United States says, Al Gore, George Bush is right, there should be no recount, or if the Circuit Court in Florida says no recount of Miami-Dade, should Al Gore then concede?
Well, Tim, that's an iffy question. We don't know what the Supreme Court of the United States is going to say. That'll probably come this next week. We don't know what the decision of the Circuit Court in Florida will be. That will probably be appealed to the Supreme Court of Florida no matter who wins in the Circuit Court. So there's a million hypotheticals out there. I don't want to give an indication of what the Gore campaign might or might not do. Look, this is real simple. We need to find out who won. You know, it would be terrible a month from now, after this is all over, if Gore is not the winner, not declared the winner. Somebody's going to go back and recount these ballots and look under the Freedom of Information Act and look and see who actually won. Would we want to wake up a month from now and have the national popular winner and the actual winner in Florida not be the President of the United States?
If, in fact, the Florida Supreme Court allows the recount of Miami-Dade alone, and they say Al Gore's won the election, and the Florida legislature said, no, 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 George W. Bush was certified, and there are 2 sets of electors that come to Washington. The House of Representatives has to decide which set to accept. The Republicans control the House. They'll probably say Bush. The Senate would say Gore, because it's 50-50 with Gore casting the deciding vote. But the Bush electors would be seated because they'd be certified by the governor of their state. What would that mean to the legitimacy of a Bush administration?
Well, I hope that doesn't happen. I really think all of us have to work together, Republicans and Democrats, people in the Congress, people in the Florida state legislature, and then the judicial branch in Florida and the country, to see that we get a legitimate result that both parties can accept and that the country can accept. I feel very strongly about that. This is a test for our country. We don't always have a close presidential election like this. This is such a case. Our electoral process was probably not up to this in parts of Florida and probably other parts of the country. We got to improve that. But in the meantime, we have what we have, and we've got to work together to see that the process, the rule of law is served, and we get to a winner that everybody can accept.
Mr. Cheney said he thinks a recession's coming on, and all the more reason for a big tax cut. 1, do you think we're near a recession? And 2, will a $1.3 trillion Bush tax cut pass the Congress if Bush is the president?
Well, I don't think we are in a recession. I hope we're not. I don't think we are. I think things have slowed down a little. I think they needed to slow down a little. I think we've gotten a little too far too fast. But the productivity figures are still good. The growth figures are still reasonable in the 2% plus range. I do think we need a tax cut. We fought over that in the last 2 years. I think whoever's president, we're going to have a tax cut. I hope it's not a huge one that I think would overdo it and get back to overheating the economy. But I think we definitely need a tax cut for middle-income Americans and people that have really had the worst time, even in this recovery.
$1.3 trillion?
Well, we see it more in the area of $200 to $500 million. But we're going to have to compromise.
$1 billion.
$1 billion. And we're going to have to compromise and come to something that'll work. But I'm confident that we can do that and make sense and do the right thing for the economy and the people.
Secretary Cheney seemed to suggest that it would be a mainstream centrist government if Bush Cheney were elected because of the close margins in both houses. Do you agree with that?
Well, Tim, I think that's the only way you're going to get things done. Let's look at the last 2 years. In the House and in the Senate, we passed campaign reform with bipartisan majorities. We passed a Patient's Bill of Rights, Medicare prescription drugs. We passed a minimum wage increase. There are a lot of things that we could do if Democrats and Republicans will come to the middle, meet, and work together to get these things done. Whoever is president, that's the prescription for getting a lot done that the American people want done.
Governor Bush is talking to 3 or 4 Democratic congressmen he may appoint to his administrations in districts where if they vacated their seat, they'd probably be won by Republicans. Is that a problem for you?
Well, he's got to, if he's president, or if Al Gore's president, they've got to put together a cabinet, and I think it would help either of them if they put some from the other side or some who are more moderate in their cabinet. And I think both of them will
even members of your
that.
caucus?
Absolutely. And members of the Senate or people that have been in the House or the Senate in the past.
If Al Gore loses this election, is he the Democratic frontrunner in 2004?
I would think so, but I think he's going to be president now in the year 2000.
Don't you have a better chance of being Speaker in 2002, running a midterm election with a President Bush than a President Gore?
I don't really buy that. I hear that, but I don't think it's true. I don't think politics works that way anymore. I think we're in a world where voters are very discerning, very independent, and they don't vote for people for Congress depending on who's president or who's not president. I think you win House seats the old-fashioned way with good candidates and run good campaigns.
When do you think this presidential race will be over?
I suspect it'll be over sometime in the middle of December.
Within the next week to 10 days?
It well could, but we don't know. We're in new territory. We've never seen this in our time before. So we're going to have to be patient and let the process, this great thing we have in our country called the rule of law, decide this and do it in a way that we keep everybody together and moving in the right direction.
House Democratic Leader Dick Gephardt, thanks for joining us.
Thank you.
Coming next, the legal argument, our guest, the 2 lawyers who stood before the Supreme Court on Friday. Ted Olson for the Bush campaign, Lawrence Tribe for the Gore campaign. They are here together on Meet the Press, and they're coming up.
CNBC Asia. Profit from it.
Are you trading with a whole world of buyers and sellers and getting the best possible price? No question. You have a broker whose only goal is to help you get the best performance. Around the world, around the clock. Instinet. Nothing comes between you and the best price.
Philips brings you Smart Money Minutes.
Looking for an investment in one of these dazzling baubles? The truth is, not all diamonds are created equal. So what's a good buy?
Basically, it's the 4 C's that you look into. Carat weight, it's the first C in the weight of the diamond. The color, clarity, and cut.
When it comes to diamonds, size definitely matters. Clarity is how clean a diamond is. When it comes to color, the most prized color is no color at all. That's because colorless diamonds are extremely rare. And finally, cut. A well-cut diamond reflects light better, hence the brilliance and shine that diamonds are cherished for.
Phillips and Smart Money Minutes, making your life better.
Got to admit, it's getting better, a little better all the time.
TV from Philips. A new way to look at television.
Bulls or bears? Profit or loss? Where's the market heading? Who are the major corporate movers and shakers? Get your wrap-up of the day's trading on Asia Market Wrap.
Japan hitting their lowest.
Analysis and insight from industry experts.
Some funds will be unlocked.
Invest.
Keep ahead with Asia Market Wrap and stay out of the red. Weekdays on CNBC Asia. Brought to you by SGI and the Citibank Private Bank.
We are back. Ted Olson, you were the lawyer for George W. Bush. You went before the Supreme Court. We have 6 million jurors watching you right now this morning. Tell them why you believe that the Florida Supreme Court did not act appropriately.
What we feel the Florida Supreme Court did is change the rules of the contest, the counting of votes and the tabulation of who was the winner and how the disputes would be resolved after the election. There's a reason why we set the rules before the game, because those will be neutral, they'll be based upon neutral principles, they will be objective, and the standards will be equal for either candidate. When you start changing the dimensions of the process after the game, you tilt it towards one side or the other. We all want to play the contest or count the votes according to the rules that were set ahead of time. And the Florida Supreme Court changed that.
Justice John Paul Stevens asked you an interesting question during this exchange. Let me roll that for you and give you a chance to respond.
One of the things that's of interest to me is the extent to which you say there was a change in the law. It seems to me that in order to answer that question, you have to know what your view of the law was before this all happened.
I think that we can answer that this way, is that whether it was shall ignore or may ignore, it was not must accept.
Under any circumstance, it was not must.
Under no circumstances was it must accept. Now the second...
Even an act of God or fraud?
I don't believe so.
The justice honing in saying, well, if in fact there was an act of God that prevented these votes being certified or delivered to the Secretary of State by November 14th, wouldn't they be allowed an exception? And you hung tough and said no.
Well, no, we said that the Secretary of State down there, who is vested with the authority by the legislature to decide what are the appropriate circumstances when there might be an extension of the deadline, would have the duty to look at that. There's all kinds of acts of God, which, by the way, were not involved here. The legislature set up a very clear set of timetables for how these things could be done. When you change those timetables, you have the chaos that we've been seeing playing out in Florida, 40-some lawsuits.
So the Secretary of State could exercise her discretion, but the Florida Supreme Court cannot change the deadline.
Well, the Florida Supreme Court cannot change the rules after the game. The legislature very, very clearly said there has to be someone that can make some judgments during the course of the process within very limited circumstances, and those rules just should not be changed afterwards.
Lawrence Tribe, you represent Vice President Gore. You said the Florida Supreme Court did not legislate, did not change the rules, but were merely trying to interpret, if you will, or reconcile statutes that may be in conflict. Explain.
Well, even more than that, Tim, the fact is the game is over. It ended November 7, people voted. We just haven't been able yet to figure out exactly who got more votes. And all that the Florida Supreme Court did was to say that whether it's an act of God or our own laws that authorize recounts in very close elections, when we're trying to figure out the meaning of this photo finish, it's okay to add 12 days to the process by which you continue the recount. And that was a very minor adjustment in laws that were internally in conflict, because on the one hand, whether the Secretary must accept or may accept these ballots, there was another provision that said very clearly that it's permissible to recount in certain circumstances. And the Supreme Court of Florida pointed out that would have been meaningless if you didn't add a little time. And in fact, if you look at the larger picture, whether 12 days were added or not, under the law that existed before November 7th, these contests that are now going on to contest the election because of some uncounted ballots would continue. And so it's really a question of whether those uncounted ballots get drawn in prior to the certification of the election through a recount process or afterwards through a challenge. And the Florida Constitution is certainly flexible enough for that.
Ironically, because the Supreme Court extended the deadline for filing the votes, if you will, they shrunk the contest period, which Al Gore is now having a very frustrating time because he wants to get the votes counted, as you said, but he doesn't have enough time to make his case, and the Bush people very effectively are saying, we want due process too. We can't rush this.
Well, exactly. Then the fact is that the total amount of time hasn't been added, hasn't been expanded for anybody. And one thing that's especially intriguing here is that the background law in Florida says the right to vote is important. And what was interesting in the argument is several justices seem to suggest that it was impermissible for the Supreme Court of Florida to pay attention to the right to vote because of an 1892 decision of the Supreme Court, which, if you read it carefully on page 39, says that the right to vote, in fact, can be derived from the state constitution. We shouldn't sacrifice the right to vote in order to adjust the deadlines back.
I found it quite interesting in the exchange when Ruth Bader Ginsburg asked you a question and you said, I'm not sure. I want to play that for you and give you a chance to talk about it.
Well, could the state legislature at least now say, in light of all this confusion, we enact a law today saying this is the way electors will be selected?
Well,
is that open to the legislature now?
I'm not sure.
Are you sure now?
I'm no more sure now. And the reason is that federal law seems to say that once the electoral choice has been made, it can't be unmade by a state legislature. On the other hand, there are people who think that aspect of the federal law is unconstitutional. If I had to tell you what my personal view is, it is that although the legislature can come in when the people have not made a choice, it cannot come in to rewrite their choice.
Mr. Olson, Ruth Bader Ginsburg also asked you a question talking about the conflicting statutes, if you will, and she says that if the recount can be asked for up to 6 days after the election, but the votes have to be certified 7 days after the election, it only leaves 1 day. Let's just listen and have you talk about that.
Mr. Olson, may I ask you, because you've been skipping over what I thought was a key piece of the Florida legislation. The Florida Supreme Court said there's the deadline, and that conflicts with another provision of this law, the provision that says there shall be, under certain circumstances, recounts. And then there's a rather detailed description of the process that's necessary. The timeline for when you can ask a recount is on the 6th day.
Up to.
Yeah, up to. And it would be impossible in a populous county to, in 1 day, do what the statute instructs must be done when there's a recount.
She makes a very strong point.
Well, you can ask for the recount right away after the election, and it's up to you to decide when to ask for that recount, and it's completely in the discretion of the county canvassing board as to whether to grant a recount or not. If you wait till the last minute and ask for something to be done that can't be done during the time available, and then they say no because there isn't enough time to do that, that's your responsibility. We have to have standards that guide us, and there are timetables and limits on which all of these things can be done. If you decide to throw a pass at the last minute and you don't have enough time to get your team on the field, that's your responsibility. We have to have an orderly process here, and everybody should want that. And we shouldn't be changing things after the fact to benefit one side or the other.
What will the Supreme Court do, and when will they do it?
If I knew that, I wouldn't be sitting here now. I'd be using those processes of prophecy to become a trillionaire. I don't know what they'll do. I suspect there's a good chance that they will say, you know, we didn't really need to take this case. There's no real federal urgency. And I suspect that whatever they do, they'll do it quite soon.
Monday, Tuesday?
Tuesday, Wednesday, Thursday, I don't know.
But this week?
I would be surprised if it was longer than this week.
What will they do and when?
Well, I'd like to answer that the same way. I certainly don't know. We did our best and put our arguments before the court, and they will decide. I'm rather encouraged that the Gore people would like the court not to decide the case. That gives me some comfort and encouragement. I think that they will decide the case, and I think it will be soon.
And you think it will be decisive?
Well, I think that the court will decide the case and give us a decision. I just don't want to predict what they're going to do, but I do think that they're going to give us a line of decision. The justices were very, very well prepared, as everybody in America knows. They're ready to decide the case on the merits.
Ted Olson, Larry Tribe, thank you very much. Thank you for representing your clients and sharing your information with the American people this morning.
Thank you, Tim.
And we'll be right back right after this.
CNBC Asia. Profit from it.
The next generation of wireless communication is here, and technologies from Agilent are helping make it all possible. We've taken the fiction out of science fiction. Agilent Technologies, dreams made real.
China, the Taiwanese are among the country's top foreign investors. More than 40,000 businesses have invested at least $30 billion US. For them, rising cross-strait tensions are a genuine concern.
Gil Galton, CNBC Asia, Beijing.
We promise no program misses. With CNBC Asia's program schedule, you'll not only be up to date on our programs, you'll be aware of all airing times with our schedule reminder. This way, you'll never miss your favorite show. www.cnbcasia.com. Keeping you informed, keeping you ahead.
Today only on CNBC Asia.
Brought to you by Nokia, connecting people.
Coming up on Dateline tonight.
Thanks, Tim. It's an ugly fact. Some taxi drivers refuse to pick up people of color. Wait till you see what happened when we sent our cameras out to grab a cab. The story tonight at 8/7 Central on Dateline. Tim?
Thank you, Stone. Start your day tomorrow and Today with Katie and Matt, then the NBC Nightly News with Tom Brokaw. Stay with NBC News and MSNBC for continuing coverage of Decision 2000 all week. That's all for today. We'll be back next week. If it's Sunday, it's Meet the Press, Go Bills, beat the Dolphins without a recount. Go get it.
Cecilia Zecca, only on CNBC Asia.
Faster, more reliable, higher quality, more profitable. Nortel Networks is building the new high-performance internet, and it can be whatever you want it to be. So tell us, what do you want the internet to be?
Come together right now over me.
Believe it or not, this is your lucky day. The day your hospital got its revolutionary new GE Lightspeed scanner. In an emergency, when every second counts, the GE Lightspeed is the fastest diagnostic scanner in the world. Yesterday, it would have taken radiologists 20 minutes or longer to scan your injuries. Today, the GE Lightspeed can scan your body in just over 30 seconds. What's more, it produces incredibly detailed images that are more helpful than ever before.
Joe, why don't you take 3 deep breaths, right? We're going to take real good care of it.
GE Lightspeed.
How are you feeling?
Does your hospital have one?
Meet the Press has been sponsored by the Archer Daniels Midland Company. ADM, supermarket to the world.
Newspaper.
Okay, now we're coming to the meeting on Friday, the day after Thanksgiving. Was anybody there?
Yes, sir. People from out of state were there.
From out of state?
South Carolina, Georgia.
How many people were there?
Somewhere in the neighborhood of 50, I'm assuming.
Was it
a very small area?
Was it in any way a contentious or was it a contentious meeting?
I'm not sure I understand what you mean.
Well, was there, did people get hot? Were people arguing and fighting and, you know, the kind of thing that...
I feel like I was the only one that got hot.
Was it a peaceful meeting?
There was very peaceful, and I had people there with signs support Mrs. King.
Now, at your meeting that you had the day after Thanksgiving, did you vote to amend the November 8th certification?
Repeat, please.
At the meeting you had the day after Thanksgiving, did you vote to amend the November 8th certification of the machine recount?
Yes, sir.
What was the vote, please, Ms. King?
3-0.
And what count did you vote to send up to the Secretary of State in your amendment?
The vote of November the 7th, 2,387.
Now, by the way, this 218 votes, those aren't Bush votes or Gore votes. Those are just a total difference in ballots, right?
Yes, sir.
Now, when you voted 3-0 to amend, well, why did you vote to amend the certification and send up the original November 7th machine count? Why'd you do that? Right.
Because I had lost 218 votes in Nassau County, and I wanted them counted. I wanted every vote to count.
But quite a few people have been saying that, every vote.
Right, and I have been sleeping on the couch saying I want my vote to count too.
Did anybody at the meeting stand up and object to your 3-0 vote to amend your certificate to include the original count of 25,387 presidential ballots?
Yes, sir. Excuse me. I believe, if my memory serves me correctly, John Cascone.
Who's he, please?
I think he's the attorney for the Democratic Party.
Did he give a speech or talk?
He spoke to us about what he thought we had done incorrectly.
Did you give him all the time he wanted to address you? Yes. That's all I have. Pass the witness, Your Honor.
All right. Mr. Clark?
No questions, Your Honor.
All right. Mr. Douglas?
Ms. King, I'm Dexter Douglas, and I represent Vice President Gore and Senator Lieberman.
I'll shut this down here. So.
I'll leave it up there. Okay. I'm going to ask you.
Want me to run it for you?
Yeah, you'll have to, because I can't.
It's a distinct honor, Your Honor, to operate the equipment for a distinguished lawyer like Mr. Douglas.
I'll tell you, having you as an assistant gives me some pause.
You certainly increased your stature immeasurably. So
all right, we'll save a little time. Ms. King, you're familiar with the fact that Nassau County has filed a stipulated statement of pertinent facts in this case.
That's
Mr. Mullen went over that with you, didn't he?
Yes, sir.
And that's presented to the court as the facts, as bare bones facts of what happened in this case, correct?
Your Honor, I don't think the witness ought to be asked to characterize a legal stipulation.
Well, we're going to ask some questions.
Well, just ask her if did her attorney consult her and furnish her a copy of this stipulation before it was signed by counsel?
That's correct, isn't it, Ms. King?
Did you hear me, Ms. King?
I'm not sure that I understand.
Did your attorney go over and show you this stipulation of facts prior to the time that he signed this stipulation?
If you're talking about what I think you are, yes.
Let me show you. This is called stipulation of facts.
Yes.
All right.
Thank you.
I'm
sorry.
Overrule the objection.
And some of the things, most of the things that you're talking about are covered in that stipulation, are they not?
Yes.
For example, as I understand the factual events as they occurred that we're discussing, on November the 7th, 2000, Election Day, that night you got the vote, which you've testified to.
Yes.
And that was an unofficial return. At least at that time.
At that time, yes.
And then you were required, as you understand it, to do an automatic recount because of the closeness of the race statewide.
That's correct.
And on November the 8th, that automatic recount was done.
Yes.
And that amount of votes that was determined by the automatic recount was then certified to the Secretary of State or to the canvassing commission as the correct vote from Nassau County. Is that correct?
That's correct.
And then after how many, let's see, you got this letter, which was not you didn't have a protest, did you? Statutory protest.
No,
you didn't
sir.
have a statutory contest until we filed it, right?
That's correct.
And the letter that you got from Mr. Wood, who was the Republican person, was mailed on the 22nd of November. I presume you got it on the 23rd?
It was handed to me across the counter in my office.
On the 22nd. And the meeting that you called was the 24th?
Yes, sir.
And the 23rd was Thanksgiving.
Yes, sir.
So you got that letter hand-delivered in the morning, and then you proceeded to give notice of a meeting on what time? Friday after Thanksgiving. Remember what time of day it was?
When did I start on Thanksgiving Day?
No. I don't want to ask you what you did on Thanksgiving Day. What I want to ask you is, what was the date, time of the meeting on the 24th that was noticed?
The meeting was held at 8:30 in the morning, the day after Thanksgiving.
And the notice was given on the day before Thanksgiving. Is that right?
There was more than 24 hours from the time that I posted the notice, and I also contacted the news media. And when the paper came out the morning of Thanksgiving, there was 24 hours until the time of our meeting.
Was the paper published on Thanksgiving morning in Nassau County?
Yes, sir.
The News Leader?
Not the News Leader, no.
Which paper?
The Jacksonville Times-Union.
And the notice that's attached to the stipulation says the notice was given to the, it doesn't say it was given to the Times-Union.
We also gave it to the News Leader. It was in, I know it was in the Jacksonville Times-Union.
Okay. And the Times-Union, of course, is the Florida Times-Union is published as Jacksonville paper. It's published in Duval County.
That's correct. And it's delivered to the front door of almost every citizen in Nassau County.
Well, you can get it here if you live in town.
Right.
So we have those dates straight. There was never a protest and never a contest until after what you call the certification, the last certification, which was sent to the Secretary of State's office or to the canvassing board, which would have been on the 26th. Is that right? Sunday?
No, it wasn't sent out on a Sunday. The certification.
We're wrong. Maybe I've confused you. You had one certification. That's all you ever had at that point, before we get to Thanksgiving now. You had one certification, official certification, that you sent to the canvassing board, and it was reported as the vote in Nassau County. That was after the machine recount on the 8th.
I sent a certification to the Division of Elections on the morning of the 8th after it had been faxed to the Division of Elections.
Okay, you sent a certification, didn't you, in accordance with the law?
Yes, sir.
To them on the 8th that certified the vote that had resulted from the automatic recount. Is that right?
On the 8th, about 8:30 at night, we faxed to the Division of Elections the automatic recount.
Okay.
The next morning, it was also overnight to Tallahassee and should be there by 10:30.
On the 9th?
Yes.
And that was the certification required by law and the statute, which you made.
That's correct.
And then that was the vote officially until you had this meeting November the 24th. Is that correct?
It was the wrong count for Nassau County.
That's not my question. There was no recount, no other recount than the machine recount that was required by law. Isn't that correct?
A recount that's required by law that was done on the 8th.
That's the only recount that's ever been done.
That's correct.
And so when the time for certification of the absentee ballots came, the set time for that.
The overseas 10-day ballots.
Correct. You didn't certify that then either, did you, on that date? That was a week after the certification you sent in the first instance.
The certification of the absentee ballots overseas were certified immediately.
Right, one vote. Is that right?
We had 8 overseas ballots in Nassau County.
Okay. And you certified how many on the required date for certification of the overseas ballots?
There was 7 that was actually counted, accepted. There was 1 that was rejected because of the postage.
Now, when you still are going along with the vote, even after you reported these 7, in the same ratio as they were in what you had certified on the 9th, is that right?
I'm not real sure, because as soon as I realized that I wasn't going to get an automatic recount, I immediately notified the Division of Elections that I had a correct and an incorrect tabulation.
Do you remember when you called them?
No, sir, I really don't.
Was it around the 20th?
I do not know.
You have no idea?
No, sir, I don't.
How long before the meeting, the last meeting?
I have been constantly trying to get this mistake that I have made straightened out ever since the morning of the 9th. And I have done many things, calling the Secretary of the State, everyone I could think of, to correct this.
And nobody told you that you needed to have a recount or you had a protest or any of those things before you could do that?
Absolutely, no one.
No one, not anybody, the Secretary of State or anybody?
No one.
So you're going along there sort of, kind of feel sorry for you. You're relying on those people.
I was asking for guidance,
Correct.
And I did not receive it.
And when you finally did get the guidance and you went ahead to set this meeting very quickly, it was down toward the time
I
it
had to
be
have
set.
a 24-hour notice.
Right, but it was, I mean, the decision and everything to do it was very quickly because just 24 hours over Thanksgiving.
We were running out of time for the certification.
Correct. Actually, there was no count or anything, but when you held that meeting, and we'll get to those circumstances in a moment, when you did hold that meeting, as I understand it, Mr. Wood, was it, who was not there?
That's correct.
Howard, excuse me.
Howard, Mr. Howard was
Mr.
not
Howard.
there.
We're going to get our names right one of these days. Mr. Howard was not there, and he was out of town, so then the county commission appointed Mary Ann Marshall.
Yes, sir, that's correct.
And then that night, as a substitute, as I read this, and then that day, that morning rather, the 2 remaining members of the canvassing board put her on the board that day as a substitute?
The county commissioners replaces any commissioner.
Okay.
We did not place her.
All right, but when she
The canvassing
came,
board did not place
when
her.
she came that morning, as I read what we were furnished, the commission acknowledged that she was serving as a substitute commissioner.
The canvassing board acknowledged the fact that she was substituting for Mr. Howard.
And you were aware, and everybody was aware, that she had been on the ballot in this very election, which we are now contesting. Is that right?
Yes, sir, that's correct.
And you're familiar with the law because it was this person that worked for you. She just didn't do it because, was she on the canvassing commission?
No, she was on the ballot.
I know, but was she on the canvassing commission or just an employee in your office?
She is an employee in my office, and she is my right arm, and she stepped down because her name was on the ballot.
Well, she did the right thing, but it
Yes,
wasn't
sir.
necessarily that she had to. She did it because it was right. And we're proud of her for that, and you for having somebody that works for you like that. But then you put somebody, you didn't, the commission put somebody on the commission to serve in this case that had been on the ballot, and just like your assistant, correct?
But her election was over.
I think we're getting into the final legal argument that
No, I'm not.
Douglas and I talked about we would make.
I got us down.
Let's try to move this quickly as we can now.
As being an expert on the law, I think that would be reserved for final argument on the legal side. Otherwise, I have to bring in all the witnesses.
I'm waiting for a question.
I've been trying my best here.
I'm listening for a question.
Okay. Now, to summarize slightly, there was one certification on November the 9th. There were no other certifications until the 24th, or was it the 26th?
No, let me object. I hate to stand and object again. I think this has been asked and answered. She said it was the 24th.
We stipulated to it, but then they went into all this other stuff. I think we have to go into
We
it.
stipulated, both the defendant and the plaintiff stipulated.
That's what we did.
Her testimony is in line with what's in the stipulation.
All right. The other thing I was going to ask you was, aren't there two sides to that ballot they put up there? The one with the red
Depends on how
line
you
on it?
look at it. There's a front and a back,
Yes, ma'am.
and there's two sides.
There's front and the back, and there were some races on the back, too, weren't there?
That's correct. In order to vote that complete ballot, you had to, if you wanted to vote on each race, you would vote front and back of an A, B, and C card. The presidential race is only on the A card, and that is also the card that tells you how many voters participated in the November 7th election.
So there is one question I didn't ask you. I think I've tried everything to get this in. Isn't it correct that at the time you sent that first certification in, you yourself thought there was something wrong with it?
At the time I sent the first certification in was the election night results.
Okay, the next day.
And there was absolutely nothing wrong with it. The automatic recount, we missed 218 ballot cards because we tried to pull out all the red ones. All the red ones were not up top. They were turned down in the bottom of the box. It was not until after they had already been sealed up, signed and sealed and stored under security the morning of the 9th. By 9 o'clock, we realized there had been a mistake.
And you sent...
The mistake was that I did not proof everything that left my office.
Okay, my question still is, at the time you sent the certification on the 9th, which certified what you now say was the incorrect count, you already knew that, you yourself.
I knew it, but not before it was certified and faxed and mailed to the Division of Elections.
I'm not going to go into the question of your political affiliation in public statements or anything like that. Thank you.
Your Honor, may I ask a couple questions in light of what he has done? I'll try to keep it short. Ms. King, my name is Joe Clark. I'm counsel for Catherine Harris and for Clay. and also for the Canvassing Commission. If I could just ask you a couple questions.
Sure.
With respect to the November 24 meeting, I believe you testified that neither anyone from Secretary Harris's office or the Elections Division told you what to do, other than advising you that if you were going to do anything, you had to have a canvassing board meeting. Is that correct?
Pretty much so.
Okay, fine. So when they say in paragraph 10 of the stipulation that the November 24 meeting, after receiving advice from the Elections Division of the Department of State, the advice they're referring to there is just that you had to have a meeting if you were going to do anything. Is that correct?
That's correct.
Thank you, ma'am. One or two more questions. When you sent in the certificate on November 7th, you just had the returns and you signed it. Is that correct? And you sent it in?
We type those figures up on the forms that are sent to us from the Division of Elections, and the 3 members sign that, and it is faxed, and then it is mailed immediately to the Division of Elections.
Okay, you don't write any personal notes on it or anything, you just fill in the blanks and sign it, correct?
That's correct, on the
Great.
certification.
Now, on the next day, after the automatic machine recount was done, did you do the same thing, ma'am?
That's correct.
Did you put any personal notes on that, or just fill in the form?
Just filled in the form for the recount.
Okay. And after you had the meeting on November 24, when you sent that particular form in, did you have any notes on that, or did it just have amended on it?
I'm not real sure, because I sent quite a few.
But you did not have any explanation in there as to why there was a difference between that one and the one you had filed on November 9th.
I believe we did. I believe we had an explanation on that. And also we sent in the precinct by precinct results showing.
Okay. And then finally, ma'am, when you sent in the numbers on November 26th, is it? The day that you were ordered to by the Supreme Court of Florida, when you on the Sunday, when you sent the final numbers in, they include the overseas ballots?
Correct.
You just filled out the form there, and that contained the total number of votes for Nassau County. It just wasn't a supplementary one, it was the total votes, correct?
We had 2 different certifications that went in. One had the overseas ballots and one had the actual election count.
Okay, that's fine. Thank you very much. Oh, just one last question. I'm sorry.
I didn't realize that he was going to ask direct or cross or whatever it is. At the time he did, I have one.
Took Mr. Bartlett's direct.
But I have one question.
One last question.
On his cross.
All right. You got another question?
Yes, sir. If he's through.
Yes, sir. I think so.
Yes, apparently.
Ms. King, I hate to belabor this point, but did you make a statement to the press that was reported in the Washington Post on the 26th November? Quote, she, King, said they were told by Ed Cast, who works in Harris's office, that the local board could certify its original tally and disregard the recount. Is that what you told them?
Something to that effect is what I was told. I was trying to get help from the Division of Elections, and they told me that it was in the hands of the canvassing board.
But Ed Cast, who works in Harris's office, that the local board...
I believe that we heard that one the first time. So
I want to know, I think they're
she
consistent.
answered that she told him something to that effect, so may we move on.
That's all I have.
All right. If by your leave, I had one question, if you don't mind. Let me ask you if your instructions were, Ms. King, that you could have a meeting of the canvassing board. First, who ordered that the ballots be sealed up and that the tape be put on and the judge sign and nobody could open that box?
That's just one of our laws, that as soon as the election is completed, you seal them.
All right, and then...
and they're not supposed to be open, to my understanding, unless you have a court order or the canvassing board has some reason to go back and open them.
Well, that's the reason I wonder, when you had the meeting on November the 24th, did the canvassing board discuss reopening the
At that
box?
time, we were running out of time, and we felt the best way to get the correct certification to the Division of Elections was to go back to the election night results. Okay. But I did offer, and I'm still offering, I will go back and count them automatically by hand, whatever's necessary to prove to you that the tally that we gave you on November the 7th is correct.
All right. And do either of you have any questions concerning any matter I may have inquired about?
No, sir. Your Honor, could I
Yes,
ask
sir.
one, Ms. King, to follow up on what Judge Saul said. You remember the day of the meeting on the 24th,
Yes.
indicating to the canvassing board that based upon your conversations with the Secretary of State's office and given the time constraint, the thing to do would be to recertify the November 7th return?
That was my understanding.
And is that what you advised the canvassing board?
Yes, it was.
And then you subsequently sent in a new certification to the Secretary of State's office indicating that this was an amended certification. Is that not correct?
Yes, I did.
Thank you.
Anything further? May the witness stand down and be excused without objection. Thank you very much. Call the next witness.
Your Honor, that was our last live witness. If Your Honor would like, I could, at this time, formally offer the various documents that we've referred to in the course of our presentation. And we've been doing the best we can on this, and we'll furnish the court and the clerk and plaintiffs and the other parties.
Apparently you're about ready to rest, I assume. And
yes.
I suppose, Mr. Clark, you had some brief, you wanted to put in some documents, I understand. And
as long as there's no
I was just wondering, it's at 5:30. You think we could take until about 5:45 and y'all can sit down and look over these respective lists that you have here and each of you make sure you've got everything in? I mean, is that satisfactory?
Sure.
All right, then let's do that. We'll stand in recess until the hour.
So we have a break in the courtroom of Judge N. Sanders Sauls as he conducts a trial of whether or not there will be a recount of some 13,000 contested ballots from Miami-Dade County and Palm Beach County. A contest, of course, brought by Vice President Al Gore in the election in Florida. We've seen a couple of witnesses this afternoon, heard some testimony. We have not heard closing arguments yet from the attorneys. That will come a little bit later. We're going to take a break. When we come back, we will have some guests talk about what we have seen this afternoon, and then we will get ready for closing arguments in the trial in the courtroom of Judge Sauls. The question is, will there be another hand recount of those 13,000 contested ballots, or all of the state of Florida for that matter? We'll be right back.
If making money were simple, we'd all be millionaires. Let's face it, money decisions are tough decisions. You need to know what's going on here and how it will affect your finances, your future, and your family. We cover the markets in plain English so that when the bell rings, you can understand what happened and decide what's right for you. We bring Wall Street to Main Street so maybe you can live on Easy Street.
Mother Nature takes her toll, raging against the elements. Fox News Channel is there, bringing you the updates. From the eye of the storms to the aftermath of destruction, make Fox News Channel your only source for complete and up-to-the-minute reports.
Fox presents 邪悪な魔力と戦うために選ばれた一人の戦士フォックスが放つニュータイプのエンターテイメントキュートでクールなスーパーヒロイン お待たせ バフィー恋する十字架彼女は高校生彼女は恋する少女彼女はヴァンパイアスレイヤー
I'm Sarah Michelle Gellar Buffy the Vampire Slayer かわいいセクシーですね
ハリウッド映画界の新星サラ・ミッシェル・ゲラーミュージッククリップにも登場ネット上でもファンが熱狂世界のメディアが注目圧倒すごいクール バフィー恋する十字架、ヴァンパイアと戦うことが彼女の使命。
運命だったのよ。
信じますね。
信じますよ。
運命の人がいたらいいな、見てほしいです。
頭がぶっ飛ぶのが愛。
君とは戦わない。切ない恋の行方は、フォックスが放つニュータイプのエンターテイメント、キュートでクールなスーパーヒロイン。バフィー恋する十字架、毎週木曜夜10時。宿命の対決か、運命の恋か。Only on Fox。
Hi, everybody. I'm John Gibson. We have a break in the courtroom of Judge N. Sanders Sauls in Tallahassee. This trial on whether or not there will be a recount of some 13,000 contested ballots from Miami-Dade County and Palm Beach County. This claim, the contest of the Florida election brought by Al Gore. Before we go back to the courtroom to hear closing arguments, let's go now to Carol Iavana for an update on where we stand in this whole post-election saga. Carol?
All right, John, it's an overview. Hello to you, and here's what's happening at this hour. Dick Cheney is calling for Al Gore to concede, but the Republican vice presidential candidate says he understands how difficult it is for Gore. The Supreme Court justices were already hard at work this weekend deliberating. Meanwhile, several election-related lawsuits are still pending in Florida state courts. And both candidates are making plans to move into the White House just 7 weeks from today. All 9 U.S. Supreme Court justices put in a rare Saturday at work. They are considering whether and how they'll get involved in the Florida election case. In court hearings Friday, some justices questioned whether the highest court in the land should interfere in the battle over contested election results in Florida. Lawyers for George W. Bush tried to convince the justices that Florida's top court rewrote election law by extending the deadline for vote counting. Vice President Gore's team wants that ruling to stand. Many legal experts believe the court will try to avoid a split decision. Chief Justice William Rehnquist has not indicated when the court may issue a decision. In Florida, tense exchanges taking place in the circuit court in Tallahassee. Expert testimony kicked off the second day of court proceedings. A Florida businessman who redesigns voting machines disputed that the so-called Chad buildup could have caused the ballots not to register. Judge N. Sanders Sauls is considering whether to grant Al Gore's request for a recount of 14,000 contested ballots in those areas. Waiting in the wings are more than 1 million ballots from Miami-Dade and Palm Beach counties. They were trucked to Tallahassee just in case the judge orders a recount. Regardless of which way the court rules, it's expected to be appealed to the state Supreme Court. The Florida Supreme Court already has turned down Gore's request that it order an immediate recount of disputed ballots. It also refused to order a new election in Palm Beach County, saying the controversial butterfly ballot is legal. Al Gore's top lieutenant in the post-election battle says it's too early to give up. Warren Christopher is responding to Dick Cheney's calls for Gore to throw in the towel. Christopher says if the time comes to concede, the vice president will do it in a very gracious way. The vice president attended a Baptist church service outside Washington today, taking a break from all the legal wrangling. Meantime, Gore's transition team continues to work on putting together a staff in case he wins. Word is campaign chairman William Daley has the inside track for White House Chief of Staff. Governor George W. Bush is shoring up his own potential cabinet. Bush and running mate Dick Cheney met yesterday with House Speaker Dennis Hastert and Senate Majority Leader Trent Lott. During the meeting at Bush's ranch, they discussed possible cabinet appointments and the next congressional session. I'm Carol Iavana in Fox Central. Now back to John Gibson and more of Fox News Channel's continuing coverage of Florida's decision. Back to you, John.
Okay, Carol, thanks a lot. We are waiting for court to resume in the courtroom of Judge N. Sanders Sauls. Meanwhile, should the current political edition of Hot Potato keep on moving, the ball could end up in the U.S. House of Representatives court. Joining us now with their take on what's going on in our Washington Bureau, California Congressman David Dreyer. Hi, David. And in Philadelphia, New Jersey, Congressman Robert Andrews. Gentlemen, thank you both for joining us.
Good to be with you both.
Mr. Dreyer, before I start talking about what could happen in Congress, let me ask you for your take on what we have seen this afternoon. What the wires are clearly playing as the big moment is the witness called by the Bush team, who at the very end was forced to admit that even though he was an expert on these voting machines, that it was his view that in a very, very close election, you might have to do a hand recount. Question came from the judge. It sounds as though the judge might find himself in a position, no matter how he feels about anything else here, since the expert says a hand recount might be necessary, that's what he might have to call for.
Well, this may sound extraordinarily irresponsible, John, but I've just come back from Mexico, where I had the thrill of representing the country for the inauguration of President Vicente Fox, and I watched the Redskins narrowly lose to the New York Giants today. And in the spirit of comedy, let me begin by congratulating my friend Rob Andrews on the New York Giants' win over the Redskins. And I hope very much that we will see the same kind of spirit of comedy when we certify the electors next month here in the Congress. I will tell you that when it comes to the issue of recounting, what we've seen here is very clearly a case of the vote. We saw a count, we saw a recount, and in many instances, as you know, John, we have seen a hand recount in some areas. The fact is, if you look at this question, and Tim Russert pointed this out this morning, there are 10,000 some odd ballots in Oregon and in New Mexico that have gone uncounted, and the margin of victory for Al Gore was about 8,000 in one case, just a few hundred in another. And so how do you make a decision that you target a single particular area? We know that there is a margin of error, but the fact is we have seen this process. The ballots in Florida, certainly in the 3 counties in question, have gotten they've gotten counted more than Rob's or my vote have been counted.
Congressman Andrews, even if the Democrats decide that this was a good day because the Republican witness admitted that maybe a hand recount is necessary, it wasn't so good in some other aspects of his testimony. If you followed his testimony, these dimples would not count at all. And that and the judge may very well order, yeah, you got to do a recount, but no dimples, in which case Al Gore would lose votes that he's already got.
In the interest of full disclosure, I'm a Philadelphia Eagles fan, David, not a Giants fan, and we lost a terribly close one to a guy to Tennessee, so we're sort of hopeful that'll play out in court, too. Tennessee wins a close one.
Okay, well, maybe Gibson is a Giant fan.
No, you know what, I don't care about the football game at all. Tell me about this thing we're watching in court.
Let me answer your question. I think that the U.S. Supreme Court is going to say that the federal courts have no role here. I think that eventually the Florida Supreme Court is going to order these undercounted ballots to be hand-counted. And I think they're going to believe that can be done before the 12th of December, and they're going to order it done.
Here's my question. I mean, it's not exactly a win-win on the Gore side today.
No, that's true.
And that what we seem to be facing as a trade-off is, okay, Al Gore, you get a recount, but you don't get dimples.
John, but I think
it seems to me the progress he's made lately has been on dimples.
I think it's very likely that if the Miami-Dade undervotes are reviewed by human reviewers for the first time, that the vice president would have a sufficient number of votes to catch up and win. That's what I think is going to happen.
Why would you think that? I mean, even the statisticians today, you've seen what?
I've seen them. I was in Miami-Dade on Wednesday watching the inventory of the ballots that went up in the famous Ryder trucks. And I had a chance to look at 200 or 300 of them as they were being sorted out, the undervotes. And my sense is at least a third of them, maybe a quarter, are votes. And they're not dimples, they're votes. And I think you'd find them counted in the vice president's favor more so than in the governor's favor.
Congressman Dreyer, before we go to a break, and I got to do that quick, on the 60 Minutes program tonight, 60 Minutes, Al Gore said, if at the end of the day, when all the processes have taken place, if George Bush is sworn in as president, he will be my president, he will be America's president. Is that sound to you like Al Gore is extending where this process might end right up to the moment that George Bush would be sworn in? Not December 18th, but January 20th, 21st, whatever the day is of inauguration.
Well, obviously, John, we certainly hope not. We very much want to get this resolved. The American people want to get it resolved. I've been talking to Democrats around the country as well as Republicans who've said they want this to be put behind us as quickly as possible. It's been a close election. Everyone acknowledges that. But I believe that it's very clear that George Bush is, in fact, the winner of the election. And I think that what Warren Christopher said today, that Carol had in her report, is very nice. That while Dick Cheney did, I think, appropriately say that it's time for Al Gore to concede, Warren Christopher did say that we'll have a very, very nice and appropriate concession from Al Gore when this is resolved. And obviously there are still questions in the eyes of Al Gore, but I think most Americans, having concluded, as the Washington Post showed the other day, 60% of them, that George Bush is the winner, and in fact the concession should take place as soon as possible, because we want to get governing. We saw that meeting that took place, John, yesterday in Crawford, Texas, at Governor Bush's ranch, and we very much want to move ahead, and we want to govern in a bipartisan way, and I look forward to working with Rob and other Democrats on a wide range of issues.
Both Congressman David Dreyer and Congressman Robert Andrews think they won. We shall see. Thank you both. I've got to take a break.
And we do look forward to working together, as David said. That's true.
I got to take a break, and we'll work together after that. I will concede it's time for a break. When we come back, we'll go back to the courtroom of Judge N. Sanders Sauls. He's on a short break. Then closing arguments in this trial, the contest of the election in Florida, brought by Al Gore. Back with more in a minute.
No. You know, we agree on just one thing. A good argument's the best way to get to the core of an issue.
Wait a minute, I don't agree with that. A discussion's the best way. You have to explain, reason, justify your position.
Everybody on TV is discussing things, Alan. That's boring. If you want to find out what people really think, you need a good argument.
No, a discussion's better.
An argument.
A discussion.
We can agree on this. It's your turn to pick up the check today.
Well, I'll argue that one.
Alan, let's see if we can discuss this.
Fox News Channel, Primetime Power. Neil Cavuto, Brit Hume, Shepard Smith. Powerful coverage. Wall Street, Washington, the world. Bill O'Reilly, Hannity and Combs, Paul Lazan. Powerful insights, confronting the politics, the newsmakers, and the issues. Primetime Power, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide.
Grandpa, that's the whole story. That's what happened.
Okay. Katie, now you tell me what happened.
Well, but Grandpa, I just told you.
Well, it's only fair if we hear her side.
What, you don't believe me?
Oh, now wait a second. It's important to hear both sides of the story so that we can understand everything that happened.
Grandpa, can I tell you my side?
Oh, yes, go ahead.
When I was playing, Greg just came over and pushed me. I wasn't doing anything.
Okay, Greg, now what about...
Fox News Channel Daytime, the whole story in context. Facts presented fairly, the issues balanced, so you have the power to think for yourself. Fair and balanced, the most powerful name in news. Fox News Channel, we report, you decide.
Fox, tonight.
最後の千日が始まった。突如焼死した少女。出生記録のないその亡骸にはある企てが隠されていた。今からの始まりじゃない、終わりだけだ。ミレニアム、今夜11時、オンボックス。
We are looking at a picture from the courtroom of Judge N. Sanders Sauls in Tallahassee, Florida, where he has been conducting a trial in which he, the judge, is the jury. And the question is whether or not Al Gore's team will get their way, and there will be a court order for a recount of some 13,000 contested ballots from Miami-Dade and Palm Beach County. These are ballots that show an undervote, no vote for president. Al Gore's team wants to look at those ballots. They contend that if they are hand-counted, if they are looked at by human eyes instead of a machine, a vote can be discerned and that Al Gore will win. Very important testimony today from the man who designs and sells of votomatic machines on which these ballots were cast. He talked about what these chads mean, hanging chads, dimpled chads, and he was forced to admit at the end that there are some circumstances in very close elections where a manual recount would be required. However, his testimony also indicated that it was almost impossible, in his view, to determine a vote from a dimple in a chad. It was his view that a vote had to be a clear punch-through, that the chad may be hanging, but that if it just appeared to be bent or creased or dimpled, that did not indicate a vote. So there was both a win and a loss, testimony-wise, for the Gore team. Let us go now to Chris Osborne in Tallahassee for more of a roundup of today's activities in the courtroom of Judge Sauls. Hi, Chris.
Good afternoon to you, John Gibson. Well, only in the last several days, I must confess, can I say that the width of a chad is .125. Nevertheless, a lot of witnesses today, a lot of verbal warfare between attorneys, of course. Several of them, the last one we just saw, Shirley N. King, the Nassau County Supervisor of Elections. Nassau, of course, being one of the 3 counties in which the Gore camp is officially contesting their certified results. Now, Shirley King talked about how we know that on election night there was then a different number than the machine recount. The machine recount found 218 fewer votes. So their canvassing board, 3-0, voted to certify the election night returns. That's something Republican attorneys wanted to bring out, and what they had her say was that, in fact, in the name of inclusiveness and fairness and getting votes counted, that's what we chose to do. Then Dexter Douglas with the Gore camp came up to point out the fact that this amended certification about this initial election night return, that was made thereafter, after doing something earlier on, and that revealed an inconsistency of sorts. Earlier we heard from Mr. Lampkin, who was a Republican observer in Miami-Dade. He specifically said that he saw a couple moments when undercounted votes were being marked for Gore. Nevertheless, as you mentioned, John, there was that person earlier today, Mr. Amon. He was a machine expert. He did, in fact, concede that his machine needed a new patent, and his analysis machine, because he had some problems with others at certain times. So a lot of sparring back and forth, as we saw, a lot of interesting moments. Also, Mr. Spargo, an attorney, talked about how the ballots were moved around. Of course, Republicans wanting to highlight the subjectivity of this process, of the way ballots had been shifted around and interpreted. Also, Mr. Spargo pointed in a detailed way to how different members of the Miami-Dade Canvassing Board saw ballots in a different way. That's something, of course, part of their argument. John?
Chris Osborne in Tallahassee. Chris, thanks a lot. We are waiting for court to resume in the courtroom of Judge N. Sanders Sauls, when we are expecting closing arguments to begin from both sides here. While we're waiting for that, let's talk to our legal editor, Stan Goldman, who is in Los Angeles. Stan, I am making, and the wires are making, a lot of the testimony of John Amon, the election machine company. I guess he sells these things and designs them and builds them from, of all places, Napa, California. What did you make of his testimony? Do you agree with me that it seemed to be both a win and a loss for the Gore side? Yeah, there might have to be a manual recount, but he seemed to say you can't count dimples as votes?
Yeah, you know, if I'd been the Bush lawyers, I think I'd have just not called any witnesses today. I thought they had a pretty good day yesterday. The two main, the two witnesses for Vice President Gore, you know, I thought had some flaws in their testimony, and although the witnesses for the Bush side weren't spectacular, I thought it was a very good day for the Bush team yesterday. I'm going to just stop because it turned out that that witness at least did give testimony that is very important for Vice President Gore. But you're right. If the judge ends up ruling in Gore's favor that they can count Dade County, but can't count the dimpled votes, this could be a very close race, and that's one of the reasons why, of all things, this little Nassau County dispute we just watched could very well end up becoming important. The reason being is it's only 52 votes. We're arguing about 52 votes. Well, you know, if they don't count dimpled votes in Dade County, maybe Gore only picks up another 100, 150 votes. Those 52 could end up deciding the presidential race.
Well, but Stan, if the judge has a couple things to decide. If he's going to decide that there's a recount, he also has to decide on a standard. That's why we're talking about the dimples. If he decides that a dimple is not a vote, Do they have to go back to Broward where they did count a dimple as a vote and undo or recount that county?
Well, that wouldn't appear to be before the court. In other words, what the court may very well say is you are to use your discretion, and your discretion does not include my telling you you have to use dimpled chads as votes. If you don't want to, fine. If you want to, also fine, as long as there is a clear indication that, in fact, this is a vote, and that's your standard, and you're given some discretion. But I found it hard to believe from the beginning that any judge was going to order Palm Beach County, for example, or Dade County, if they are allowed to recount, to force them to count dimpled chads.
Stan, thanks a lot. As you can see, they're underway again in the courtroom of Judge N. Sanders Sauls. Let's listen in.
The parties to review their document list.
I'm told that ours has been reviewed and agreed to on the items that I'm going to be offering. And I am sure that the plaintiffs has been reviewed, and we've made some sort of agreement on that as well. But in any event, I will now read in the exhibit numbers of those that we'll be offering. And does Your Honor want me to note for the record just a thumbnail description of what the exhibit is, or shall I just read the numbers?
Well, if you've stipulated to them, if you have a list of the exhibits and everyone has the exhibits, then I would then just move your list, and we'll put that in as a court exhibit.
With the court's
if you
permission,
have one that's not scratched up.
If we could supply that a little later. We have a list, but it's got arrows on it and crossouts and handwritten things. So we need the evening to prepare a list that is presentable.
Well, would you take one that you have there where what it is you've agreed on, where you can initial it so we all know that that's what it is, and then you make a copy of it?
Sure.
Mr. Locke, do you want to participate in that?
Okay.
Your Honor, while they're busy signing, we have some objections that we'll hand up. Most of them, Your Honor, just go to weight and weight that we'll give the exhibits. One of them,
you can argue the weight of them in the argument.
Precisely, that's what I'm saying, Judge. That's what it doesn't
that
require
won't be an objection.
Right. And so I'll hand that up, Your Honor. And the first one having to do with the
show them what it is you have.
Official amendment certificate of state elections. They just put part of it. We have the rest of it. The part they put in is fine. It's just the part they didn't attach. It's understandable. It's a box. So if I could hand this up, Your Honor. Objections?
No objection. All right. Without objection, is that going to be a court exhibit?
No, that's just the objection is written down, Your Honor, so we don't have to talk about it. As I said, the first one, we have the rest of it. The part you have in is fine. The rest of it just go to weight.
Well, then can ours be then subject to the agreements made with Mr. Beck and with y'all be admitted, subject to the weight being given by the court?
Absolutely. Yeah, no problem.
God bless you. That's wonderful.
All right. All right.
And, Your Honor, our trial exhibits as well, which are numbered, pre-numbered, and there's two boxes over here. The first one is the official returns, Your Honor, which you might want to just leave in the box. And so they're right here in front of the clerk.
We have a list.
Yes, sir.
Yeah, I just
This is right there, sir.
Court exhibit. All right, then plaintiff's list we have, I assume, will be Court Exhibit 1. Bush et al. Will be number 2, and this will be number 3. Is that satisfactory? Court exhibits.
And, Your Honor, I think you'll find on several of the lists there are transcripts of the canvassing board determinations, and sometimes they're partial transcripts. And what the parties have agreed is that we will get together this evening, hopefully, and we'll put together a complete set of the transcripts from all the meetings of the canvassing boards in issue, and we'll simply submit that jointly without separating them into the partial transcripts that the parties have designated, so that you'll have a complete
That'll be
set.
satisfactory. I recall there were the plaintiffs filed 4 or 5 or 6 transcripts, and then there had to be an additional filing because of another meeting that was not in the original file of transcripts. All right.
I think that's right. So we'll get together a complete set.
All right.
Judge, this is significant and it's difficult. I've worked with your clerks and they've helped so much in trying to straighten this out. We moved into evidence the approximately 9,000 undervotes from Miami-Dade County that were up here. There appears to be a question in what box they appear in the transport stuff and what numbered boxes. All I want to make sure is that we've moved them into evidence. We'll have to find where they are, but they are here under your order, and we want to make sure they are in evidence irrespective of the trouble we might have figuring out which box they're in. Am I making sense with that?
Yeah, well, you've attempted to list the boxes, but you don't know if that's all.
These are the transmittal forms that were given to us by the clerks, and what it says, number 80 on this particular one, they have this before. You know, it says undervotes from precincts 1 through 451. Then the next box says voted ballots from 501 to 940. I don't know where the rest of those undervotes are in the boxes because I can't see those boxes or get into those boxes. But I just care that they are.
You have a receipt list, do you not, Mr. Clerk?
Yes, sir.
And that's what he has?
We have not opened those boxes.
That's what's confusing.
Well, just move that in. You've got them all now. Nobody's going to be switching them from envelopes or doing anything with them, and they'll all be there, yes.
Your Honor, I mean, you know, we said it enough times that I should sort of understand. Obviously, we object to any ballots coming in for a recount unless you have all the ballots coming in. And as you know, we believe the time has expired for that, and it was the responsibility of the objector to request it in North 67 County. So subject to that objection.
All right, we'll just mark those for identification. Well, they're entitled. If they want to put them into evidence, we've got them. They can put them into evidence, and you can argue whatever your argument is. All right. Mr. Kitchen, I don't know if that's clear. You've attached the receipt documents of the clerk, and that's satisfactory to represent your submission of all of the ballots. And then we will, at the appropriate time, and you have the clerk. The clerk can sort them out to make sure which ones are in which box, I assume.
That's our problem. I don't know what box it is.
Okay.
We may need the supervisors help on something like that.
Well, talk to Mr. Greenberg.
Your Honor, may I address the court on
may
that?
need the supervisor's assistance, your supervisor's assistance, that the clerk may, as far as the box.
We would be glad to help, Your Honor.
Thank you, sir. All right.
May I address the court up briefly, Your Honor?
Chairman.
We will be filing later today a motion to exclude the Miami-Dade ballots from any consideration for this reason. I suppose you could tell from Mr. Kitchen's effort to try to figure out what's in what box. We don't know either. And this is not casting aspersions on the good faith of the good people in Miami-Dade County. That's not the point. That evidence has been through all kinds of reshuffling, or those ballots have been through all kinds of reshuffling that Your Honor has heard about this afternoon. That's point one. Point two, as part of the plaintiff's affirmative case, they did not prove up through any witness the authenticity of those ballots. They didn't call Supervisor Leahy. They didn't call anybody from Miami-Dade to actually put those ballots before Your Honor in an appropriate way. So I suppose my objection is twofold. One is there's no proper predicate for them as part of the plaintiff's case. They missed the point where we could have cross-examined someone about that. And number two, there is a spoliation issue. We believe strongly that no one could go in and look at those records now and have any confidence that they are really what 625,000 voters put into the box on November 7th. They went through the machines at least 3 times. We believe that at least some, and perhaps more, went through a 4th time. They were handled by hand in many instances. There is evidence of...
I understand the nature of your objection.
Yes,
I think it goes to the argument and the weight and credibility and and the utilization, if any, of those particular items that were in evidence. But I don't believe that that would go to their admissibility, and as far as their authentication, I would have to deem that they, pursuant to the order that the supervisor furnished all of the ballots that are down there, unless there's information that is developed that that's not all of them.
I'm not going to argue with Your Honor at all. My only point is there's no evidence that's in testimony, and therefore no evidence admissible in a trial, and accordingly no opportunity for us to cross-examine about that, and for that reason I respectfully object, but I understand how Your Honor feels.
Right. Well, I think that your objection is duly noted in the record. And at this time, are there any other witnesses? And Mr. Clark, you've submitted your evidence. We have a court. All right, we have a court exhibit. All right, at this time, does the plaintiff wish to go to rebuttal, or no? We still have two additional. Yes, sir, Mr. Meyer. You had one witness.
I wish at this time to hear witnesses from the interveners.
All right.
We have deferred to Mr. Madigan to go first on the order of his witness.
What purpose does the gentleman arise?
Your Honor, I think we have stressed the need for, and the intervenors are here subservient to the main cause of action. I think to reach the decision here that's needed to move this matter, the intervenor's interest does not identify completely with either party that are to the contest. I therefore suggest that their issues be raised later after the court has made a decision about recounting the ballots and about possibly how they're going to be recounted, because we need that just as soon as we can get it. And to tie up considerably more time with testimony after this long period, we think would be detrimental to our clients and to their clients.
What's your position?
Your Honor,
feasible solution?
Terry Madigan on behalf of Matt Butler. Mr. Butler has appeared through counsel, has filed pleadings. They have not been objected to or denied by counsel for the plaintiffs. He is here in the back of the courtroom in the far corner for purposes of authenticating he is who he is, but again, that's not been denied. He's appeared, and I'm concerned that Mr. Douglas is now making a standing argument again, which...
No, you know he's here, and you show...
All right, what we'll do is I'm going to let them, actually, apparently both of the intervenors, classes, they represent actual voters, and voters are people who have an interest in this, so I'm going to let them make a limited presentation. And I think I've already explained to them that theirs is very limited. I'm not going to have, did you furnish a list of witnesses?
Yes, we did, Your Honor. And how limited are you talking about?
Well, how many witnesses? Nobody showed me the witness list. I'm not going to have people come in and duplicate. Just it should be stipulated if all they're going to testify to is that they were a voter in a certain county. Yes, sir. Mr.
Your Honor, again, in the interest of time, he has appeared through counsel.
How many witnesses do you have, sir?
Just him.
All right, fine. How many witnesses do you anticipate?
4, Your Honor.
All right, and the nature of those, the purpose of those witnesses?
First witness to establish the time at which she heard that the state had been called for Vice President Gore in the Central Time Zone.
Does that have any relevancy to this proceeding?
Yes, Your Honor, it does.
In what regard?
In regard to the court is required to look at the contest as a whole from a statewide perspective, as we have argued earlier on, and from the point of view that the court is to consider all alleged wrongs that took place in the statewide election pursuant to 102.168. We ask the court to consider all the factors, all of the issues that are raised as alleged wrongs in this particular election so that the court can determine as a whole the intent of the voters in this statewide election.
What's your next witness, the substance? What's the next witness you have?
The next witness is to establish that, in fact, this call did, in fact, affect voters. They did not go to the polls as a result of that.
It'll take about 2 minutes. What's the next witness?
And the last one is an expert witness who will indicate that it did have an effect on the voting in Florida. It will have had an effect on the results, which of course your court is well aware that as one of the things you're looking at to determine whether there's been any effect on the results.
That what had an effect on the overall?
The early call of the election by the press. And
I believe that would be bringing in some extraneous matters to the issues that we have in here as far as that expert is concerned.
My co-counsel, Manny Klausner, would like to address the court on that. May you address the court?
Your Honor, very briefly, our view is that under the applicable section of the Florida statutes, which ask the court to look at all the circumstances and frame a remedy that's appropriate, whatever the court may find has been done erroneously or improperly with respect to the election, that if the court finds there have been any errors, whatever, before the court is able to frame an appropriate relief, the word is appropriate remedy under this code, the court...
Well, what you have are some witnesses, apparently, depending on what type of supposed remedy that would be fashioned, but as far as I know, the plaintiffs have filed a contest to this election on certain specific allegations. The other defendants have defended on those allegations, and this apparently goes to another matter.
Respectfully, Your Honor,
yes,
our view is that under the code, the court may provide any relief appropriate under the circumstances. Our view is that this codifies the inherent equitable party of the court. If there were a tornado that wiped out half of western Florida, our view is that the court should consider any act of God or other intervening circumstance as a bearing on a designing
with
an
respect to the
appropriate
relief that these plaintiffs...
That's our view, Your Honor.
I'm going to have to respectfully disagree with you, sir.
May I suggest this, Your Honor, because our evidence is very limited in terms of time. And
I'm not going... Your fact witnesses that you want to present, I will permit those, sir, but we're not going to bring in another statistical expert that's going to, I suppose, have an opinion concerning the effect of as I understand it, an early call by
the networks or the local media.
By the networks, as that might have some bearing on this case. I'm just going to have to respectfully disagree with you. I think that your position is noted in the record, and will be a part of this, subject to appropriate appellate review.
We do have another expert, Your Honor, who would be prepared to testify very briefly on the issue of the use of selective hand recounts in certain counties as diluting, in terms of the overall effect on the statewide results.
Has this witness disclosed to the other party so they've had an opportunity to...
The answer is yes, he has been disclosed, and he's here in the courtroom. And he's ready to testify.
That one witness.
No. Your Honor, if I may make a brief suggestion. Miami-Dade County...
Did I hear dissent?
I think so, Your Honor. Miami-Dade County Canvassing Board doesn't care, but maybe as an expert, as a way to speed these processes along, these interveners, first of all, as Your Honor recalls, were admitted and allowed to intervene subject to and subordinate to the rights of the main parties, or else I think there would have been more objection at that time. They have filed an intervener's amended witness and exhibit list. They filed it today. If everyone can stipulate that that goes into the record, it speaks for itself. We don't have to hear from anything else, and we can maybe move on.
I think, Your Honor, I think technically we would have to proffer them for purposes of the record, and I would suggest to the court that a written proffer could be done in order to save the court time.
All right. Well, let's proceed. Let's proceed in that fashion. Bring on your fact witnesses at the appropriate time, and then you may proffer the expert testimony.
Your Honor, I have only one party that testifies to stand. If the plaintiffs will stipulate that my client is a voter in Duval County, voted for Governor Bush, and that he has not received any certification of how he voted, that's all I want.
Well, we certainly could agree with that, but he may not have pushed his Chad.
Subject to that, he stipulates to your proffer.
Your Honor,
and your client's name, Mr. Jennings, for the record.
Your Honor, there are 5 clients.
All of them named, each of those individuals as clients.
Declaratory degree, and also on a motion for...
All right, let the record so reflect. Mr. Madigan.
All he did was
Your
name
Honor.
the client, is that right?
Actually, he had 600,000 of them.
Mr. Madigan has the floor.
Your Honor, just for the record, I believe we reached a similar stipulation. All his appearances have been through counsel. We don't need for him to testify as long as we are resolved that we do have standing and we have the right to participate in closing argument. We don't need to put him up for the testimony.
What is the stipulation?
That is the stipulation.
The stipulation is that his party is back there in the courtroom and he's who he says he is. That's right.
He is, yes, sir. He's made his appearance through our pleadings, which have not been objected to.
And that's the same thing.
Or denied, rather.
Same thing we're agreeing to with
All you're going to do is present your witness that he is he?
Yes, Your Honor, and walk through what we've already said. In fact, we probably could have done it by now, but I was trying to.
Well, does he have a status? Are you proffering what your argument was the other day?
Yes, sir, and we did submit the witness exhibit list that again essentially said the same thing.
You admitted the witness list, but all that I hear is being stipulated to is to identity only. Now, if you wish to proffer that your client, I believe your testimony or your argument was to the effect that he was a resident of Collier County, that he voted in the election for George Bush, that there was some 3,000 so-called, I suppose, undervotes or no votes in Collier County, and that your client doesn't know whether his vote was counted or not. Is that
yes, sir, Your Honor?
Off the top of my head.
And Your Honor, that he did not have an opportunity
to ask for a recount.
All right, and that he did not have an opportunity to ask for a recount. Now,
yes, sir.
That's the proposed proffer.
No. He's going to proffer that, so we're not necessarily going to agree with the proffer.
All right,
and he's prepared to
call your witness.
Okay. I thought we had it.
Ask him to come forward and be sworn.
Please raise your right hand. You solemnly swear that the evidence you shall give on this issue shall be the truth, the whole truth, nothing but the truth, so help you God.
I did.
All right, be seated, sir. You may proceed.
I'll be brief, Your Honor. Would you state your name for the record?
Matt Butler.
Okay. Thank you. And you are a resident of where?
Collier County, Florida.
Okay. And how long have you been a resident of Collier County?
Just over a year.
I'm sorry, I'm hearing objections or?
Leading. No.
Huh?
Leading.
Okay, I heard. Okay. Nobody objects if I leading. Mr. Butler, did you vote in the November 7 general election?
Yes.
Okay. And did you have any problems in voting? Did you encounter any problems with the machinery?
No.
And who did you vote for?
George Bush.
Okay. What kind of voting machine was it that you used?
Punch card.
A punch card. And you had no problems?
No.
Okay. Do you know if your vote was in fact counted?
I do not, for a fact.
Are you aware that there were a number of votes in Collier County that were not counted for one reason or another?
I have read that.
Okay. And you don't know if yours was one of them?
I do not.
Okay. Do you know who gained the most votes in the presidential election in Collier County?
I believe Governor Bush did.
Do you have any idea what the percentage was?
I've read it was like 2 to 1.
Okay. Was there a manual recount conducted in your county?
No.
In Collier? Did you ask for a manual recount?
No.
Why not?
That's not, my understanding, that's not allowed by a voter. That can only be asked for by a candidate or a political party whose candidate appears on the ballot.
So you were not allowed to ask for a recount in any event?
No.
Okay. Are you concerned about recounts being taking place in any other county, Mr. Butler?
Extremely so.
Why does that concern you?
Because it places my vote at a disadvantage. It makes my vote potentially worth less than the vote of someone else's.
Okay. Is that why you've intervened in this cause?
It is.
Okay. Do you want your vote to count the same as any vote in any other county?
I do, the same.
Would you want, if there's a recount in any county, would you want the same thing to be done in your county?
Well, I want the same rules applied to my vote as to anybody else's vote in this state. That's what I want.
Okay. Thank you, Mr. Butler. Okay. No further questions, Your Honor.
Any inquiry?
Nothing, Your Honor.
All right, thank you. May the witness stand down. Without objection. Thank you, sir.
I call 1 o'clock.
I think you had a stipulation, or did you?
Well,
I don't know.
wasn't sure about
well, at this juncture, call your witness.
Try it.
All right.
All right, I call Mr. Keith Temple.
All right, is this Mr. Temple? All right. Mr. Temple, allow the clerk, if you will.
Please stand and raise your right hand. Do you solemnly swear that the evidence you shall give on this issue shall be the truth, the whole truth, nothing but the truth, so help you God?
I do. Be seated, sir. You may proceed.
Mr. Temple, you're an intervener in this action by order of the judge, is that correct?
Yes.
And your first name, sir?
Keith.
Your full name is Keith Temple.
Yes.
Where do you vote?
Duval County.
Are you a registered voter there?
Yes.
On November the 7th of year 2000, did you vote for George W. Bush as president?
Yes, I did.
Or for the electors for George W. Bush? Have you had any kind of certification as to how your vote was counted?
No, I have not.
Do you want to be sure that you are on an equal standing with everyone else in the state as to whether or not your vote was correctly counted?
Yes.
And if your county is not counted, are you assured that you're going to be on the same standing as the individual voters in the 3 counties that are the subject matter of this lawsuit, primarily Palm Beach County, Miami-Dade, and Broward County?
No.
Are you a taxpayer in the state of Florida? If you're alive, you're a taxpayer.
Yes.
Are you a taxpayer? That's all I have.
All right. Myers, did you have that witness? Will the witness stand down and be excused if there's no inquiry? Thank you, Mr. Temple.
One inquiry, Your Honor.
Oh, yes, sir.
Sir, did you file a protest in this election?
No, I did not.
Did you know you had a right to do that?
No, I did not.
Did you file a contest in this election?
No, I did not.
You know you had a right to do that?
No, I did not.
Thank you.
You were allowed to intervene on the basis of a petition to declare the manual recount statute unconstitutional, were you not?
I'm sorry, could you repeat?
You were allowed to intervene by the judge in this court on the basis of your petition to declare the manual recount statute unconstitutional. Is that not correct?
That is correct.
Did you have? All right, may this witness then, Mr. Temple, may he stand down and be excused? Without objection. Thank you, sir.
Your Honor, at this time, I call Teresa Cruz to the stand.
Ask her to come forward and be sworn.
Please raise your right hand. Do you solemnly swear that the evidence you shall give on this issue shall be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, you may proceed.
What is your name, please?
Teresa Cruz, C-R-U-C-E.
And you're the same Teresa Cruz that is listed as an intervener in this action?
Yes, sir.
And you live in Panama City, Bay County, Florida, correct?
Yes, sir.
And you voted before November 7, 2000, didn't you?
Yes, sir.
And how did you do that?
I went into the Supervisor of Elections office and voted because I was going to be out of town on Election Day, and I cast my ballot that day.
Were you a member of the military at the time?
Yes, I was.
So was this done through the military absentee or just a normal absentee ballot?
It was. I'm not sure what it was. I did fill out the ballot. I don't know how it is categorized, but it, I was there and turned it into the Supervisor of Elections in person.
And you don't know if your vote counted because you don't know if anybody physically looked at your ballot, right?
I do not know.
And then at some point, you came to be in Bay County on the evening of the election, is that right?
I had a conflict in my schedule. I was driving back to Panama City on 267. I could get channel 87.75, which is CBS, and it was around the news time. I don't know the exact time, but it was around 6:15 or 6:20, and I heard that Florida had been called for Gore. I heard the polls were closed in Florida, and I was very, very upset. I switched to another channel, NPR. They had also called the polls in Florida being closed, and being in the Central Time Zone, I knew the polls closed at 7, and this was like 6:15 in the Central Time Zone. I was so upset, I just couldn't say anything for 15 not 15, but about 5 minutes. And then I called my mother on my cell phone. So there is a record on my cell phone bill, which has already been mailed out. I don't have it with me, but it shows the time. And my mother she had heard on ABC. That's hearsay, but she did hear that it had been called.
Had you paid attention to what was going on in the election up to that point?
Yes, I had.
And have you paid strict attention since that time to everything that's going on in the election?
As close as I can.
And who do you know was the company that was responsible for the early call in Florida? Do you know?
I do not know.
Wasn't it Voter News Service?
I don't know.
All right. Would you tell the judge, last question, would you tell the judge why you as a voter in Bay County are concerned about this election contest that's going on in Lee County?
I do know that I know of a person that worked at some polls, and there was a definite change in the polls and the turnout, and for a major election, you know, it's surprising of that. And I know of one other person that did actually not go to vote, and I believe she's going to testify. I do know of other people saying they knew of people that did not vote because they heard the polls were closed and they didn't think it made any difference because it had already been called for Gore.
So you know there were valid votes that would have been made had the call not been made at least 40 minutes before the polls closed?
Yes, sir.
All right. Your Honor, I have nothing further.
Anybody tell you, like your lawyer or anybody, that you had a right to protest this election?
Objection calls for privileged information.
Okay. Did anybody tell you on your cell phone or otherwise that you could protest this election?
Objection to the extent it calls for privileged information.
I don't understand the basis of the woman could protest.
The last question was not related to any advice of counsel, as I understand it.
Well, you said anybody, Your Honor. Did anybody tell you?
Anybody other than
your counsel will tell you you can protest.
Your Honor, there's no statutory basis for her to protest.
Yes,
the
there
same
is.
way with the last witness. I mean, it may make a good press, but it makes no sense. She can't.
We don't think there's a statutory basis for it either, but it provides in the statute that an elector can file a protest, whether it's any good or not.
Not a protest, as I read the statute, this candidate, is that not, or does it say? Well, you know, it's any elector and or a candidate.
And an elector is a voter.
Your Honor, unless I'm missing the import of the pleadings that have been filed here, the position that is being taken by the interveners is that in terms of the totality of the circumstances in a voting contest, one of the things that should be taken into consideration by the court, since I'm sure the plaintiffs are going to be arguing very strongly equity, every vote should count except of course the ones in Nassau County and a couple of other places, that they're going to be making a strong equitable argument, and the position of the interveners is that the equity should also be considered for all the voters who did not vote because the election was called early.
I understand that, but this question was simply, did she understand that she had a right under the statute to file a protest? And I believe the witnesses said she did not.
I did not.
Okay. All right. Do you have any other questions?
And also the contest, I presume you didn't know you had a right to do that.
I did not.
Okay.
I don't want to reply to that about technicals and so on. We spent days arguing. They argued the other side of this.
All right. Thank you.
Any other questions, Your Honor?
Any other questions of Ms. Cruz? If not, may she stand down?
She may, Your Honor.
Thank you.
At this time, we call Jeanette Seymour.
Ask her to come forward and be sworn.
Please raise your right hand. You do solemnly swear that the evidence you shall give in this issue shall be the truth, the whole truth, and nothing but the truth, so help you God.
Be seated. You may proceed.
Would you please state your name?
Jeanette Seymour.
And Ms. Seymour, you currently live in Navarre, Santa Rosa County, Florida, don't you?
Correct.
And you're a taxpayer there?
I am.
And you were registered and qualified to vote in the 2000 presidential election in that county, weren't you?
I was.
Were you present in that county during the times that the polls were open?
I was.
Did you ever take the time to drive to the poll to vote for president?
During the daytime I worked. My plan was to go at 5 o'clock when I got off. I was delayed a little bit. It was closer to 6 when I got off from work, and on the way to the polls, my husband called me and told me that it was over, that it had been announced that Gore had won, and there was no point to vote. And so I turned around and went home.
Did you have plenty of time before the poll closed in order to go cast your vote?
I did.
Did you intend to vote for a presidential candidate when you got there?
I did.
Would you tell the judge why you, a Santa Rosa County resident, are concerned about this election contest proceeding over here in Leon County?
Because the media made a mistake and called the vote early, there's a lot of votes that were not counted, not just in the, my area, but the whole panhandle of Florida that should have counted. Whether they were for Bush or whether they were for Gore, they should have counted. And, other than the machines being, whether they were actually not working or not maintained correctly, that was out of the voters' hands, and so was this. It dilutes my vote.
And are you aware that your attorneys have filed a request with the court to do, if he orders anything, to order a statewide manual recount of all the undervotes and overvotes in the state of Florida?
I believe so.
Is that a concern of yours?
It would be a strong concern of mine.
And would you tell the court why?
Because in order to have a fair and accurate count of the votes, you have to consider everybody's votes and not just selected counties where they may have a strong Democratic outcome.
Thank you,
Any inquiry? Does anyone wish to inquire? If not, thank you, Ms. Seymour. You may stand down and be excused. All right, at this time then, I believe that that is everyone except the case will now go to the plaintiffs for rebuttal. Yes, sir.
If I could interrupt for a moment. Robert Zing on behalf of Steve Thrasher.
Yes, sir.
I don't want to be forgotten. You recall on Friday we filed a motion to intervene, a motion to dismiss, and Mr. Beck on behalf of Governor Bush and I discussed with you at some appropriate time during the hearing that we would have hearing on the dispositive motion to dismiss.
You would be entitled on the intervention to present in the final arguments, whatever it is. I suppose we'll take up I suppose the issues of your motion to dismiss is my recollection, but not in the context of this proceeding.
Yes, sir. We don't wish to put on any evidence. We wish to just have the argument at the appropriate time, and final argument at the appropriate time.
Well, let me finish with this case, and then I suppose if we need to do that, then we'll have a hearing on your motion to dismiss as soon as I can take all the evidence in this case. But right now, let me ask if the plaintiffs, Mr. Claiborne.
Your Honor, when Your Honor kindly allowed Judicial Watch to appear as an observer the other day, you raised the possibility that our witness, Kevin Haggerty of the CPA firm Johnson & Landworth, might want to be called by one of the witnesses or the court. We simply proffered him. We did file a motion to take judicial notice of independent expert's report and for leave to present testimony. If the party or the court would like him as a witness, he did make certain observations with regard to the vote in Palm Beach when we did that inspection earlier in the week. We just wanted to make him available for the court or the parties.
All right. Well, I didn't know. That's the reason I had left it up to you and the parties as to whether or not anyone wished to utilize any of the information that was available, and apparently neither of the existing sides have done so.
Thank you.
All right. Thank you, sir. Case will go to the plaintiffs for rebuttal. Call the first witness if you have.
The court.
Yes, sir.
We would first offer Plaintiff's Exhibit 61, which is a stipulation that we've entered into, and I think we offer this without objection.
Signed by, all right, by Mr. Berger, Mr. Greenberg, and Mr. Beck. I believe that's all the parties. Mr. Clark.
Our feelings aren't hurt, Judge.
Yes, sir. Let's see.
Fine.
Just
No objection.
sign on the bottom.
Our next witness is going to be Professor Hangarten. Perhaps you could approach the stand.
Yes, sir. Ask him to come forward. witness has been previously sworn, remains under oath.
This is a witness that has appeared before earlier in the Al Gore case. He's being called back as a rebuttal witness. We are nearing the end, but not quite there yet. Professor Handgarten back on the stand.
Hypothetical questions drawn from that testimony. First, there was some testimony, I ask you to assume, about a person who said that they voted in precinct 626 in Miami-Dade. And there was a question about undervoting in that precinct. From your review of the records, were there any undervotes in that precinct?
I have been told that there were no undervotes in that precinct, and I expect to have delivered in this courtroom.
Sustained. Hold on. Okay. He's got an objection to the form of the question, or he's been told. You're going to have to straighten that out.
Have you personally reviewed the statistics by precinct of the undervotes in Miami-Dade County?
Yes, I have.
And do I take it from your answer that you were checking on whether or not there were undervotes and how many there were in 626 because you didn't have that number in your mind?
Yes, that's what I'm referring to, sir.
And did you ask somebody to check that by looking at the figures?
Yes, I did.
And as an expert, do you frequently rely on people to check figures for you?
Yes, I do.
Your Honor, I'd like to object.
Do you wish to take the witness on board there?
Well, Your Honor, my objection is that the rebuttal case is not to rehabilitate your witness that has been impeached. The purpose is to rebut. This isn't a rebuttal. It's a rehabilitation.
Your Honor, this has nothing to do with rehabilitation.
He's directed this to other testimony today concerning precinct 626, as I understand it.
But, Your Honor,
that's exactly right, Your Honor.
Being introduced for the purpose of proving whether or not there was an undervote in 626. That is not the province of an expert. If he wants to prove that there were no undervotes in 626, he has to do it some other way.
All right, I'll overrule the objection. You may proceed. Give me the tally.
Were there any undervotes in precinct 626, sir?
There were none.
The second subject. I ask you to assume that there was testimony that in the Miami-Dade precincts that had not been subject to a manual recount, that is the so-called 9,000 votes that have not been manually counted, that the total vote for President Bush, or Governor Bush, and not President Gore, Vice President Gore. Let me start over again. I've got two presidents here, and in fact we have none so far. I ask you to assume that there was testimony that, with respect to the precincts from which those 9,000 uncounted or manually uncounted ballots come from in Miami-Dade, were precincts that in total, in the aggregate, gave more votes to Governor Bush than to Vice President Gore. Does that tell you anything about which of those two candidates is most likely to get votes if those ballots were counted?
No. Objection, Your Honor. Same grounds we've stated before. Any basis of selecting the president or any other candidate on statistical data we object to. The only evidence that is relevant is something that goes to something that to do with statewide figures, not on a county basis, Your Honor. We're not electing the county supervisor.
Note your objection. Would you restate the question?
Yes. I ask you to assume, Professor Handgarten, that there was testimony put forward by the defendants in this case that if you took all of the Miami-Dade precincts that had not been subject to a manual count, that Governor Bush would have gotten more votes from the machine count in those precincts in the aggregate than Vice President Gore. You have that assumption?
Yes.
If that were true, would that have anything at all to do with the statistical likelihood that Governor Bush would in fact get more votes from those 9,000 ballots if they were counted?
No, it doesn't.
Why not?
Because it depends on how the distribution of the number of undervotes in each precinct is related to the proportion of Democrats and Republicans, at least as measured by the machine count.
And did you look at that?
Yes, I did.
And what did you find?
There seems to be some association between number of undervotes and the political persuasion of the counties. In particular, there seems to be more undervote in Democratic precincts, not counties, precincts.
When you say Democratic precincts, are you talking about precincts in which there is a registration majority of Democrats, or are you talking about this particular election?
I'm using majority as a precinct. I say Democratic precinct if the precinct has more machine-counted votes for Vice President Gore than for Governor Bush.
And that is more machine-counted votes in this last election?
Yes, sir.
And using Democratic precincts in that way, that is, a precinct that returned a majority of votes for Vice President Gore in this last election, where are most of the undervotes that have not yet been counted?
That would be in the Democratic counties, sir.
Democratic counties or Democratic precincts?
Precincts. I'm sorry.
That's okay.
We're talking about precincts.
Okay. No more questions, Your Honor.
Beck?
Good evening, Professor.
Good evening.
Are you aware that of the statistical approach that was taken by the Gore-Lieberman legal team in the concerning the undervotes in Miami, the position taken in their complaint?
Objection, Your Honor. Outside the scope.
We're talking about the computation of the projection of undervotes in Miami based on the undercount. I thought that was one of the two subjects that was in the...
What we were talking about is exactly what we went through. It was not a projection from the complaint. It was direct response to the witness they put on.
All right. And objection. Rephrase.
Oh, okay. Mr. Boeis was asking you about improper methods to project the undervote for all of Miami based on the undervote total for the 20% that was manually recounted. You remember that?
Yes, sir.
And he was asking you about the significance of whether a particular precinct is a Democratic precinct or a Republican precinct, right?
Yes, sir.
Now, and you said that one of the things you have to take into account is that I think you said that there tend to be somewhat more undervotes in Democratic precincts than in Republican precincts, right?
Yes, sir.
But you still have to take into account whether the precincts are Republican or Democrat, don't you?
Yes, sir.
So that if some lawyer writes a complaint that says 20% of the ballots have been, of the undervotes have been manually reviewed, and they all come from heavily Democratic precincts, and then they say, and the way that you can project the total for the county is just to project that out times 5 to get 100%, that's just flat wrong from a statistical point of view, isn't it, Professor?
Objection, Your Honor. Back to the complaint, which you already have ruled out.
Your Honor, he opened
You've asked him about this.
That approach is just plain flat wrong from a statistical point of view, isn't it, Professor?
That is, taking the number of votes or the difference of votes and just multiply that by 5, because that's the calculation you're asking me?
Yes.
It is not an accurate prediction.
Thank you.
there anyone else? May the professor stand down and be excused. Without objection. Thank you. All right, call the next witness.
We have no more witnesses and we rest, Your Honor.
All right. At this time, what is your pleasure? Do you wish to proceed at this time with your closings? We can take a short recess so you can prepare your notes. Would it be feasible to start at 7 o'clock?
Yes, Your Honor.
All right. And let me suggest before you leave, can we get some agreement as to time? Would something like, is an hour sufficient for the plaintiffs and an hour, I suppose, for the Bush defendants? And will you need an hour, Mr. Clark?
No, sir.
Can we take that hour and allot you 15 minutes, each of the canvassing boards, I suppose? 15 minutes, so that'd be another hour, and then I have my intervenors, which are, well, let's see, how many hours have I just figured up?
I can help you, Your Honor. We'll waive any closing.
Oh, all right. Well, how many of my the canvassing board defendants wish to be heard in final
Nassau County.
closing summations? Nassau. Mr. McMahon?
We'll wait, Your Honor.
All right. Nassau still. All right. That's everybody? That's Palm Beach and Dade and Nassau.
Your Honor, 5 minutes to intervene, Butler.
All right. And who else did we have? Mr. Myers?
Approximately 10 minutes, Your Honor.
All right. Well, we can. That's 15 and 15. Well, total, you and Mr. Madigan then would be 15 for our intervenors, and then I have, who is it, Mr. Jennings? 10. And let's see, Mr. Gluck, you 30?
No more than that, sir.
30 minutes. All right, that'd be 30. Well, that's an hour, and we got 10 minutes on another, and then Mr. Vizina, I believe you had your motion, and it was my impression that the subject of your motion was something similar to the motion of the defendants Bush that I reserved ruling on, and subject to their renewal at the close of all the evidence. And I believe it was the earlier indication that Mr. He's gone. Mr. Richard had basically come up and said he would reserve on presenting the motion to dismiss and argue it at the time of closing arguments.
We do not propose to make any legal arguments on those motions this evening, Judge, and we'll rest on the papers rather than take the time to do that this evening.
Rest on which papers now?
Well, we submitted a brief on our motions to dismiss, and what I'm suggesting, Your Honor, is that rather than take up additional time on oral argument of those motions, we'll rest on the paper unless Your Honor wants to hear from us, and then I'll be happy to address it.
Well, that's up to you. And of course, the other side, you of course could stand on your motion and your memorandum in support of it. But I don't know if did you filed a response in opposition to that. I don't know if you'd want to stand on that. See, I don't want.
Judge, I'm going to want to be. I'm sorry. I'd like to be heard briefly on that when we come back. So I'll address briefly our legal motions, but I won't be.
I'm still
taking a lot of time.
I'm still trying to figure out where we're going to fit our last intervenor into this. And what type of time period are we talking about? 15?
Just very few minutes, Your Honor.
Very few? 10?
I don't think 10 at most, perhaps 15
down. All right.
Both sides, and I suggest it probably fits in well to do it at the same time, Mr. Beckers.
Well, that's what I thought we'd try to group you up. So we'll put you down at 15 or or less, and then that was Mr. Jennings at 10, and Mr. Clark had 30, and Messrs. Myers and Madigan had we're going to try to share 15, somewhere in that area, and Mr. Mullins had 15. All right, now, since I've used up another 20 minutes of your time, what time? How much time do you wish to take?
7 o'clock.
7 o'clock? 7 it is.
Your Honor, that we have 1 hour.
Yes,
Is that right? And what's the total time on the other side?
All right, 1 hour, 1 hour. Then Mr. Clark has 30, Nassau 15, Intervenors 15, Jennings 10, and Thrasher 15.
Your Honor,
So you can see that it's going to be a long evening in the courtroom of Judge N. Sanders Sauls. He has just set closing arguments to begin in 15 minutes. He is speaking some more. Let's listen again. Judge Sauls.
What was you talking about?
Yeah, I'm talking about when we argue and then they argue, we feel we would be entitled to some time to rebut all these arguments.
Well, you've got the right to close. How much time would you like?
Probably 30 minutes. Half an hour.
30 minutes.
Yes, sir.
Very good.
As Wilson Pickett once said, it looks like it's going to be in the midnight hour before things are done in the courtroom of Judge N. Sanders Sauls. By my count, we're up to 3.5 hours, is that right, of closing arguments, which began in 15 minutes. This is Fox News coverage, continuing coverage of the contest trial going on in Tallahassee, Florida. We're going to take a quick break, come back with some experts telling us what's going on there, and then back for the closing arguments beginning in about 15 minutes. Stay with us. We'll be right back.
You know, some mornings this is just too much. Especially when it's cold and nasty outside. But you're my pal. You're always there for me, unlike some people. And I'm not gonna let you down. Come on, man, let's go outside. So, Cosmo, got any big plans for today? There you go.
Fox News Channel, powerful all day. John Scott, Bridget Quinn, David Asman, bringing the world to you, making the issues clearer. Powerful hour to hour. Linda Vester, Shepard Smith, Neil Cavuto. Breaking stories, aggressive coverage. Powerful all day, fair and balanced. Fox News Channel, the most powerful name in news. We report, you decide. Power. You want to make the right choices. We give you the power to decide for yourself. Power. 24 hours, 7 days a week. Nobody gives you more original live programming. The power of news to keep you up to date. Shows that go in-depth. Issues in context. Topics that matter to you. The power of Fox News Channel. News and information, fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide.
Come first to Fox News for breaking news, exclusive stories that impact the world. Unique, timely interviews that shape our nation. First on the scene with breaking news. Continuous coverage from over 70 bureaus around the globe.
We're the only ones here who still have live pictures out.
Reporters, anchors, and correspondents that are first, fair, balanced. Powerful insight, powerful perspective, powerful news. Come first to Fox News for breaking news.
感動、興奮、見たかったものがここにある。エンターテインメントチャンネルといえば FOX しかない。華麗なトリックの裏側を仮面のマジシャンがついに全て公開。破られたマジシャンの掟。謎に包まれたストーリー。真実を知るのは今。X ファイル特別版モアシークレットファイル。あまりにも無力な人間。追跡、生死を分けた大暴風。生き残りをかけてかつてないバトルが繰り広げられるワールドレスリングフェデレーションスペシャルサバイバーシリーズ。救いを求める人を放ってはおけない危機一髪世界の救出劇。 ニュース番組の裏側を描いたブロードキャストニュース、ドラマを超えた衝撃、ツインピークス劇場版、マイケル・キートン主演のマシンガン・ジョニー。12月も話題作続々、FOX ムービー。感動と興奮がここにある。本物のエンターテイメントはいつも FOX から。
Hi again, everybody. I'm John Gibson. We continue to watch the action in the courtroom of Judge N. Sanders Sauls in Tallahassee. This is a trial. It is Al Gore's contest of the election in Florida. He is trying to get at least 13,000 undervote ballots counted from Miami-Dade and Palm Beach County. And, of course, the Bush side wants none counted, but if they're going to be any counted, they want all of the ballots in those two counties counted. We have been watching the testimony in court. Let me go now to our legal editor, Stan Goldman. Stan, let us not waste any more time on those interveners, okay? I don't even want to talk about them. They got their 2 minutes of fame, whatever it was worth. End of story. I guess the judge, because he's a patient man, has to listen to them. What was important in what we have seen this afternoon?
Well, what was important this afternoon, I think actually this morning was the most important, and that was the fact that pursuant to a judge's question, we had a Bush expert witness basically say that in close elections, hand counts of these of these punch ballots are very important. And that was the first time I thought in the entire trial I actually got an inkling that I thought the judge might very well end up ruling in Gore's favor on the question of recounting the votes in Dade County. I don't know if he's going to do it or not, but it's certainly the best argument the Gore people have.
Yes, it is a good argument, and it did seem to be a bad moment for the Bush side. However, also weighing on the judge's decision are two factors. One is that a flaw in the voting machinery is a reason for a recount, but a voter error is not. In other words, if the machine is bad and caused the voter to not be able to cast their vote as they would like, that would be a cause for a recount. However, just the voter making a mistake is not, right?
Exactly, and the burden is on Gore's side to prove that.
And the other is that a recount could change the result of the election. Those are two very important factors weighing on the judge. Now, we've heard testimony on both those points. Your analysis of the testimony on those points, please.
Well, first of all, we do have the argument that these machines as set up perhaps don't count all the votes and that a recount is needed. Now, the judge or the Supreme Court of Florida, whenever they eventually have to rule on it, is going to have to decide if you don't actually tear it off and you don't do it properly, you don't push it all the way through so the chad comes off, are you, as the voter, making a mistake, or has the state provided you with a system of voting that is, in a sense, faulty with respect to some votes? And I agree with you. That's a very close question. Gore does have the burden in it. I, up till this morning, actually thought that the judge would not order a recount in Dade County till pursuant to his question. We got that answer back from the guy who owns the patent on these things. So that made me believe that perhaps, for the first time, Gore's got a chance of getting a recount by saying, hey, it may very well be the ballots and not the voters.
Okay, now, Stan, looking ahead, I mean, we've got by my calculation, upwards of 4 hours of closing arguments coming up here in about 8 minutes. Give me your sense of what it is David Boeis and the Gore team are going to argue here.
Well, they're going to argue that we've got experts who say there is a problem. We've got a law that says that, you should have hand recounts. That's a law in Florida. They're going to say, look, it will make a difference in this case. The reason why it'll make a difference, and this is going to be one of the keys to their argument, is the vote is so darn close now. I mean, if you count the 215 votes in Palm Beach that weren't counted because they came in about 2 hours late, and if you count the 157 votes that we already know exist in Dade County for Gore and weren't counted, and you count the rest of these, all you need is a couple of hundred votes, and suddenly he overcomes the 537 vote lead by Governor Bush, and therefore you ought to recount because it could make a difference. That's their argument. Of course, as we've heard several times, there are a lot of very strong Republican precincts that are yet to be counted in Dade County. So whether it's actually going to make a difference in the long run, especially if they don't count dimpled chads, I find it hard to believe this judge is going to order that, it may not make much of a difference because Gore may only pick up a handful of new votes, if at all.
Stand by. We're going to take a break. When we come back, we're going to check in Austin, Texas at the Bush camp, in Washington, D.C. at the Gore camp, and we continue to wait for arguments to begin. And the judge in the courtroom, Judge N. Sandersall, closing arguments in the contest trial of Al Gore, trying to upset the election results in Florida. We'll be back. Florida's decision continues after this quick break.
Hey, kid, come on over here. I want to show you something. I want you to listen to me now, okay? Because you got to get this ready or else you're never going to make it. Now, if it goes over too much way this here, it's no good. If it falls over this way too much, it falls all over you. You got to make sure you got balance.
Balance?
All right.
Fox News Channel Daytime. You want to make the right choices. We give you the power to decide for yourself. Fair and balanced. The most powerful name in news. Fox News Channel. We report, you decide. You Decide 2000. Exclusively on the Fox News Channel. Powerful coverage. From America's election headquarters. John Scott. Bridget Quinn. David Asman. Linda Vester. Shepard Smith. Neil Cavuto. Fair and balanced reporting from America's election team, giving you the power to decide. You Decide 2000. From the most powerful name in news, Fox News Channel. We report, you decide.
Fox presents 科学分析プロー危険人物関与目撃証言消去だが真実はそこにある X ファイル on Fox さあスカリー行くぞ2人の FBI 捜査官が挑む世界の裏側の巨大な謎
I think that we've succeeded in doing that first and foremost. It's become a lot of other things, but I think it is a scary show.
X ファイル全米のメジャーなテレビショーを連続受賞
The X-Files has really caught on because I think people around the world like to be scared.
X ファイルその魅力は今も世界中にファンを生み出し続ける
X ファイルよくできてますよねもっと続けて来週はどんな話なんだろう見ればハマる
テレビ史上真実が知りたいかつてない答えを見つけて進化し続ける最高傑作真実はそこにある目撃者はあなた X ファイル毎週月曜夜10時 Only on Fox
Fairly quiet all weekend long until a few hours ago when the Gore team essentially called up 60 Minutes and said, hey, why don't you send a camera crew out to the vice president's residence? He'll give you an interview. That has happened. From early reports, it does not seem as if Vice President Gore did anything earth-shattering in that interview. It's scheduled to run shortly. He did plead once again for patience as this process unravels, or unfolds, I should say, and also said that if that time comes that George W. Bush should be sworn in as president, he would be my president, he would be America's president. That's a quote. Until then, it had been, as I say, a fairly typical post-November 7 weekend for the vice president. Saturday saw him venture out with his family on the streets of Washington, D.C., and Sunday saw him this morning entering and exiting church. The vice president attended services at Mount Vernon Baptist Church in Northern Virginia this morning. Besides waving and smiling to onlookers, he had nothing to say to the reporters camped outside. However, yesterday, the Democratic nominee enjoyed a private lunch at his residence with his old Harvard roommate, actor Tommy Lee Jones. And a little while later, he, wife Tipper, and daughter Kristen stopped by a coffee shop in Northwest D.C. Vice President even buying coffee for members of the news media, even our own Fox News cameraman. There you see it, handing it to him. But Gore wasn't there to talk. The only thing he had said at that time was that his legal effort was making, quote, quiet progress. Now, Gore advisor Warren Christopher sounded a slightly less optimistic note earlier today on CBS News. This may have prompted Gore to call up 60 Minutes later this afternoon. Bob Schieffer had asked Warren Christopher earlier today, quote, if the U.S. Supreme Court rules against you down there in Florida, then will Al Gore say it's time to go? At first, Christopher noted there were two other proceedings going on, the one we have been watching in Leon County Circuit Court and the one in Seminole County over some absentee ballots to which the Gore campaign is not technically a party. But then Christopher suggested that a concession from Al Gore is just a matter of the right time coming. Listen.
So, as I say, it's late innings, but it's the contest is not over. I can assure you that the Vice President, when the time comes, will concede in a very gracious way. He understands his obligations to the people of the country.
At the same time, Christopher confirmed the Vice President would plan to appeal any adverse ruling from Judge Sauls down there in Leon County, and that further legal action could also be in the offing, even if Gore receives an adverse ruling from the United States Supreme Court. Now, reporting on the Bush campaign, let's go to Austin, Texas, where my Fox News colleague Carol McKinley is standing by. Carol.
Thanks a lot, James. I don't have any magazine shows to tell you about that George W. Bush will be on tonight. In fact, they'd be hard-pressed to find him. He's holed up at his ranch about 2 hours north of here in Crawford, Texas. The place he hopes, if he's president-elect, will be the Texas White House. So he spent the day in the country. Dick Cheney, though, spent the day in the city working hard. He was doing the media rounds and working in the transition office in McLean, Virginia. In fact, he was on one of the Sunday morning shows today and had this to say, a message to Al Gore.
I do think that it's time for him to concede. So far, he's chosen not to do that, to pursue other avenues, and clearly that's his prerogative. But I think long term, I think history would regard him in a better light if he were to bring this to the close in the very near future.
And if you want a job, I've got some news for you. The Bush camp is looking for some energetic souls. This website tells you how to get an application to work for the Republican Party. It's at www.bushcheneytransition.com, and there is a warning. If you want to work, there will be long hours, low pay, and you have to have integrity. And if selected, you'll have to supply your financial and legal backgrounds. Now, of course, the same criteria might be said for those that they'll be choosing for cabinet should Bush become the president-elect. And today, Cheney also said on some of those TV programs that he's assuring us all that that cabinet is underway for being chosen, and that once it is, it'll be very diverse, both politically and ethnically. John?
Carol McKinley and James Rosen, thanks to you both. I think Judge N. Sanders Sauls would say, not so fast. We have closing arguments. They're coming up in just a couple of minutes. Stay with Fox News as we continue to cover not only Florida's decision, but the contest of the decision brought by Al Gore. We're in the home stretch here. Your primetime viewing tonight. 4 hours of arguments in Judge Sauls' courtroom. You don't want to miss a moment. We'll be right back.
You Decide 2000, exclusively on the Fox News channel. Powerful coverage from America's election headquarters. John Scott, Bridget Quinn.
307円81銭、1円11
America's election team, giving you the power to decide. You Decide 2000.
777の翼の大きさだということです。また遠隔活動で
pieces of hardware that have to work properly to make these huge solar cells work well. And they're trying to get those fired up before they unfurl the solar arrays. NASA is telling us it will not be a significant delay, not a showstopper is the word that was used just a moment ago, but nevertheless, a bit of a delay in unfurling these solar arrays. It will be quite a sight once that happens. Now, let's take a look at some pictures which have come down over the past 6 hours or so. We've had a bit of a unique perspective all throughout this spacewalk. The spacewalkers have had cameras mounted to their helmets. This is a first ever for a shuttle spacewalk, and those helmets have been able to capture live images like you're seeing right here. This is a spacewalker's view of things, grabbing handholds with those $10,000 gloves as they work their way along the radiator structure on these solar cells. In the course of that, they spent a lot of time with cordless drills, undoing bolts and launch restraints that kept it stiffer for the ride up to orbit. There you can see that's Carlos Noriega there, and you have Joe Tanner's hands in the foreground, the two of them working. Once again, that ability to see what they're doing up close and personal is unusual. And before he left, Carlos Noriega told us a little bit about it.
Well, for the first time, you'll have the point of view of the EVA astronauts available to you. There's 3 different cameras with 3 different lenses, so they can optimize the camera selection for whatever they need. If I have say a connector with a pin that just doesn't look right, I can actually hold it up to the camera that's above my head and let a ground controller on the ground see immediately what I'm talking about, as opposed to trying to describe something that may be difficult to put into words, but very simple to show visually.
And just to help you out with the NASA acronym there, EVA is NASA vernacular for extravehicular activity, which is what you and I call a spacewalk. Back to these live pictures now once again. Here once again is Joe Tanner, appearing to be upside down, but bear in mind in space there is no up or down, so he's just working anyway, which suits him well. He's working near a restraint, which is at the end of the 50-foot robotic arm, which is attached to the Space Shuttle Endeavour. This camera is at the base of Endeavour, looking up at the structure of the International Space Station. This is a truss which was attached during the last mission, and this is the portion that was just put on during this spacewalk today. The joints were here. They connected several bolts. It is now officially a part of the space station. I don't know if you can see, but over here in that little corner there's Carlos Noriega. He's doing his tasks as well. These 2 items right here are part of the mast structure, and from them will extend some 70 meters across in all the solar arrays. That is supposed to happen soon. When it does happen, almost instantaneously, the International Space Station Alpha will become one of the brightest objects in the sky. If you look up in the sky, you know when and where to look, usually in the pre-dawn and post-sunset hours. You will see the International Space Station streaking by. It will be very unmistakable and very bright because these large solar arrays, the largest man-made structures ever deployed in space, will catch the sun and provide a stunning reflection. Once again, the spacewalk going well. A bit of a delay as the NASA ground controllers in Houston work through a few minor, as they are characterizing them, hardware problems. The spacewalkers doing well, as you see. There they are, the 2 of them, doing their job, and we will keep you posted as this spacewalk, which is perhaps the most...
Both lawyers for each camp, the lawyers from both of the sides, trying to get the best kind of answers that they could. As for the decision, who knows? It could be quick. Certainly we know that a lot of people would like this resolved. There's been a growing sense of fatigue, certainly in polls, among people in the public, hoping that this can get to some kind of an end game. John?
Chris, stand by there for a second. Stan Goldman is still with us. Stan, I rushed to ask you a question just because we have no idea when the judge will take the bench again and arguments will start. Just your guess, with this voluminous material that has come before the judge and his quite heavy responsibility in this decision, how long does it take him to make a call here?
Well, chances are he's not going to make it from the bench tonight, and if he doesn't, which he probably won't, obviously, he's going to have to consider it and probably write something out. I mean, the idea that he'd come in tomorrow morning at 10 or 11 and just issue an opinion doesn't seem real likely. On the other hand, if he doesn't do that, then you start to run into a real time problem in terms of starting the counting if he's going to rule in Vice President Gore's favor. If he's going to rule against Vice President Gore, then the Democrats immediately take an appeal as quickly as they can to the state Supreme Court and try to get some ruling immediately. But boy, I've got to tell you, if he hasn't ruled by the end of tomorrow, I can see Vice President Gore filing again petitions to start the hand count regardless of which way he plans on ruling, on the off chance that the state Supreme Court may in fact decide in his favor, in Gore's favor. Because, I mean, what are you going to do? It's, you know, it's only a week from tomorrow that is the 11th of December, and if we consider the 12th as a due date when all this has to be settled, we're running up against some problems.
All right, Stan, judge is back on the bench. Argument's about to begin. Let's listen to Judge N. Sanders Sauls.
believe we outlined our tentative time schedule after having a few minutes to review it. Let me poll council. Do you feel that's sufficient for all parties so we can have that on this record? This is satisfactory to all parties. All right, then let's proceed.
May it please the court.
Yes, sir.
First, let me say that all counsel appreciate bringing this case as rapidly as you could to a conclusion of sorts here today, at least in this court, as we go forward from here.
Cooperation of highly skilled counsel, sir.
Thank you. I did want to start this by saying one thing that doesn't at all relate to the argument, but this morning I received from my 19-year-old granddaughter some inspiration thoughts which she sends me. And first she quoted Proverbs when she says, all cats are gray in the dark. Now, I don't mean to say that this case reminds me of Proverbs, but it certainly gives us a start here as we go, because we are after dark. And then she also sent me another one from Proverbs, which said, the best of men are but men at best. And I trust when we end, we'll be the same way. Then she sent me a personal one that's based on Psalms, which I'm going to keep private. But it reminded me at least of the great burden that we have here today, that Your Honor has and all counsel, and how hard everybody's worked to try to get a just result for their clients and for others so that we do arrive at what can be a good decision to move this case to the end. And I'd like to point out to the court that the balance of the argument, with the exception of the Nassau County matter, will be argued by Mr. Boeis. And I will just briefly touch on Nassau County to point out that this is not a case where there's some technical application of this statute. This statute is designed to protect the integrity of the vote, and that's to keep people from saying something was done when in fact it might not have been, but it would give the appearance that the election had been manipulated or changed or something of that nature. And that's why there is a provision that says there shall be no person on the commission considering the election who was in the election as a candidate. And it doesn't say may or otherwise, it says shall. And that's 102.141 of the Florida statutes. And it also provides other ways to appoint a substitute member when you have to have one. It can be appointed by the judge rather than having the county commission do it if that's necessary, particularly when it's a critical matter. That's not a fatal error here, but it is pointed out that it's very, very important that we keep the appearance that everything is done correctly for the public and everybody else. I don't think anybody, in particular this lady that testified here today, was trying to do anything wrong, but unfortunately I think they did a lot of things wrong that violate the statute, all of which raise the issue of there could be impropriety, not that there was. So those statutes have to be strictly enforced to preserve the integrity of all the ballots in that county, in all of the elections in that county. And I would like to point out that there has never been a recount of these votes of any kind. What happened, there was a recount at the night after, statutorily required, and then without public meeting or without any other thing, this group decided that when they got down to the time when they had to send in the final certification, that my goodness, we've got to not recount these, but we somebody looked at this, not out in a public meeting or anything, and said, gee whiz, we counted these wrong. And therefore, they called the Secretary of State, and I'm not inferring because they are Republicans, but this was a Republican benefit that occurred, that they advised her incorrectly that she could, or the canvassing board could, amend these returns without any prior recount or recertification of any kind. and then they turned around and certified the first count without, in effect, performing the required mandatory recount by the statute. We think that means that these 51 votes that were taken away in order to preserve the integrity of the system, of the integrity of the counting of the ballots, must be allowed to stand. To do otherwise would always hang a cloud over this county as having, in effect, counted them favorably to the big majority voters in that county, to the detriment of the others who chose to vote for other candidates. And therefore, we suggest to the court that that is a fairly straightforward issue of law, which is pretty well covered, or very well covered, in the stipulation we filed, plus the other explanations that were made here. With that, Your Honor, I will preserve time for my colleague, and may I say, which I'm sure the court agrees, that Mr. Boeis has been, for us here in Tallahassee and Florida, a real pleasure to have in our community, and the following that he attracts is well deserved. And in fact, he can put up with me as co-counsel, then he deserves accolades given from everyone, and I have thoroughly enjoyed it, and I'm very pleased to present him to the court to present our closing argument on behalf of Vice President Gore and Senator Joseph Lieberman.
Thank you, Mr. Douglas. And let me point out that the clerk has the clock. Mr. Boeis.
May it please the court?
Yes, sir.
I want to begin by going back to what I said in my opening yesterday. And that is to remind the court that this is, as the court well knows, a contest action under Section 102.168 of the Florida statutes. It is not a protest action under Section 166. It is not an application for a manual recount under Section 166. It is a protest. And it's terribly important to keep in mind the difference between 166 and 168 in this regard. Section 166 talks about manual recounts, and it talks about the obligation of a canvassing board to consider the possibility of a manual recount, to make a decision as to whether to do a sample, if the sample turns up enough votes to be meaningful to the election, to then undertake a mandatory recount of all of the ballots. That is not what is involved here. What is involved here is a question of a protest that the plaintiffs have made with respect to particular counties and particular ballots. There is nothing in 168 or in any precedent that says in order to have an election contest in a statewide election, you must count all the votes. Indeed, there are many, many cases of election contests under Florida law in which the courts have counted far fewer than all the votes. Sometimes as few as 2 or 3 or a dozen or 20. Sometimes several hundred, sometimes several thousand. But we are not aware of any authority, and I'm sure that if the defendants have any authority, they will cite it to the court, that says that in a statewide election, in order to have a contest, an election contest under 168, you have to recount all the votes. Let me turn to the issues that we have contested. And let me begin with Palm Beach County, because I think Palm Beach County ought not to take a lot of time given the record that we have established. First, the court will remember that Governor Bush's counsel told the court earlier this week on the record that they did not have any problem with the way Palm Beach County had conducted their recount. They thought that Palm Beach County had exercised their discretion properly. And the court heard Judge Burton testify that they had identified 215 net votes for for Vice President Gore and Senator Lieberman as a result of a recount analysis that was designed to determine whether they could ascertain the clear intent of the voter. And the court heard Judge Burton, called by the defendants, testify that they had been able to identify the clear intent of the voters, such to add a net 215 votes to Vice President Gore. There is no contrary evidence. There is no evidence in this record that suggests that those 215 votes are not legal votes that need to be included. And those votes are, of course, votes that are not included in the certified results. So we begin with 215 votes that the record is now undisputed are legal, valid votes in which the intent of the voter has been clearly demonstrated. Now, it is arguable whether or not those votes should have been included by the Secretary of State on November 26th. We obviously think they should have. We think that the Florida Supreme Court decision compelled the Secretary of State to accept at least the votes that were certified as of 5 p.m. on that date. We think the Supreme Court's decision a dozen years ago in State against Chappelle compelled the Secretary of State to accept returns that were 90 minutes, 120 minutes late. But whether we're right or the Secretary of State is right is fundamentally irrelevant at this stage. Because at this stage, the question is not, should those votes have been certified or not? Should they have been included in the certification? The question here is simply, are those legal votes that have not been included? And there can be no doubt that they've not been included. Everybody says that. And now there cannot be any doubt that those votes are legal votes. You have the uncontradicted evidence from Judge Burton, and you have the statement from Governor Bush's counsel. Now let me turn to the Palm Beach County votes that we do contest, the 3,300 votes. Those are votes that we have asked the court to review and make a judicial judgment on as to whether, under the law of Florida, the intent of the voter can be discerned from those ballots. And one of the issues that the court has been presented with is whether or not this court has to apply an abuse of discretion standard or whether it looks at that question de novo. And the court is aware that we believe that that is clearly, under Florida law, a judicial question to be decided de novo. And you have both the statute and case authority both going in the same direction. As the court knows, we rely on a long string of Florida Supreme Court decisions, not necessarily beginning with State against Williams in 1929, but certainly including cases at least back to 1929. We've also relied on State against Smith in 1932. And in that case, the Florida Supreme Court expressly stated that the ballots were the best evidence of how the contest should be resolved, and they were to be looked at as original evidence by the court. That's at 144 Southern at 336. That's State against Smith. The site is 144 Southern 333, and then the particular portion that I'm referring to is on page 336. In 1936, the Supreme Court decided Peacock against Latham. And again, the Supreme Court held that, indeed, it and the Circuit Court had jurisdiction to do an original count of the ballots themselves. Jumping to Beckstrom 2 years ago, in that case, the Supreme Court approved what the Circuit Court had done, and in that case, as this court knows, the Circuit Court had delegated to the clerk of the court the process of counting the ballots. And I want to take a detour for just a moment on Beckstrom, because the court has heard a lot about voter error. And there's been a suggestion here that in contest actions, if the court finds voter error, but nevertheless can discern the voter's intent, the court should disregard that voter intent. Now, there's never been a case that says that in Florida. There's nothing in the statute that says that. But defendants' counsel continue to argue that voter error somehow is an important concept to this litigation. We believe that Beckstrom should have put that to rest once and for all. Because in Beckstrom, the ballots that were at issue, the ballots that the Supreme Court ordered to be counted, were ballots in which there was unquestionably voter error. Just as the voters of the punch card counties have been told, punch all the way through, dislodge the Chad, get rid of it entirely, the voters in Volusia County, involved in the Beckstrom case, were told, fill in the bubble, fill in the circle with a number 2 pencil. But they didn't do that. Voter error. A voter error that made their ballots unreadable by a machine. But the Supreme Court didn't say, well, we throw those out. They didn't even say, we've got to look at all the ballots in the county. What the Supreme Court said is you look at these particular ballots that are the subject of the contest, and you determine, regardless of voter error, whether or not you can discern the intent of the voter. And the Supreme Court found that the Circuit Court was right, and that the Circuit Court could discern the intent of the voter, and so those ballots had to be counted. Now, in addition to this unbroken line of Florida precedent, you have the language of Section 168 itself, which casts a protest action and a contest action not in terms of a abuse of discretion standard for the contest action, but in terms of an original action before the Circuit Court. And it says the Circuit Court has to make the judgment. In the protest procedure under 166, discretion is given to the canvassing board. But in the contest section, 168, which of course is the section that is applicable to this proceeding, there is no provision for discretion in the canvassing board. There is no concept of abuse of discretion. There is no threshold requirement. So that Section 168 is consistent with State against Williams, State against Smith, Peacock against Latham, the Beckstrom case, and all the other cases that we've cited to the court, in providing that this is a question for judicial determination. Now, it might be possible for the court to put that question off because the court is going to have to look at the ballots, whether it is an abuse of discretion standard or whether it is a original judicial decision. The court is also going to have to look at the Miami-Dade ballots, the 9,000, because there's been no discretion exercised. No one's even looked at those even once. But we would urge the court to directly deal with the issue at the earliest possible stage as to the appropriate standard to be applied, whether it is abuse of discretion or whether it is this is a original judicial determination that this court in the first instance has to make. And we do that because we think the law is clear and because we think that that will simplify the issues in terms of the ballot review and the ballot count. So with respect first to the 3,300 ballots in Palm Beach, which are the first group of ballots that we've presented to the court for contest and for counting, we think that that review ought to proceed as expeditiously as possible. Now, part of what the court will want to take into account, perhaps, is some of the evidence that the court has heard. The court has heard witnesses not called entirely by the plaintiffs, but witnesses called from the defendants as well, who have told the court that in a close election, a manual recount is the only way to be sure of how certain contested ballots should be counted. You've heard testimony from Judge Burton of the many kinds of ways that the Palm Beach Board found that people had not exactly followed instructions, about how sometimes they put it on top of the throat instead of in the throat, about how sometimes they don't punch it all the way through, about ballots that for whatever reason were dimpled in every race or dimpled in several races. So there was unquestionably a lot of ballots from which voter intent could be discerned, but the machine could not read them, just like in Beckstrom. Was it because of voter error? Was it because of inadequate instruction? Was it because of inadequate time? Was it because of a buildup in the Chad? And the court will remember that box almost chock full of Chad. And remember, that wasn't a box we selected. That was a box that was set up by the Canvassing Board. The court will remember the stipulation in which Miami-Dade agreed that it had not cleaned out the Chad in those machines for 8 years. Machines that are used for a variety of state and federal elections and even union elections and other elections. Whether it was because of those factors or any other factors, we respectfully submit to the court is not really the question. What is important is that we now all know from the record in this case that in a significant number of instances, not even 5% or 10%, but down at the level of 1 or 2%, maybe not enough to make a difference in most elections, but many times more than enough to make a difference in this election, you have ballots that for whatever reason are not machine readable. Whether it's the people or whether it's the machines, and we've submitted, we think, a lot of evidence that it's not the people, that it is the machines, but whether it is the people or whether it is the machines is not the critical question. The critical question is, are there votes out there from which a review of the ballot can discern the intent of the voter? A manual review of the ballot can discern the intent of the voter that the machine can't read. And we know that. We know that from the Beckstrom case. We know that from Judge Burton's testimony. We know that from the testimony of the machine expert that the defendants made. We know that from the expert that we brought on election procedures and the operation and characteristics of these machines. We know it from essentially every piece of evidence that we have that there are ballots that the machine cannot read, but from which the voter intent can be discerned by a manual review. Now, is that a lot? Depends. It's not hundreds of thousands. It's not tens of thousands. It may not even be many thousands. But it is certainly many, many hundreds and perhaps thousands. And that is far more than enough to make a difference in this race. If you have only a fraction of 1% of ballots from which you can discern the voter's intent, but the machine cannot read, those ballots are sufficient to change the result of the election and certainly to place that result in doubt. The standard of a 168 contest action. Let me turn now to Miami-Dade. And in Miami-Dade, we have two groups of ballots. We have the 388 ballots that the Miami-Dade Canvassing Board counted. And the court has heard from witnesses who may have agreed or disagreed with individual decisions that the Miami-Dade Board made. But every one of those witnesses testified that they thought the Miami-Dade Canvassing Board were competent, honest people doing their very best to identify the intent of the voters. And they were succeeding in identifying the intent of the voters. We brought in a statistical expert. They brought in a statistical expert. Both of them agreed on the arithmetic. They differed about what the consequences of that arithmetic was, but both agreed on the arithmetic. And the arithmetic is very telling. In the precincts that were reviewed in Miami-Dade, Miami-Dade Canvassing Board was able to discern the clear intent of the voter in between 1/4 and 1/5 of the ballots that the machine did not read. That was sometimes referred to as the recovery rate, in the sense that they were recovering ballots that would otherwise have been lost. But however you describe it, you have a situation in which Miami-Dade was able to discern the clear intent of the voter in between 1/4 and 1/5 of all of the ballots that the machine could not read. I think that there cannot be any doubt about those 388 ballots, just as I believe there cannot be any doubt about the 215 net votes for Vice President Gore that come out of Palm Beach. Because in each case, you have a group of ballots that have been gone through and the clear intent of the voter has been discerned. However, I will agree that there is one distinction between the 215 ballots on the one hand and the 388 ballots on the other hand, between the Palm Beach situation and the Miami-Dade situation. Because in the Palm Beach situation, we have undisputed evidence, and indeed we have the agreement of Governor Bush's counsel, that the Palm Beach board was applying the right standard, was exercising its discretion properly, and that those votes truly represent the clear intent of the voter. We don't have that concession with respect to Miami-Dade. And so it may very well be, because this is a judicial question, that in the absence of that undisputed evidence and in the absence of that concession, the court may have to look at those 388 ballots. We think that review can be done expeditiously because we think that the court will find that those ballots are extremely clear examples because of the spade work that Miami-Dade has done. But we do recognize that there is a distinction between the Miami-Dade ballots on the one hand and the Palm Beach ballots on the other in terms of what's already been counted. The second group of ballots in Miami-Dade are the 9,000 ballots that have never been counted by a human being. These are the ballots that have been counted only by a machine, and the court knows from the undisputed evidence before the court that the machine is going not to count a significant number of ballots from which the clear intent of the voter can be discerned. You know that from their machine expert and our machine expert. You know that from Judge Burton. You know that from the recovery rate of Palm Beach County and of Miami-Dade County, and to the extent it's in the record, of Broward County as well. So what needs to be done with those 9,000 ballots? We think the answer is obvious. They need to be counted. They need to be reviewed. These are ballots as to which even the abuse of discretion argument that the defendants make has no place. These are ballots as to which the bending, manipulating, shaking argument that they make has no place, because these have not been counted manually by anybody. So that these are ballots that we respectfully urge the court clearly must be counted and ought to be counted as promptly as possible. Let me turn to, just briefly, to Nassau County, which is the issue that Mr. Dexter addressed. And in that connection, I want to emphasize Section 141, 102.141, which deals with the canvassing board's duties, and particularly subsection 4 of that statute, which provides that there will be an automatic manual recount in the event that an election is sufficiently close, which it was here. And then the last sentence of that subparagraph says that if there is a discrepancy between the election returns and the later tabulation, the machine recount, it is that later tabulation that controls. That's what the statute says. Now, that doesn't mean it would be impossible to have a later tabulation as part of either a protest or a contest. You could have a situation in which you had the original machine count and then you had the statutory recount, and then somebody said that statutory recount is wrong. We believe it's wrong. And so we're going to contest those results, and we're going to ask to have those ballots counted again. That's possible under the contest statute. But nobody did that. What they did was, first, the people in the county tried to get some guidance. They said, well, what are we supposed to do? And the Secretary of State's office says, well, you can just disregard the machine recount, the statutory, mandatory machine recount. Now, that was advice that was flatly contrary to the statute. What they did not say is you can have a contest, you can decide to recount those ballots again, you can try to correct the error, you can open up those sealed boxes and try to figure out what those votes are. They didn't do any of the things that they could have done. What they did was the one thing that the statute prohibits them from doing, which is to go back to the election night returns without any verification that those are the right returns. Because, Your Honor, all we know is that there is a discrepancy. And the witness from Nassau County comes in and says, we lost these 200 votes. But I don't know why. I think maybe they were upside down, but I wasn't able to check because the boxes were sealed and I couldn't get anybody to agree to let me unseal them to look. So what you have is just a speculation that maybe the first number, because it is higher, is right. And yet the statutory direction is that when you have a discrepancy, you pick the mandatory machine recount. The statute doesn't say, well, take the mandatory machine recount if it's higher. But if it's lower, go back to to election night returns. You might have had a statute like that, but we don't. There is nothing in the statutory scheme that suggests that just because the election night returns were higher, a county canvassing board is permitted to take those returns as opposed to the later filed returns. And there was certainly a time when I think everybody recognized that in Nassau County. Because not only were the machine recounts certified, they were faxed on Tuesday, they were sent on Wednesday, and certainly they knew then that the second count was lower. But then when the absentee ballots were counted, the overseas absentee ballots were counted, they again sent in the old figures. That is, they didn't correct it then either. It was only after Thanksgiving that, acting on what they thought was the advice of the Secretary of State, they went back to the election night returns. And they did so without any statutory authorization, without any precedent in their favor, and without any factual investigation as to exactly what the ballots in the box would show. Now, this doesn't mean that every time you've got a machine recount, that's the end of the story, because the statute provides for a contest if somebody believes that that mandatory machine recount is in error. But they didn't do that. They simply went back to the first election night returns without any basis and in violation of the statute. So we think that with respect to those 51 or 52 votes, that too is a question that on this record is a question of law, that there simply aren't any disputed facts. So in summary, where we think the case stands now is that you have two groups of votes that we believe are clearly subject to a legal ruling. The 215 net votes in Palm Beach County and the 51 or 52 net votes in Nassau County. We also have either 2 or 3, depending on how the court looks at the 388 votes in Dade, groups of ballots which, in our view, must now be subject to judicial review. Those are the 3,300 ballots in Palm Beach that we have contested, where a decision was made not to count them in the manual recount, but we have contested that decision. The 9,000 ballots in Miami-Dade that have never been counted, and the 388 ballots in Miami-Dade that have been counted. We agree with those counts, but it may be that the defendants disagree, and that will require the court to review them. Now let me touch on a couple of arguments that I know that the defendants are going to make because they've made them to the court before. And obviously I will respond in rebuttal, but I want to have the court have a context of what our view is when the court listens to what they have to say. First, there may be an argument, they've certainly made this argument before, that somehow you have to recount all of the ballots if you're going to have a contest on any of the ballots. That is something that I challenge them to cite the case that says that, because the statute doesn't say it, and the case authority in which circuit courts and the Florida Supreme Court have repeatedly had election contests in which they have reviewed less than all of the ballots at issue are to the contrary. Because What the section says is that you have to look and you have to test the allegations in the complaint. And the allegations in the complaint are the ballot contests that we've identified. Now, second thing that they've begun to say, and that they may argue today, is that somehow the Miami-Dade ballots have been contaminated in some way. Now, exactly how that has happened isn't particularly clear. Nobody has brought in any evidence. There was a suggestion to the court that they needed a witness to identify the ballots. Florida law makes clear that the ballots themselves are official records. You don't need a witness to testify to the ballots. I think that however creative their argument is in terms of contamination, that is clearly something that they bear the burden on, and that burden has not been met. Indeed, if you listened to the people from Palm Beach County and you listened even to the Republican observers from Miami-Dade, I think the court got the sense of citizen officials trying their best to deal with a difficult situation, making every effort to get it right, keeping close controls. The court is well aware from telephone conversations and from this hearing of Mr. Greenberg's intent to make sure that Miami-Dade got it right, and that when they moved the ballots, they moved them in a way that this court directed, so that there would not be a chain of custody type argument that tried to distract the court. So the court has the ballots have been segregated, that is the undisputed evidence, and those ballots are available for the court to review. Finally, they have argued from time to time that in this case, in this contest case, that other matters should be injected, matters from other counties with which they may or may not have a disagreement. You've heard the interveners argue that somehow the court should take into account in this contest whether or not the networks prematurely called the race for Vice President Gore to the detriment of Governor Bush. I think the court has no competent evidence before it from which the court could conclude that that had any effect on the election. But irrespective of that, and more important than that, whatever effect that had is not relevant to a contest action, which under the terms of the statute simply asks whether there have been legal votes rejected or whether there have been illegal votes received. And it is up to the plaintiff to identify the legal votes that the plaintiff claims have been rejected and the illegal votes that the plaintiff claims have been received. And we've done that. We've done that in each of the 5 issues that we've put in front of the court. Those we respectfully submit are the issues for the court to decide. Some of them issues of law, others the issue of the application of law to the individual ballots themselves. Thank you very much.
Thank you, Mr. Boeis. Richard?
It please the court. Like Mr. Boeis, I return to my opening statement and the threshold question that I believe defines the task that this court faces in this proceeding. And I believe that a good beginning point to analyze that task is the statement of the Florida Supreme Court in the 1981 case of McPherson versus Flynn at 397 Southern 2nd, 665, in which the court said, since there is no common law right to contest elections, any statutory grant must necessarily be construed to grant only such rights as are explicitly set out. In other words, among the three co-equal branches of our government, it is the legislature, to which our Constitution has entrusted the right and the responsibility of determining the circumstances under which an election can be contested, and there is none other than what it has stated. So, too, the Constitution has entrusted the legislature the right to determine when, if ever, there shall be a manual recount. And I pause here to note that there is no right by the federal or the state constitution to manual counts ever. Now, the Florida legislature has indeed told us in very explicit terms the circumstances under which there can be a manual recount and what body makes that decision. It did it in section 102.166, subsection 4C, a section which Mr. Boeis conveniently ignores. And here's what it says. The county canvassing board may authorize a manual recount, period. Now, the county canvassing boards are interesting bodies. They are unique within our system of government. The legislature has provided that they shall be composed of a representative of each of the branches of government. A judge, a supervisor of elections from the executive branch, and a member of the county commission, indeed the chairman of the county commission, a legislative branch. All of them, with the singular exception of Dade County, elected officials, and all of them at the closest level of government to the people. And it is that board, and that board alone, to which the Florida legislature has entrusted the decision as to manual recounts, and I defy Mr. Boeis to find for this court any other provision of Florida law that entrusts that decision to any other body. Now, in his effort to suggest to this court that the review of ballots is de novo, he rests upon a premise which I suggest his entire case needs for success, and it is this, that there is something different about a Section 168 contest than the provisions of Section 166, which lay out the circumstances for recount. Mr. Boeis suggests that once a contest has been demanded under Section 168, that we no longer concern ourselves with the authority of the county canvassing boards. They essentially disappear. And what they have done is no longer important. It is no longer a question of abuse of discretion. Just 2 weeks ago, the Florida Supreme Court in Palm Beach County Canvassing Board versus Harris told us this. The decision whether to conduct a manual recount is vested in the sound discretion of the board, and they refer to the county canvassing board. Once the county canvassing board has made that decision, there is only one other provision in Florida law for a person to challenge it, and that is a contest under 168. Now, if Mr. Boeis is correct, then what did the Supreme Court mean when it said the decision whether to conduct a manual recount is vested in the sound discretion of the board? What did it mean? Because according to Mr. Boeis, once that decision has been made, and the next thing by statute you can do is an election contest, the court can disregard what the board did. Well, that's not discretion, sound or otherwise. That's meaningless, because as soon as the board acts, the court can disregard it. I suggest to this court that that is not a proper construction of Florida law. What Florida law says, not only with regard to canvassing boards, but in fact, all fact-finding boards, is that when the legislature entrusts to a fact-finding board the authority to act, and that board acts within the scope of that authority, the standard for review is abuse of discretion. And that's what the statute says here, and that's what the Florida Supreme Court has told us when it said that the board has the right to act within its sound discretion. Now, once the court says that, we know it leads to one and only one conclusion. The standard of review is whether they abused that discretion. That's what discretion means. And we also know what the test is for whether or not discretion has been abused. It is the reasonable person test. The test is, can reasonable persons differ as to what that board did? And if they can, you cannot overturn it. If any reasonable person could have done what the board did, knowing what the board knew, it's not subject to being overturned. That's elementary law school fact. It's a simple principle, and we know it. Now, I suggest, Your Honor, and I will discuss it in greater detail with respect to each of the issues that Mr. Boeis has talked about, that there is no evidence in this case of any abuse of discretion by any of the county canvassing boards that are being challenged. But first, I want to talk about Mr. Boeis' cases. In my opening statement, I invited Mr. Boeis to tell this court what case law provided that the review of an election is de novo in the sense that once a county canvassing board has decided not to conduct a manual recount or has conducted a manual recount, that the court can disregard it. Mr. Boeis has provided the court with a series of cases, primarily early cases in the 1930s, 1920s. I don't suggest that that makes a difference. But I will tell the court this. If you read these cases, you will not find in any one of them any discussion of the discretion of a canvassing board and the right of a court to disregard it. It is not an issue in any of these cases. In State versus Peacock, there was no canvassing board involved. There was no discussion of de novo review. It is true that the court reviewed ballots, but this issue was not before it. In State versus Smith, there was no discussion of de novo review. There was no recount by a canvassing board. It was not an issue in the case. The issue in the case was the proof necessary to justify a recount. And with regard to Beck, by the way, Your Honor, I will not spend the time to analyze every case, but I will tell you that not one of the cases cited in the state of Florida by Mr. Boeis is contrary to the proposition that I have presented to this court and that flows necessarily from the decision 2 weeks ago from the Florida Supreme Court in which we were told that the board has the sound discretion to make that decision. And by the way,